Well, good morning, everybody. Welcome, welcome. I hope my sound is doing okay, bright and early. Just having a little issues over here, of course, because it's 5:45, and I'm back in the studio after a little trip to Las Vegas, where I got to meet Melanie Little, who is like one of the coolest people ever. Super fun. But if you know about going to dead shows, I'm like still in recovery, still in recovery phase. So I had a good old time and wasn't exactly at my best to try to sort out sound issues and all the tech and everything like that. I haven't been able to find a feed for the courtroom yet, so I'm not quite sure what's going on with that. I'm gonna, be continuing to sort of look here. But if anybody happens to have one up that they are going to be bringing it live as soon as they go into session, let me know, and I'll have that queued up and ready to go. Well, so April Fool's Day, I guess. Getting started, maybe not. We know that, of course, they're doing jury selection today, and jury selection is not going to be televised. We're not going to see that part of it. Not expecting that. But there are, as Judge Canoni herself acknowledged at the conclusion of the last hearing, still a lot of loose ends. And boy, oh boy, even more loose ends, because apparently I can't leave town without a whole deluge of things being filed. So my gosh, what a lot of things have come down since the last time we talked about this case. Let's just work through them. I mean, gosh, the very first thing, we got that decision on the motion to dismiss. Yeah, we sure did. Let me go ahead and pull that up here. See what we got. Here it is. Let me make that a little bigger. This isn't great quality on the scan here, but it's good enough that I can read it. Hopefully you guys can do the same. This was a little infuriating for all that, I really didn't have any expectation that she was going to grant this motion. I think my prediction, if I remember right, was pretty much that she's going to say, no, it's not the right remedy. She went even further than that. Here I am trying to give her credit. I'm trying to work with the perspective that she is gonna at least try to appear to be fair and even-handed and equally gravely concerned about wrongdoing on both sides of the aisle. But that isn't what we got, is it? Instead, this motion or this order pretty much read like, you're wasting my time. And it's just throughout. I mean, even at the very beginning, such a drastic sanction is justified only in response to the most egregious and truly harmful conduct in all but the worst cases. The appropriate remedy is at best a new trial, such as the one that is scheduled to begin soon, because the claimed violations here do not rise to a level that would justify the most draconian sanction of dismissal, and because the defendant's constitutional rights can be fully protected in the coming trial, her motion to dismiss is denied. So none of this, although troubling the Commonwealth's conduct, although shouldn't have happened, what the Commonwealth did, although clearly inappropriate by the Commonwealth, nevertheless doesn't warrant. Oh, no. No, we're not getting that in this ruling. We are just getting, this isn't a big deal. Nothing to see here. So first off, it looks like Judge Canoni's got a law clerk now. Somebody helping to maybe do a little bit of the research and writing for these opinions. Maybe. I don't know if she really does or not, but ahead and just kind of scroll us through this ruling here. So, just more of the same. It's presumptively it's very drastic, and the defense here argues that the Commonwealth committed egregious discovery violations by destroying and or withholding exculpatory evidence, and that a Massachusetts state trooper interfered with the jury during the first trial, warranting dismissal of the charges. As discussed below, the defendant has not demonstrated that she suffered any prejudice as a result of discovery violations that cannot be cured by her new trial, and has not substantiated her claims regarding interference with the jury, which is discussed in detail below, are baseless. I definitely have some thoughts about this. Right? So these are the ground rules. At least this is what we're being told. These are the ground rules in Judge Cannoni's court. It's no harm, no foul. That's how she is. That's how she's reffing. That's how she's reffing this trial. So basically, as long as you get away with it, as long as she doesn't actually get acquitted, then a do-over. A do-over is enough. That's all you need to do to make sure that she's having a fair shake here. That's really all you have to do, is just keep at it until you get your conviction. I'm always been troubled by the harmless error standard, really, for that reason. It's like, well, yeah, you can mess everything up, and the worst case scenario is you get a do-over, or you don't even get a do-over. Like, you don't even have to mess with it. It's like there's no consequences. When there's no consequences, there's no disincentives. So she is really communicating pretty clearly, I think, to the Commonwealth. I'm not here to scold you. I'm not here to call you out. I'm only here to call out the defense when they do something I don't like. The Commonwealth, no big deal when you guys mess up, because you'll just get a new bite at the apple. You can try again. Really, really alarming state of affairs. So first, talking about the discovery violations, the Brady rules, general due process argument that the prosecutor has the duty to turn over all exculpatory evidence. They have a duty to inquire to make sure that they have located all discoverable information. And then in Massachusetts, you have this added step that you certify. You certify to that as well. The prosecutor does. He files this discovery certification. Says he's complied with his obligations, and everything that's been responsive has been turned over. Everything is good to go. So doesn't seem like that matters really all that much in Judge Cannoni's courtroom either. So anyway, going through the surveillance footage, her description of the facts here. Now remember, we didn't have an evidentiary hearing, okay? We had affidavits. I should say we had an affidavit from the defense and supporting exhibits and so forth. All we had from the Commonwealth was that joint affidavit that all three of the lawyers signed, where they don't have personal knowledge about anything having to do with the collection, storage, etc. of the Sallyport video. They're just laundering what they're being told by other people. But even in that declaration, they're just mostly concerned about about protecting their own backsides. We asked, it wasn't our fault. It was Proctor that did all this stuff. The Proctor under the bus affidavit. So I think it's really significant that there was no evidentiary hearing here, because it's not required to have an evidentiary hearing if you assume the facts are as the defense presents them to be, and you make your decision based on the facts as they're presented by the defense. And so it's like, even if all of these things are true, we don't need to have a hearing to establish that they're true, because even if they're true, they don't get us to where they need to be. But that's not what we get. That's not really what we get from this order. When we see how she's describing out these facts, this is really not the version of events as the defense has presented it. And just as an example here, according to the Commonwealth, surveillance footage from these cameras is automatically overwritten on a regular basis. Footage on the night in question, however, was not lost because CPD Sergeant DGM Pietro, I still can't say that name yet, but I'll get there, DGM Pietro, followed his customary practice of downloading the recording to a hard drive in 6-hour segments. There was quite an issue raised in the defense pleadings about the overwriting. And when did that start? How did it start? Why was the Commonwealth able to locate all of this additional video from other incidents that they started bringing in to, validate their argument that, the cameras work the same, they're always jittery and jumpy and inverted and so forth. It always works like that. Kind of an issue, like why you even had that if it's all on a 30-day overwrite and always has been, except for these chunks that you came in, like years later and said you actually downloaded the whole thing. The whole part of Karen Reed's, the time frame when her SUV was there in the Sally Port. So I would say it's a little bit more of a complex issue, what the Commonwealth has been up to here with the discovery violations under the defense's theory, than Judge Cannoni has really accepted here for purposes of the argument, for purposes of deciding the motion to dismiss. And exactly how egregious is this, and exactly what kind of sanction does it warrant? She was charged with murder, et cetera, et cetera. There was a preservation order that was granted that sought to preserve all physical evidence, including anything present near the decedent at the time his body was discovered, anything found at the crime scene. Michael Proctor took possession of the requested CPD video of the Sally Port in February 2022, but did not turn it over to the prosecutors. Instead, for reasons unclear on the record, he kept the material in his case file. Yeah, for reasons unclear on the record. And why is it unclear on the record? Because you didn't have an evidentiary hearing where he would have to answer that question. And then we would know, and then we would have an understanding of the scope of the egregiousness of the behavior by the Commonwealth. Just putting that out there. We didn't have to not know. We didn't have to have an unclear record about why exactly did this trooper download all this video, acquire it, and then tuck it away in some paper file to never be found again. Is that even the final story that the Commonwealth landed on? Because we heard so many different stories. It's on a hard drive. It's on an iCloud. DJ and Petro's got it. Now apparently Proctor had it in a paper file. We don't even know what the explanations are for all of these different versions of events we got. Why did the story keep changing? The record doesn't need to be unclear about that either. Why all of these competing Explanations that kept changing were being given. Why were we ever told it was on an iCloud? Where did that come from? Would have been maybe nice to have an evidentiary hearing so that these kinds of details would have been fleshed out. So then the next order was for crime scene photos and videos taken in connection, including white plastic, metadata, and the metadata associated with these photographs and videos. Yeah. Yes, required to turn over metadata. Several months later, Proctor asked CPD whether it had in its possession any exterior Sallyport video showing the defendant's vehicle on the flatbed of the tow truck. Over a year later now, remember we're supposed to be on the 30-day overwrite? In response, CPD gave state police the video from the main driveway side exterior Sallyport camera. Weird how they still had that 15 months later when the system is on a 30-day overwrite. Weird how that was. Maybe it was on that file that DG and Pietro located. No, it wasn't there because Proctor already had that and he had stuck it in his paper file. So how would they have given it to state police? Proctor had it, not CPD. The story hasn't even been kept straight here. And it's like deliberately missing the point. Deliberately missing the point here. Well, they got it 15 months later, despite the 30-day overwrite. And Proctor took possession of the video, but again, for reasons he unexplained, he didn't turn it over to the prosecutors yet. Again, because we didn't have an evidentiary hearing because you didn't want to put him under oath about these issues. He didn't turn it over. Instead, he placed it in his case file. This footage shows the exterior of the Sallyport. It's grainy, it's blurry, and the condition of the taillight cannot be discerned. And then Proctor testified before the grand jury. Of course, we don't get to see the details of what exactly he testified to the grand jury about. But we know that he did. And we frankly know from the defense's pleadings as well that that's where he, like, for the first time acknowledged the existence of this video, the fact that he had seen this video. Because we learned from the defense, that's how they learned that it existed. 3 months later, Lally received Proctor's federal grand jury testimony. After reading his testimony, Lally asked the trooper if he was in possession of the video footage referenced therein. In response, Proctor gave Lally the Sallyport front wall camera footage provided to Proctor in February 2022. But not the main driveway side exterior Sallyport footage provided to Proctor in June 2023. Lally immediately turned over the front wall camera footage to the defense, along with the footage from the CPD main driveway showing the SUV on the flatbed. Look at this footnote. It is unclear to the court where the CP main driveway footage come from. Yeah. It is unclear, isn't it? And how incurious is this court about trying to find, where did all of these things come from? How did this footage suddenly start materializing late in the day in drips and drabs and pieces? How exactly did that happen? The CPD main driveway camera appears to show a different view than the main driveway side exterior camera. The recording from that camera remained in Trooper Proctor's file. According to Trooper Proctor, not under oath. According to what Trooper Proctor told Mr. Lally, this time being the, third or fourth version of where this footage was and what they did with it. So yeah, it's unclear to the court where it came. It's unclear to everybody because you didn't bother to find out exactly how much are these rats scrambling to try to cover up their tracks. How much have they been scrambling to try to cover up their tracks? You didn't want that under oath. That's why it's unclear. None of the footage contained a view of the back of her SUV. On April 10th, Lally filed a certificate of compliance, indicating that to the best of the Commonwealth's knowledge and after reasonable inquiry, it had disclosed and made available all items subject to discovery pursuant to Mass Criminal Rule of Criminal Procedure 14, whatever, or court order. When defense counsel reviewed the Sallyport front wall camera footage, they saw that 42 minutes of footage was missing. The defense raised the issue to the court at a hearing on April 12th, 2024, days before the trial was set to begin. Arguing that the missing footage was critical to the defense's theory. The Commonwealth explained that the footage was intermittent because the camera was motion activated. The Commonwealth explained that it was motion activated. Remember that? Yeah, we have those apparitions where people are moving around and just suddenly like fading in and out. And then we have, big sections where the car is just sitting there. Like the whole inverted video that they provided, from the just unrelated situation earlier in January to show, or earlier in November, I think, to show that this is just how the cameras work. They record inverted. There's no action in it. There's no action in that video. But the Commonwealth explained the footage was intermittent because the camera was motion activated. And boy, did that turn out to be true, guys? Did that turn out to be true also? Oops. Uh-oh. Hang on here. Trying to get our next page here. Okay. On November 8th, the defense emailed Special Proctor requesting, wait, is that where we got to? Sorry, hang on here. Oh no. I guess we still have another page here. Okay, my bad, guys. I just jumped the gun a little bit. So the trial began. Yes, footage was intermittent. The trial began. On April 17th, Lally received footage of the Sallyport interior back wall camera from the CPD, which had been looking for continuous camera footage of the Sallyport on the relevant date. Obviously not looking very hard because it's apparently in all these different locations. Nobody's been able to find it. And we're still not even clear if they're on the 30-day overwrite at this point or not. On April 23rd, 6 days later, so a week later, he provided the Sallyport interior back wall footage to the defense. The images contained in this footage were inverted. So yeah, now we have the situation where the prosecutor has filed a certificate of compliance saying he's turned everything over and he's made a reasonable inquiry into anything else that may be out there, and can give his assurance that there's nothing else out there. And yet now here we are, a couple weeks into trial. Trial started, I forget the exact, okay, April 16th. So a week into the trial. Here's more. Now, part of the things that I find so interesting about this decision, and just how Judge Cannoni kind of thinks anyway. I mentioned this back when it happened, when we got that order where she found the defense attorneys to have committed willful and egregious misconduct because they had said in that memorandum that ARCA was not paid by the defense, when, yes, ARCA was not paid by the defense for the subject matter of their testimony, for developing it, for anything having to do with the opinions, which is what the ARCA motion was about. But they had, in fact, paid some money to ARCA for travel and for their time testifying because they had subpoenaed ARCA to do that. That was willful and egregious misconduct, according to Judge Cannoni. And in that decision, she cited some case law, and one of the cases that she cited was quite a fascinating read for me because it involved a sanctions motion over prosecutor filing a certificate of compliance and then subsequently producing more stuff. And it's not a very favorable opinion. They don't look kindly on filing a certification, your word, giving your word as an attorney that you've done your due diligence when it comes to discovery, and it turns out you haven't. Yeah, that's misconduct, and that's sanctionable. So very, very strange that she finds that law and utilizes it in the context where it's not exactly appropriate, not exactly on point. And yet here, where it's squarely at issue, somehow that case law just doesn't come up. Interesting, isn't it? Very, very interesting. Buchanan testified on June 5th and 6th, 2024. During his direct examination, Lally showed the inverted Sally Port interior back wall footage in open court. Because the video was inverted, what appeared on the screen as the right side of the vehicle was in fact the left side, and vice versa. The direct testimony did not alert the jury that the video was inverted. No, and in fact, they pointed to the video to say, look where everyone's standing. See, we never went anywhere near that rear passenger taillight. It's right here close to you. You can see nobody's ever anywhere near it. That's in fact what they did. They didn't just fail to inform the jury that it was inverted. They misled the jury about what it was depicting. That's what they did, just to be clear. On cross-examination, however, defense counsel questioned Buchanan extensively about the inverted image. So then the CPD began a review of other video surveillance footage in an attempt to explain the inverted image and to respond to allegations that it had deliberately manipulated the recording. As part of this process, CPD Chief Rafferty reviewed surveillance footage from cameras in the hallways and the parking lot at the CPD in the early mornings of January 29th, 2022, prior to O'Keefe being discovered in the snow. Once again, this was supposed to have been overwritten a year and a half ago. So why is it even there? The Commonwealth told you it's on a 30-day overwrite, and here they are finding all this stuff that hasn't been overwritten after 30 days. And there's just a remarkable lack of curiosity about why that is. She just doesn't want to know. Is this becoming clear? She just doesn't want to know. She doesn't want the record to establish what's really going on. She doesn't want to know. Keep her willfully blind, because if she knows she might have to do something about it, and if she had to do something about it, that might not be so comfortable from a social situation, would it? The rear lot cruiser side camera had recorded ATF agent Brian Higgins, a witness called by the Commonwealth at trial, walking across the parking lot at 1:34 a.m. holding a phone near his face. So more footage, late produced. Could have just given it all to the defense. You really could have. Give them all the Sally Port footage since you have it anyway. But no. Nope. Drips and drabs. Isn't it convenient too? It's kind of convenient that this Higgins stuff, this is impeachment material, and impeachment material does fall squarely under Brady. Very clear. Impeachment material, they have a duty to turn it over. So isn't it a little bit of a coincidence too that she just happens to be looking to validate their footage, their inverted footage? She just happens to be looking at the rear lot cruiser side camera. That's not the same camera. Remember, the Sally Port interior back wall is the inverted one. So to prove that the inversion wasn't manipulated, she's looking at completely different video and happens to find impeachment material that gets turned over mid-trial after Higgins has testified. To be clear, to be real clear that that's what happened, because you're not necessarily going to get that from reading Judge Cannoni's opinion here. But that's what happened. Weird, she's not curious about that at all. Why were you, Chief Rafferty, looking at this unrelated camera? Because you had concerns about how a different camera was working. That doesn't really make a lot of sense, does it? Kind of speaks a lot to this certification of compliance and the value that it has, doesn't it? Because this was all supposed to be done a couple of years ago, year and a half ago. In September 2024, Special Prosecutor Brennan joined the prosecution team. On October 10th, he provided the rear lot cruiser footage along with other surveillance videos. The CPD interior hallway, the church side exterior sally port, the rear lot main side to the defense. So yeah, actually, we don't even know the CPD began a review of other surveillance footage. We don't know when that happened. We don't know when they started looking. We know the defense didn't have it when it was time to cross-examine Higgins. We knew that they didn't have it then. Nothing to see here. Nothing to see here. Guys, I am seeing that apparently this courtroom stream is going to start at 9:30. So I will go ahead and try to keep an eye open to see if that comes up. But they are probably doing some logistical kinds of things, or just having a late start. Who knows? It's always a little bit chaotic on jury day, especially if they're bringing in a big panel. So maybe that's why we have so many filings. We can occupy our time while we wait to see if anything happens in court that we're going to get to see. On November 8th, 2024, the defense emailed Special Prosecutor Brennan requesting all raw video footage from the CPD, included but not limited to all cameras capturing the interior and or exterior, including all parking areas, et cetera, this time period. Special Prosecutor Brennan responded he would request that CPD collect and produce all footage responsive to the request. Therefore, he asked all of them to go through their files. During this process, he came into possession of the main driveway side exterior sally port footage originally obtained by Proctor in June 2023 and not previously turned over to the defense. Yeah, and also the stuff with Higgins. Didn't you get the stuff with Higgins, the Brady stuff, and finally turn that over? On January 28th, 2025, the Commonwealth turned over the main driveway side exterior sally port video to the defense. As noted above, the footage shows the exterior of the sally port when the defendant's vehicle was brought into the CPD garage, but the quality of the recording is, as noted, poor. Yeah. Well, the Commonwealth isn't the only one who can enhance videos, make it a little cleaner and easier to see. Remember what they did with that dark video? Remember? They brightened it up so you can see. Yeah, it's not magic. It's the use of programming. And the defense can do that too. They can also have access to that. So the fact that it is poor quality doesn't matter. It doesn't matter. They may be able to make it better quality. It may not be poor quality for their purposes of what they're trying to establish. So again, just a constant theme here, the minimization. We're not going to question, any of these details that the Commonwealth has provided, even when they don't make sense and even when our record is unclear. We have to explicitly come out and say, we don't actually know because we didn't have an evidentiary hearing. Defendant's arguments. The defendant argues that the Commonwealth provided an untimely disclosure, withheld, or destroyed certain CPD surveillance video in violation of Rule 14, Brady, and the court's preservation orders. Further contends that the timing and quality of the video footage that has been produced demonstrates that the Commonwealth sought to intentionally deprive the defendant of exculpatory evidence. That's right. That is the argument, which is why they needed the original metadata. Just for example, according to the defendant, the Commonwealth's conduct was so egregious that dismissal is warranted. This argument is flawed in several respects. First, no order required them to produce it. So, we're going to very narrowly construe these orders when it comes to the Commonwealth's, duty to explicitly, on their own accord, obtain this video surveillance footage and turn it over. The fact that they were using it at trial, apparently not enough to trigger that, not enough to trigger them doing that. No, until it came out in Proctor's grand jury testimony that it even existed, it was being kept a secret. So, not under any duty because, physical evidence doesn't include surveillance footage. And, she cites all these cases that are about other things and may have some dicta in it about stuff like this. Based upon witness interviews, physical evidence, and video surveillance footage, police determined that 2 suspects had entered the store and opened fire. She's saying that reflects Massachusetts case law, that there is a clear distinction between physical evidence and video surveillance footage. No, it does not, because that was not the issue that was to be decided in Commonwealth versus Lattimore. Commonwealth versus Lattimore is just describing things that were at issue in that case. Commonwealth v. Lattimore was not deciding, is there a distinction between physical evidence and digital evidence for purposes of interpreting an order? No, it's just a case where they describe different things that were in evidence. But that's how Judge Bev does her legal reasoning. That's what we've started to see with more and more of this case law showing up in her decisions. This is not a rigorous legal analysis where she has sought diligently to find law on the specific proposition that is being placed before her and then analyzing the issue accordingly. This is just looking for language in cases that she can use to support her outcome. The outcome that she wants to reach is physical evidence isn't the same as digital. They didn't have to preserve it under the preservation orders. Clerk, go find me some case law that will say that. And so the poor clerk, desperately trying to find something that's not there because court hasn't squarely decided it before, which is really not particularly uncommon, goes in and finds these cases where they just detail different pieces of evidence. And that's their support. Now, here's the thing. Like a real legal analysis can get you to this same conclusion because it's just a question of interpreting language. And the easiest way to interpret language is to use a dictionary. And you'll see that a lot in opinions where they're interpreting statutes, they're interpreting contracts, they're interpreting language and trying to understand what was meant and what was contemplated here. You start by looking at the dictionary. And so I'm pretty sure, you could look up a definition of physical evidence that would not include, digitally preserved information, maybe. Or could you not? And that was the problem. Could you not find a definition of physical evidence that excluded the video surveillance? So you had to go with this instead. It's just such poor quality legal work that it offends me. It offends me because this is a judge. Okay, this is a judge. The bar should be much, much higher than this. But nevertheless, that is what we get. That is what we get from this court. Furthermore, where the physical evidence described was further defined as including anything present on or near the decedent at the time his body was discovered and anything found at the alleged crime scene, the order cannot reasonably be interpreted as including surveillance footage from the police statement, from the police station. That's really good enough. You don't have to do this, this other. You can just say it's limiting the request for preservation. When you have limiting language like that, typically what you're doing is you are just calling for things that are similar in category, similar categories of items. So the other order didn't either. The other order didn't either. It just required production of crime scene photographs and or videos taken in connection with the case. The CPD was not part of the crime scene, and therefore the order did not compel production of the CPD videos. It wasn't part of the crime scene. Heard a lot of versions of that one too, haven't we? Yeah, we in fact heard that it was the crime scene. We heard about secondary crime scenes. We heard about a lot. We saw crime scene footage in the Canton PD Sallyport crime scene tape. We saw that tape, the tape they couldn't bother to put up at the scene on the morning of January 29th because of the snow. The snow that prevented them from being able to do normal police work. Snow is apparently such a novelty in Massachusetts that couldn't even get that going. I see, looks like I did find a stream here on CBS Boston, but they're not going yet. So we'll see if anything goes live anytime soon. But this is not the end of the inquiry. The absence of a court order requiring production of the CPD surveillance does not foreclose the possibility that the production may still have been required under Brady and or Rule 14. The defense contends that the prosecution should have inquired of the CPD if any footage existed and then produced all the footage because she maintains that it contains exculpatory evidence. Specifically, the defendant argues that the footage shows Proctor approaching the taillight in a manner that she says supports an argument that he tampered with the evidence, assuming without deciding that the footage is actually useful to the defense. You mean like they in fact used it at trial to point out the shenanigans? Yeah. Defensive dismissal is not warranted because defense counsel actually used this evidence to advance the tampering theory at the first trial and can do so again at the retrial. So the fact that the Commonwealth held on to it, the fact that we've got all of these different explanations for where it came from, its provenance, the fact that the defendant still hasn't been provided access to the metadata for this video so that they can analyze whether it's been tampered with or whether it's just, just inconveniently kept in that manner because of the way the camera works. Don't matter. We don't even need to address whether that was a bad thing that the Commonwealth did because she can just use it now. So no issue with that certificate of compliance, notwithstanding she's familiar with that law. She just looked it up when it was time to go and criticize the defense attorneys and try to find them in contempt. Looked it up then, but now it doesn't really matter. In addition, while the current Rule 14 makes clear that the Commonwealth is required to provide to the defense's investigative materials, video and audio recordings in the possession, custody, and control of any member of the prosecuting team, the Rule 14 in effect at the relevant time had no such requirement, nor did Rule 14 in effect at the time clearly state the prosecutor's duty to inquire whether such evidence exists. They have this, footnote to a new note now. Because the defendant made no specific request for the Commonwealth to produce such evidence until after the first trial, it is not clear on the record how or when the Commonwealth should have known that the surveillance video was germane to the defense. Well, once again, if there is responsibility for the unclear record to be laid at anybody's feet, it's at yours, Judge, because the record didn't have to be unclear. There's a way to have these questions answered. You have an evidentiary hearing and you put the people under oath. And then you find that out. Why exactly did you only start looking at this stuff a year and a half later when you're not even supposed to have it, according to your explanation? And when you're looking at something completely unrelated based on your stated concerns about something different, it all stinks. It all stinks. And Judge Bev wants to do that. She don't want to find out what it is. It's not clear on the record how or when the Commonwealth should have known that surveillance video was germane to the defense until the Commonwealth knew, for example, that the defense theory included that law enforcement tampered with the taillight while it was at the Sally Port, or that Higgins was a proposed third-party culprit. It had no reason to inquire as to whether any relevant video footage existed. Well, their duty is to turn over exculpatory evidence. And so when they know, for example, that their witness has testified contrary to what the situation is, to what is shown on this video, yeah, you certainly have a duty to turn it over then, because now it's impeachment. Now you know that. Karen Read was framed was not a novel theory. It was not a novel theory. And everybody knew that this was the type of thing she was going to be investigating. All right, it looks like court is live now. I'm going to go ahead and switch us over here. This is CBS out of Boston. Doesn't sound like anything is happening yet, but looks like they are getting ready to go. Maybe I will keep that on in the background and go ahead and bring us back. Close all these things up. See where I am here. Oh, I'm over there. So let me just go ahead and go back here. So yeah, until they knew, they had no reason to inquire. No, this isn't rocket science. And certainly once you knew that you were going to present it, once you knew you were going to present it at trial, yeah, you have to turn it over. Not a week later. You have to turn it over. And then, yeah, they're probably going to have some reasonable questions for you about why so late and what else is there. That seems pretty normal. All right, let's go back. She's got us on and then off. Looks like I'm a little behind over here. They're just chit-chatting.
God save the Commonwealth of Massachusetts. This court is now open. You may be seated. Jurors remain standing. Everyone else may be seated.
I'm sorry, jurors. Could either of you all raise your right hands, please? Do each of you solemnly swear to make true answers to such questions as should be put
We're in the
forth
big
by the court?
courtroom jail,
Thank you. You can have a seat now, I promise. May I call the case, Your Honor?
Yes.
Your Honor, this is 22-117, the Commonwealth versus Karen Reed.
Counsel.
You want counsel? Or you want me to say?
Counsel.
Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson on behalf of Karen Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Victoria George on behalf of Ms. Reed.
Good morning, Ms. George. Good morning, Ms. Reed.
Karen Reed, can you please stand? Karen Reed, you are now set at the bar to be tried, and these good men and women who I shall call to pass between the Commonwealth and you upon your trial. If you'd object to anything, you must do so before they are sworn. You have a right to challenge any 16 jurors without giving reason. Thank you.
Okay. Good morning, jurors. My name is Beverly Cannoni. I'm a judge of this court, and I want to welcome you here today and give you some idea on what you will be asked to do. So, jury service, as you know, is one of the most important duties we have as citizens. We appreciate that you're here, ready, willing, and able to serve if you're called upon to do so, and our system of justice simply does not work without you, so we thank you. This is the case of Commonwealth versus Karen Reed. The Commonwealth alleges that at approximately 6 a.m. on the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was subsequently pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty. So Ms. Reed is charged with second-degree murder. She is also charged with manslaughter while operating under the influence and with leaving the scene after causing personal injury or death. I will describe these indictments in detail at the end of the case when I teach you the law, but briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that the murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in greater detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while the public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all.
No,
The law
we
works
had
in a
trial.
different way,
What on
and the
earth are you
difference is
telling
crucial to our
the
system
panel
of justice. The
about
jurors selected
protesters?
for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies.
That is wild.
Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So, while public comment will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask you questions, all as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the questionnaire and to my questions. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you are not selected for jury service on this case, you should not take it personally. Don't think that somehow you're not a fair person, because it's not a reflection on you at all. You will be directed back to the jury room and perhaps be picked for another case. In a few minutes, I'll pose a number of questions to you as a group. You have just taken an oath that requires you to truthfully answer these questions and all questions posed to you. If your answer to any question is yes, I will ask that you raise your hand and hold up your juror card in the air with the numbers facing out so that the court officer can read the number from the card. You don't have to get your cards out yet. I'll tell you when it's time to get your cards out. Now, the fact that you answer yes to one of my questions does not mean that you're automatically disqualified from jury service. It simply means that there are matters that counsel and I must discuss with you. If you find a question posed to the group overly intrusive, you may elect to answer the question at sidebar. I may have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding your ability to serve as a fair and impartial juror in this case. And the lawyers are permitted to ask you questions for the same reason. This is not a test. There is no right or wrong answer to any question. We're simply looking for your honest and best answers to the questions. Now I'm going to have the lawyers introduce themselves. We'll start with the Commonwealth, and when the defense introduces themselves, please introduce your client. Mr. Brennan,
Your Honor.
please.
Thank you. Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. Along with me are two other attorneys I'd like to introduce you to. All the way to my right is attorney Laura McLaughlin.
Good morning.
And next to me is attorney Adam Lowry.
Thank you.
Well, he's just here so he
Defense
doesn't get
counsel, please.
fined.
Good morning, ladies and gentlemen. My name is Alan Jackson. I have the privilege of representing Ms. Karen Reed, who is to my right.
Good morning, members of the jury. My name is Elizabeth Little, and I also have the privilege of representing Ms. Reed.
Good morning, ladies and gentlemen of the jury. My name is Robert Alessi, and I also have the privilege of representing Ms. Reed.
Good morning, ladies and gentlemen. My name is David Yannetti. I'm an attorney. I have an office in Boston. I also have an office in Dedham. It's my privilege to represent Karen Reed.
Office in
Good morning,
Dedham.
members of the jury. My name is Victoria George, and I have the pleasure of representing Ms. Reed.
Good morning, I'm Karen Reed. Thank you for being here.
All right, thank you very much.
Making sure everybody knows he's
Folks,
got
I'm
local,
going to read a very lengthy witness list
local-ish
to you.
connections.
It's important that you listen to the names because at some point I'm going to ask you whether you know any of these folks. So when you hear it, please listen to it in those terms. Now, it does not mean that all 150 witnesses are going to be called at trial, but you'll hear their names if they're not called. You may hear their names during trial. So it's important that we know if you know these folks. The list is alphabetical, but it's alphabetical by first name. So Aidan Kearney from Jefferson, Mass. Dr. Aziz Wolf from South Miami, Florida. Alfredo Lopelato from Canton. Allison McCabe, also Canton. Andre Porto from the Massachusetts State Police Crime Lab. Andrew Klain from Bridgewater. Andrew Rentschler, PhD from Pittsburgh. Angela Malvone from Canton. Annie Chung from Canton. Anthony Flamati from the Canton Fire Department. Ashley Bell from Canton. Ashley Valliere from the Massachusetts State Police Crime Lab. Brian Albert from Norwood. Brian Albert Jr. from Boston. Brian Higgins from Sandwich. Brian Loughran from Canton. Brian Wanless, retired Canton Police Department. Bridget Meehan, keeper of the records in Canton. Caitlin Albert from Easton. Charles Ray, a lieutenant with the Canton Police Department. Chief of Police of Canton, Helena Rafferty. Chris Van E., PhD from Novi, Michigan. Christina Hanley from the Massachusetts State Police. Christopher Albert, Canton. Christopher Curran, Canton. Colleen Crawford from the Norfolk County District Attorney's Office in Canton. Colin Albert from
Still on the
Canton.
list.
Courtney Proctor from Canton. Kurt Roberts from Canton. Daniel Whitley from the Canton Fire Department. Daniel Wolf, PhD from Penns Park, Pennsylvania. Derek Ellington from Wake Forest, North Carolina. Dr. Marie Russell from Los Angeles. Dr. Elizabeth Lopesada from Providence. Elizabeth Proctor from Canton. Eric Hanlon, Canton. Erin Beatty, Canton. Erin O'Keefe, West Bridgewater. Francis Walsh from the Canton Fire Department. Garen Wing from Green Cove Springs, Florida. Gary Fowler from Brockton. Gregory Woodbury from the Canton Fire Department. Gretchen Voss, Boston, Mass. Hannah Knowles from the Massachusetts State Police Crime Lab. Heather Maxon from Walpole. Arabito Hernandez from the Boston Police Department. Holly Price from Mountain View, California. Ian Whiffen from Vienna, Virginia. Dr. Irene Scortibello from the Office of the Chief Medical Examiner in Massachusetts. James Crosby, Master's PhD, from Jacksonville, Florida. Jason Becker from the Canton Fire Department. Jean DeMulis from Canton. Jennifer McCabe, also Canton. Jessica Hyde from Bridgeport, New York. John O'Keefe Sr. from Braintree. Judson Welcher, PhD, from a company called Aperture, LLC. Julie Albert from Canton. Julie Nagel from Canton. Dr. Justin Rice from South Weymouth. There's a juvenile whose initials are KF from Canton, and there's another juvenile whose initials are PF, also from Canton. Caitlin Boudreau from Raynham. Karina Kolakithis from Canton. Katie Camerano, also Canton. Katie McLaughlin from the Canton Fire Department. Keeper of the records for Ring from Hawthorne, California. Kerry Curran from Canton. Kerry Roberts, Canton. Kevin Albert, Canton. Kevin O'Hara from the Massachusetts State Police. Lance Mello from the Massachusetts State Police Crime Lab. Laura Sullivan from Pembroke. Laurie Cahill from Worcester. Leslie Pearlstein from Canton. Lieutenant Michael Lank from the Canton Police Department. Louis Jetris from Canton. Lieutenant Brian Tully from the Mass State Police. Lieutenant John Fanning from the Mass State Police. Lieutenant Paul Gallagher from the Canton Police. Maggie Gaffney from Bonita Springs, Florida. Mark Lopalato, from Canton, Margaret O'Keefe from Canton, Marietta Sullivan from Pembroke, Mary Souza, Dighton, Matthew Amory from Canton, Matthew DeSogra from Charlotte, North Carolina, Matthew Erickson from Grosse Pointe Farms, Michigan, Matthew Kelly, Canton Fire Department, Matthew Kelsch, the Federal Bureau of Investigations, Matthew McCabe from Canton,
Good,
Maureen
FBI.
Harnett from the Mass State Police Crime Lab, Megan Mariani from New York, New York, Michael Camerano from Canton, Michael Easter from Los Angeles, California, Michael Trotta, Canton Public Works Department, Michael Wagner from Foxborough, Mike Maroli from Bridgewater, Mike Rushworth from Thompson Station, Tennessee, Natalie Week Berschneider from San Marino, California, Nathan Reed from Raynham, Nicholas Bradford from Lorton, Virginia, Nicholas Curran from West Roxbury, Nicholas Kolakithis from Canton, Nicole Albert from Norwood,
Thank you for
Norfolk
helping
County
us
District
with the,
Attorney
Phoebe.
Michael Morrissey, Officer Kelly Deaver from the Boston Police Department, Officer Nicholas Barrows from the Dighton Police Department, Patrick Haggerty from Somerset, Paul Makowski from Melrose, Paul O'Keefe from Canton, Rebecca Bison from Canton, Rebecca Treyers from Norfolk, Mass, Dr. Renee Stonebridge from the Office of the Chief Medical Examiner's Office in Boston, Richard Green from St. Beach, Florida, Richard Donatino from Canton, Robert Gilman from Hull, Ryan Nagel from Canton, Sarah Levinson from Canton, Sergeant Brian Gallerini from the Needham Police Department, Sergeant Sean Good from the Canton Police Department, Sergeant Paul Giampietro from the Canton Police Department, Sergeant Yuri Buchanan from Massachusetts State
Judge,
Police,
could you make
Shannon
it a little
Burgess
more boring?
from South Lake, Texas,
I don't
Cheryl
think you
Waugh
zoned
from
out
Canton,
enough.
Sophie Herzan from the Mass State Police Crime Lab, Stephanie Devlin from the Mass State Police Crime Lab, Stephen Mullaney from the Canton Police Department, Steve Nelson from the Norfolk DA's office, Steve Bernstein, who is a keeper of the records in Stoughton, Stephen Ridge from the Boston Police Department, Stephen Seraph from the Canton Police Department, Stephen Scanlon from West Roxbury, Terry Kuhn from Davis, California, Tess Chart from Lorton, Virginia, Thomas Beatty, Canton, Thomas Kelleher, Canton, Thomas Martin, Weymouth, Timothy Nuttall from the Canton Fire Department, Tristan Morris from Easton, Trooper Connor Key for the Mass State Police, also from the Mass State Police, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Kostowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Garino, Trooper Zachary Clark, Wendell Robery from Canton, William Reed from North Dighton. That's the list of witnesses, folks. So in a while, I'm going to ask you all if you know any of those folks.
Oh, yeah, they'll remember that
So-
real well, Judge. Good Lord.
As you can imagine, this case is expected to take a while. The lawyers tell me that once we get a jury, which may also take a while, once we get a jury, that it's estimated that the evidence in this case should take 6 to 8 weeks. We do our best to let you know in advance what we anticipate the length of trial will be. When we start the trial, we will go full days so that we can expedite the trial. The dates that I'm giving you, the 6 to 8 weeks, is the far end of what we expect this to be, just for planning purposes. So the days will begin at 9 o'clock. We'll take a recess at about 11 for 15 or 20 minutes. We'll go until 1. Lunch will be brought into you. We'll start up sometime around 2 and go till 4 o'clock or 4:30 every day. And there'll be days off here and there throughout the schedule, and perhaps half days throughout the schedule. So that's the
So
schedule
you're going
that
to
we
go full days,
intend
except
to
when you
keep.
don't go full
Now,
days.
it might help you if I give you a preview right now about some basic law that applies to criminal cases like this. It's my job to teach the jury the law, and I don't do that completely until the end of the trial. So for now, I'll give you a very brief summary of some of the legal principles that govern the trial. First, and most basically, The defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. An indictment is merely a formal manner of accusing a person of a crime in order to bring her to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the Commonwealth, "You accuse me, now you prove it, and prove it beyond a reasonable doubt. I do not have to say a word." A defendant's decision whether or not to testify has nothing to do with the question of whether she is guilty or not guilty. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before the jury in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. A juror's job is to find the facts. In determining the facts, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and circumstantial evidence. I'll define those terms in greater detail later, but direct evidence essentially is evidence of what a witness claims to have seen or heard or touched or somehow perceived with his or her own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Jurors are entitled to consider both kinds of evidence. There is no difference at all in the probative value between direct and circumstantial evidence. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt.
This is so boring to
Now,
the
I've used
jury.
the word
They're not
inference.
retaining
An
any of
inference is a
this.
logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one which is not too remote in the ordinary course of events. You may not guess. You may not speculate or engage in surmise. When the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice.
Yeah, they do, Judge.
Regardless
Yes,
of their
they do.
race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. We judges have the same problem, obviously, as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the
None of
evidence
this has
and the
anything
law
to do with
instead
implicit
of
bias
on
or overcoming
unsupported
implicit bias.
assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you individually and as a group do your best to resolve this case based upon the evidence and law without sympathy, bias, or prejudice to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you've heard all the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all the jurors will have to apply the law as I describe it. So for
you
jury
listened to that
selection, it's
last 10
important to
minutes
know if
real
any of you might
closely,
have
right?
doubts whether you can accept and follow these legal rules. So I'm going to ask you questions in a few minutes. So if your answer is yes to any of my questions, please raise your hand. Before we begin, though, I understand that sometimes jurors do not fill out the juror questionnaires completely, that sometimes we are in a rush to send them in, or sometimes we don't think that our situation applies to the question that is asked. If the lawyers and I notice that the questionnaire appears to be incomplete, we may ask you to answer the question for us. Also, if you know now that you failed to include information on the questionnaire, for example, a work history, prior involvement with the court, whether as a party in a case, a witness, or a juror, please let us know. So while you're taking out your cards, I will see counsel and Chief Rosen, juror number 79 too, and counsel at sidebar, please.
Okay. Well, that was sure boring, wasn't it? I mean, there is definitely such a thing as over-instructing a jury. Definitely such a thing as over-instructing a jury. You give them so much information that none of it lands. And it doesn't help when you include all of this stuff that isn't useful. Like reasonable doubt is something you understand, as a matter of common sense, stuff like that. Like, no, Just give them the definition, give them what they need. If you're going to do that now, it's a very odd selection of laws to instruct the jury on, just for purposes of like alerting them to what their responsibilities are going to be so that they can be questioned about whether they're qualified to be able to fulfill those. I don't know why you give a circumstantial and direct evidence instruction at that point. Like, is there really going to be a juror who's like, no, I can't rely on inference. I can't do it. I can't be logical. Like, really? It's just a little bit bizarre. Like, if the point is making sure that the jurors can carry this out, what you're really looking at, of course, bias. Are you going to be able to treat both sides fairly in the way that they're supposed to be treated? Are you going to be able to hold them to their respective burdens, of which, of course, the defense has none? And the prosecution has the full burden of proof. Are you going to be able to, pass judgment on somebody? There's always, concern about religious objections. People, for a variety of personal, moral reasons, sometimes are like, no, it's not my job. That is for a higher power than me to do. So I'm not comfortable doing that. Those are really the things that you're there to be concerned about, not these detailed instructions about
Patient. So now I have questions that I'm going to ask you, and the court officers will read your number. So if you have that card, and hold it high, please. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names I've read? Please raise your hand.
Yeah, because they remember all those witnesses now.
96, 32, 32, 59, 59, 3, number 83.
Juror number 46, 46.
Number 90.
All right, thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or with the Norfolk County District Attorney's Office? I see no affirmative responses. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses. Has anyone seen, heard, or talked about this case? Please raise your hand.
Juror number 47, 47. Juror number 108, 108. Juror number 54, 54. Juror number 4. Juror number 7. Juror number 95, 95. Juror number 12, 12. Juror number 35, 35. Juror number 2. Juror number 107, 107. Juror number 41, 41. Juror number 46, 46. Juror number 24, 24. Juror number 97, 97. Juror number 23, 23. Juror number 99, 99. Juror number 25.
Yeah, keep going. We know you're not done yet.
Juror number 90. Juror number 92, 92. Juror number 91, 91. Juror 106. Juror number 101. Juror number 68. Juror number 65. Juror number 105. Juror number 60. Juror number 115, 115. Juror number 76. Juror number 66. Juror number 85.
Juror number 5757, juror number 6, juror number 96.
So many people,
96,
they have to
juror
take
109,
turns reading off the numbers.
13, 13, juror 73, 73. Juror 31, 31, juror 32, 32. Juror 111, 111, juror 88, juror 53, 53, juror 110, juror 59, 59, juror 40, 40, juror 94, 94, juror 3, juror 86, 86, and juror 62, 62, juror 84, 84, juror 112, 112, juror 64, 64, juror 82, 82, juror 19, 19, juror 77.
She's putting on that mask like she's really
Juror
super
17,
pleased with how this is going.
Juror number 75, 75, juror number 38, juror number 43, juror number 29, juror number 87, juror number 28, juror number 56, juror number 113.
They all know this case, like every single person in there.
Juror number 83, juror number 72, juror number 14, juror number 42, juror number 78, juror number 18, juror number 67, juror number 37, juror number 69, juror number 63, and juror number 22.
Juror number 30, 30, juror number 45, 45.
Still more.
Okay, thank you. Have any of you folks expressed or formed any opinion with respect to this case? If so, please raise your hand.
Juror number 108, 108. Juror number 7. Juror number 95, 95. Juror number 107, 107. Juror number 2. Juror number 35, 35. Juror number 80. Juror number 97, 97.
Juror number 90, 90. Juror number 91. Juror 106. Juror 101. Juror 105. Juror 60. Juror 115, 115. Juror number 66. Juror number 85.
Juror 109, juror 73, 73, juror 86, juror number 3, juror 94, juror 40, juror 59, juror 53, juror 84, juror 112, 112, juror 64, juror 82, juror 77, juror 17, 17. Juror number 75, juror number 43, juror number 29, juror number 28, juror number 113, juror number 36, juror number 18, juror number 37, and juror number 22.
All right, thank you.
A lot of
Are any
numbers.
of you folks aware of any bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? If you believe that you might have a bias, please raise your hand.
Juror number 25. Juror number 8. Juror 90. Juror 91. Juror 101. Juror 105. Juror 65. Juror number 60. Juror number 115, 115. Juror number 66. Juror number 85.
Juror number 17, juror number 38, juror number 36, juror number 37, juror number 3.
All right, thank you. Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict? If so, please raise your hand.
Juror number 95. Juror number 8.
Juror 101, 101. Juror number 65. Juror 105.
Juror number 13.
There will be a lot of hardship excuses requested anyway. No doubt about that. Interesting how much the pool shrank from knowing about the case, which was everybody,
Okay.
having an opinion.
Would any of you folks have any difficulty following the
30-some.
concepts that I've described? First, that the
Having
burden of
prejudice.
proof rests entirely with the Commonwealth.
Somewhere in the ballpark
Second,
of a
that
dozen.
burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant has absolutely no burden. She's presumed to be innocent unless and until the jury determines that the Commonwealth has proved its case beyond a reasonable doubt. Is there anyone who would have difficulty following those very important constitutional concepts?
Juror number 58. Juror number 8.
Okay. Now, I can tell you folks that after every jury trial, I talk to jurors, and they often tell me not only that their jury experience was an interesting one, but a rewarding one. I do understand, though, that for a few of you, however, service in this jury may be a substantial hardship, and let me explain what I mean by that. It's something more than mere inconvenience, because every civic duty we have causes us to be inconvenienced. It's far more extraordinary. It's something that would justify your being excused and a fellow juror having to serve in your place. I do understand, though, that it may be a substantial hardship. So if anyone has a substantial hardship, and what I typically mean by this is you have airline tickets or surgery scheduled during the course of this trial. But bearing in mind that this case may take 6 to 8 weeks to try according to the schedule that I've described, and keep in mind that I'll only excuse those who have a substantial hardship. If you think you are in that group, please raise your hand.
Juror number 97.
There will be a lot. People that don't get paid for jury duty will have a substantial hardship serving in a trial of this length. That is why these juries consist disproportionately of retirees.
Juror number 90. Juror number 91. 106. 101. 34. 105. 70. 80. 60.
Juror 6. Juror 109. 13. 31.
Yeah, really,
32.
really. See, you can buy your way out of the jury. Are you getting this yet? Are you getting this yet?
110.
If you can afford to have airline tickets
112.
or a surgery scheduled during the time frame of this trial, because you have good access to medical care and vacations, then you can get off the jury. If you'll just not be able to pay your rent because you're self-employed and your business will go under.
All right.
Yeah, she's not going to guarantee you that one, because that's almost
to give you a
everybody.
chance to fill out the supplemental questionnaires that we have. I ask that you not talk to anyone around you or share with any other prospective juror or anyone any questions or comments or concerns that you may have about jury duty, either generally or in this particular case. If you should have any questions or concerns, you can raise that when you come back to talk to me. So we appreciate your patience. We understand that this will take a while, but I will recess now for you to do that. All right. Thank you.
All rise for the court.
Recessing now. Okay. Well, I'm kind of surprised we've gotten to see as much as we have here. You know, when we're under these strict lockdown rules about like we can't even physically describe the jurors, I'm surprised that, you know, we get to hear the answers associated with the numbers and so forth. Now, having said that, yeah, jury selection is part of the public trial. It's one of the things that it's one of the stages where the public has a right to attend. It's been established in the case law. So you don't get to close it. You don't get to boot us out. But of course, with the cameras, it's always a little bit more flexible because they say there's no constitutional right to have cameras in the courtroom. Access doesn't really mean that. It doesn't really mean that. Once again, it means access for, you know, the people who can afford to be there, to take their time off of work, to go to Canton and, you know, get in the line, sit in the courtroom, spend their time there. That's what they mean by access. Well, very general panel questions there, ones that they're presumably going to have to follow up at the sidebar. But boy, an awful lot of people know about this case, don't they? An awful lot of people know about the case, and an awful lot of people already have opinions about it. At least a third. I mean, it's got to be about a third. I don't know exactly how many jurors they have in there in this panel, but it sounds like it's in the ballpark of like 120, maybe 115. I think was the highest number that I heard, 115. So that's, you know, that's a lot of people. So they're going to have to follow up on that. And the reason why is because they're going to have to explore the possibility of a venue change. They need to see, what are your opinions that you formed? Maybe you don't, because maybe it's good for you. You know, maybe the opinions that have been formed are largely critical of the Commonwealth, largely favorable to Karen Read. That's definitely possible if they've followed the trial closely. But the issue is always, if they haven't followed the trial closely, they've just followed mainstream media reports about it. Maybe they watched a documentary, heard a podcast, something like that. You know, might have more of a narrative viewpoint on the case as a result of that exposure. And the reality is, most people are not, you know, true crime junkies. Most people are not sitting at home watching this live stream, you know, trying to get a feel for jury selection. Most people that hear about a case are hearing about it because they read about it on the news or something like that. So is that going to give them a good impression of Karen Read? I don't know. They could have heard about Trooper Proctor. Sure, that, you know, was big news. We know there's all kinds of stories about, you know, the audit that's being done locally of the police department. People are aware of that. So don't really know what the climate is locally. So if it's generally favorable to Karen Read, no, you're not going to move venue. Why would you move venue to a less potentially friendly location? You keep the one, right here where you're at, and you take advantage of that jury. Now, one of the questions then that comes up, well, then could the Commonwealth move to change the venue? Commonwealth generally can't do that, and that's because there is a vicinage, what's called a vicinage clause. It's in the U.S. Constitution, and it's in many state constitutions as well. And what that is a right that the defendant has. Part of their trial rights is to be tried by a jury in the county where the crime took place. So that's her right, and that's why she can move to change venue. She can waive that and say, I can't get a fair trial in this one. But the Commonwealth doesn't have that right. The Commonwealth doesn't have that right. So she gets to choose, basically, do I want to exercise my right to be tried in this county where the events happened, or do I think it's unfair and I can move it out? So they're definitely going to have to follow up on that with the questions. There's really no doubt about that. And, you know, again, I've talked about this before a few times, but I'm always concerned about what you actually get out of this type of questioning. I can't imagine that Judge Cannoni is going to be real lenient when it comes to what the defense gets to ask and how and so forth. She's just so much of a control freak. She's kind of got her own view of how she wants things to be done and how the questions should be asked. And so it's just kind of how she operates, is to try to keep the defense within the boundaries she thinks they should be running their case with. And, it's a fine line with being a judge. That is kind of what your job is, but you need to not get out of your own lane. Their job is to defend, to make strategy decisions. You getting micromanaging with stuff that's really not about the overall fairness of the trial, really not appropriate. So I see Judge Bev crossing that line, more than I would like to see, for sure. But I just have concerns about their ability to really meaningfully flesh any of this out after what we learned in the Koberger case, when they were doing all of the litigation over the motion to change venue, because they did that through a pretrial survey process. And we got so much information, just fascinating information through that litigation about how these prejudgments are formed, people's awareness of them, the way that they disclose information and don't disclose information. We already heard with this questionnaire, the judge is saying, be thorough, give every answer, but she also wants to limit things to like 2 lines. Tell us in 2 lines everything you know about the Karen Read case. Like, it's not going to happen. People are at best going to, edit what it is that they say they know about the case into that 2-line period and just give you the general overview. And it's not going to meaningfully reflect what they've actually been exposed to. So we heard the general prompts don't work. When people are asked, tell me everything you know about the case, they tell you sort of general things. It's if you prompt them specifically, have you heard this? Have you heard that? Have you heard this other thing? That's then what will tend to trigger them to be like, oh yeah, I do remember that. They didn't disclose it initially, but that is in fact something that they've been exposed to. And of course, the risk in doing that with an actual jury panel instead of with a like cohort, people that aren't actually going to be asked to serve, but just are potentially eligible people out in the community, is that you are tainting the actual people that may need to sit on the case if you're providing them with this information. And so the only way I can think of to do it in a setting like this that wouldn't be problematic would be to tell them, I'm going to ask you if you have heard certain things. Some of the things that I ask you are not true and have not actually been reported. Some of them have. I'm not going to tell you which is which. And just mix it up. Have you heard that, I'm not gonna make up anything real egregious. But I'm sure you guys can think of some good fake news in the chat to ask the prospective jurors about. So that's the only way I could see it potentially working from a not tainting the actual panel standpoint. But is Judge Cannoni going to allow that? No, of course she's not. Of course she's not. So the reality is you go in knowing you're going to get incomplete information about what they actually know, and you're going to have to try to find a different way to get to what they're actually thinking. So I think they're going to really focus in on the opinion part, not so much the just have you heard of it, even though that is normally what you need to get into for a change of venue issue. It's just that's everybody. And if you can't ask anything meaningful, maybe you bring all these people up and ask them what did you watch? What sources of information did you rely on to get information about the case? Maybe that's going to be helpful. But it's really these people that have the opinion, and you're going to want to get a sense of what's the trend. Is it split? If it's split, maybe that's still okay. But you have to be thinking about the fact now that, okay, if it's a split, everybody knows about the case. And that's a broad potential pool of people that already have an opinion against Karen and against her case. You're not going to have that hurdle that you might have to clear in a different county. So flesh out, where are the opinions falling? People generally think Karen did it. People generally think Karen didn't do it. I think that's going to drive a lot of the decision making about what you do in terms of responding to all the publicity that this case has gotten. Definitely poses a whole set of challenges of its own, but yeah, I mean, everybody knew about this case. Okay, we got some questions we'll go ahead and go through, and of course we got plenty of motions and things like that we can get back to while we see if court comes back into session for us anytime soon. But before we do that, I really have to get back to this instruction that Judge Canoni gave, where she said, she's drawing their attention to the protesters, to the fact that there are people who are advocating for one side or the other. Bizarre to me that you would call that out, but then to also put that twist on it that they're advocating vigorously for one side or the other without having seen any evidence. That's a lie. That's a flat out lie to the jury, because this case has already been tried. And so a lot of people have already seen a lot of evidence, and that's why they have opinions about it. That's why they are advocating for one side or the other. We've seen it. Oh, we haven't seen the evidence in this case. That's true. Not this trial. But we already saw it in the 6 weeks or 8 weeks or whatever it was that we sat here for last year, a year ago. We saw a lot of the evidence about the case. So that's not right. That's not right. There was no need to put that in, and it's not true. And the thing is that if a lot of these jurors are familiar with the case already, they already know there was a trial. I mean, how many people are going to be exposed to this case, have information about this case, and not know that it was already tried last year? It seems like one of the basic timeline facts that pretty much even any random news story is going to cover that for background. Like, you're going to know that. So they already know. They already know. People have watched the trial. People have seen the evidence. They have, potentially even heard about what's come out. Proctor's texts was like one of the big headlines from the first trial. I did not like that one bit. Did not like that one bit. It's not true. It's not true. And you setting the stage in the opening moments of this trial by misleading the jury about what's going on doesn't give me confidence. No, it does not. Let's take a minute to go through some of your guys' comments here so we don't get too far behind, because you probably started while I was reading the motion to dismiss. So from Chopped Trials, if the camera is motion activated, how could he download it in 6-hour chunks? There wouldn't be 6-hour chunks if it's only recording seconds at a time. Yeah, that'll be interesting to see, won't it? Because now the defense has, at least in theory, all of the 6-hour chunks. So they're going to be able to see, is it recording when nothing is going on in there? There should be, right? There shouldn't be people in the Sally port around this car 24/7. Is the Sally Port that busy of a place? You wouldn't think so. I mean, doesn't look like a lot really happens in there besides holding the car for evidence. Like how often does that happen? I don't know. But yeah, that's going to be interesting to see, isn't it? Now, I mean, I can conceive of a possible explanation here, which is just that, okay, it doesn't record for 6 hours continuously, but it records 30 seconds here and a minute there and 2 minutes here, et cetera, et cetera. And once that aggregates into 6 hours, that's somehow how it gets chunked out with the download. Maybe. I don't know. But the defense knows by now. So they're going to know if that is not true, if that can be disproven. So James Cassatelli, any interest in covering the Rex Heuermann Gilgo Beach trial when that starts? I think it's going to be a doozy. You know, that is one I've been watching from a distance for a while. Haven't really commented on it because I just haven't had the, bandwidth really to go in deep with it like I like to. If I'm going to talk about a case, I want to know it. And so I just haven't had the time to really be following that one as it's happened. But I'll tell you what caught my attention with it right off the bat was the probable cause affidavit in that case. And I brought this up. It's been one of those things that has been like in my list of things. Like when I get a chance to write about this or make a video about this or something, I really want to talk about it because the comparison of that probable cause affidavit to the probable cause affidavit in Brian Kohberger's case, to me, it's very compelling. It really illustrates the difference between what a strong circumstantial case looks like and what a weak circumstantial case looks like. And it's because when you have the right guy, you tend to be able to corroborate their involvement on multiple levels. And so that's really what you see in the Rex Heuermann probable cause affidavit. You see that there's searches, there's journals, there's travel records, there's phone calls, there's emails, there's DNA that they, get from the trash can at the scene, like all of these different levels of things to be able to tie him into each particular incident that they're alleging. Now, of course, is all of this going to bear out at trial? I have no idea. But at least from the standpoint of the charging decision, they don't have him, as far as I know, as far as I've heard. It's not like they have him on video doing it. They don't have eyewitnesses. They don't have anything like that. It is a circumstantial case. They're piecing it together based on, what they can get from trace DNA at the scene and just other information that tends to corroborate, yeah, it was him because he communicated with this person, he traveled to this area, he had this MO, he did these things, so on and so forth. So that's kind of what initially caught my eye about the case. I don't know. When is it going to start? I'm not even sure when it's going to start. I'll look into it. It's a maybe for me. Canoni's baloney. I don't like that Bev said the jury will decide if Karen Read committed any crime. Shouldn't she have said the jury will decide if Karen Read committed the crimes for which she is charged? Yeah, very good catch here. Very good catch. No, you're actually not. It's not your job to decide if she committed any crime. Your job is to evaluate the charges that have been filed against her and determine if the evidence supports those charges. This whole did she commit any crime is kind of inviting the jury to exceed the bounds of its responsibility and decide if Karen is like morally culpable for what happened. Right? And that's not your job. That's not what you're there to do. You're there to make a legal decision. This is a This is a court of humans. This is not a higher court to, pass judgment on people's souls or whatever. We are literally here to evaluate whether the evidence supports the charges that have been brought. So yeah, I don't like that language at all. I noticed last time in the first trial, Judge Cannoni doesn't always follow the form instructions. She has her own little variations that she puts on them. I remember she even kind of discussed it last time, that she's got her script that she uses, or standard comments that she makes. And I guess I would like to know, I'm curious to find out, does she provide these to the defense ahead of time? Because they should have an opportunity to be able to object, provide input on how these instructions should read. It was very confusing last time, kind of trying to follow how they do the instructions in Massachusetts, because it kind of seems like the judge sort of comes up with the bulk of them. And then if they want extras, they might put those in or not put those in, object to what the other side wants. So it's sort of a process of building this thing, but at the same time, it was confusing about, what sort of notice they had about what was going to actually be said. We saw that there was that confusion over the verdict sheet, and like the verdict sheet went back to the jury before it had been approved or had an opportunity to review it, that type of thing. That's not good. With a trial of this length, you got plenty of time to be getting these kinds of details right. And so the instructions are really critical. Not taking the time to distribute those ahead of time and give the parties an opportunity to review them and catch potential things like this. Like, yeah, that's objectionable. That warrants an objection. That is not their job to decide if she committed any crime. It's their job to decide if she committed the crimes that she's charged with. So that should be well taken as an objection. It's just not clear if the defense is really given the opportunity to be able to do that. Cannoni's baloney. Bev, you just did mislead the jury. You said Trooper Michael Proctor. I have grave concerns. Yeah, it's not even the first time she misled the jury, right? Not even the first time. She already told them the people that are advocating haven't seen any evidence, when a whole bunch of them very likely watched the first trial and saw all of the evidence presented in that case. Yeah, Trooper Michael Proctor, he's ex-trooper. Ex-trooper Michael Proctor. He's ex-trooper. He's not Trooper Michael Proctor. Yeah, why do I suspect she's not going to have grave concerns about that? D. Brown, 83. What happens if they can't get the number of jurors they need? Then it's essentially the equivalent of a mistrial. They have to start over and bring in a new panel. So they would just reschedule it and start from scratch. Try again. Maybe they would consider, what are the reasons for it? If it's because of all of the pretrial exposure, maybe at that point, they evaluate, do we need to change venue? But, if Karen is happy with the way that the perspectives are aligning, then she may not be inclined to do that. So, Tammy Martin, Andrea, how long will jury selection take? Weeks? Yeah, I don't know. It's a good question. They have brought in a much bigger panel this time than they did for the first trial. First trial, I want to say they brought in like 400 people. This one, they're bringing in like 1,000 some. Pretty sure, like it's big. She just told us like a couple weeks ago, and I can't remember the exact number, but it is bigger. So they've got more people to go through. I think that's in anticipation of the fact that there are going to be more issues with people knowing about the case. Some people may very well have watched it. Been a lot of news about it, all that type of thing. So just volume alone suggests it's potentially going to take a while. Normally when you have 16 peremptories, it's like, how long can it really take? But the issue is going to be cause challenges here. And depending on how broadly or narrowly she tends to grant those types of requests. So cause is you've got bias. You can't apply the rules. You've already got a fixed opinion. You're not going to be able to be fair and impartial and do the job of the jury. People in that boat, yeah, I mean, you're not gonna be able to serve, and so then that leaves the peremptories to be exercised on essentially whoever is left. Really depends on how broadly she's inclined to grant those. If she doesn't grant very many of them, then they will exercise their peremptories probably pretty quickly, getting through the jury panel, striking the people that, may not favor their position, may not be receptive to their position, may not be open-minded, whatever, but hasn't risen to the level of Judge Cannoni granting a for cause challenge. Maybe the juror is able to rehabilitate themselves after, they answer all the questions about how terrible Karen is and, how they're totally sure that she did it, but they can be fair and impartial. That's all. All they have to do is say the magic words, and those magic words will be fed to them by the court or by the prosecutor or whoever. But can you be fair and impartial? Oh, yeah. I mean, not that many people say, no, I really can't. Nah. If you want off the jury, you might say that. But people that are just being, forthcoming, don't really care if they get chosen. Maybe they even want to, people who are like, yeah, it'd be all right with me. Yeah, I can be fair and impartial, even though, they've already formed these opinions. So she doesn't grant a lot of cause challenges, then jury selection will go a lot faster. But if she grants a lot of cause challenges, then it could very well take some time. So we'll just have to see. I mean, we'll get a better perspective, I think, once we see how things go today and how quickly they're able to move through the process. We'll just see. Palmyra Media has gifted 5 Andrea Burkhart memberships. Thank you so much for that. Very generous of you. YSL Kells. Bev didn't say John O'Keefe was an officer when describing the case or all the people that night. How does nobody know in Albert? Figures. These cues are broad AF. Yeah, so they didn't ask people to raise their hands when the names were called. They just read the entire list and asked, do any of you know any of those people? Asked them, probably not a whole 5 minutes later, but it could have been all 5 minutes later. Oh, by the way, that list that I just droned on to you for 10 minutes, maybe 15. Yeah, those people, remember that. Tell me if you knew any of them. So we don't know specifically who, I identified knowing who. We just know that some people raise their hands. Yeah, they're familiar with somebody on that list. Seems more likely that it would be some of the local people. You tend to know people in your neighborhood better than some random PhD from Pittsburgh, unless you happen to be in the business where you interact with those types of people. Odds of that are pretty low. So yeah, I would say it's probably a pretty good chance that there are people on there that know some of the Alberts. Stephanie, hi, Andrea. Can the lawyers explain impeachment to the jury? It's a good question. In theory, sure. I mean, they can rely on case law, rely on kind of anything that establishes what impeachment is. I guess it would just kind of come down to what exactly do they want to say and why. Generally speaking, impeachment is not like a principle. It's not a formal thing. It's not like a determination that gets made. Somebody has been impeached, somebody has not been impeached. It's just a thing you do when you point out this witness is contradicting prior evidence. This witness is contradicting other things that they've said. This witness is generally uncredible because this witness has a history of lying, of dishonesty, that type of thing. So it tends to be a thing that you show. It's not necessarily a thing that you have to announce that you did. And in fact, in some ways, like it's like that, what is it, Margaret Thatcher saying, I think, if you have to tell people you're a lady, like, probably not. I don't remember the exact saying, but something along those lines, like some things you really shouldn't have to say. And it kind of lady doth protest too much type of situation if you do. If you have to announce that you've impeached somebody, you probably haven't. If you've done it, it's unsaid. We all see it. Like we all see the credibility fell apart on the stand. So that's really all impeachment is about. I think that the bottom line, the answer to your question is it depends. It depends on what exactly do you want them instructed on, and what's the purpose? Like, how is it going to help them be better jurors to understand what impeachment is? Jonathan Dean, should the Bowden defense allow the defenseman to ask Tully about his previous horrible cases he investigated, like Birchmore case? Yeah, the whole role of the Sandra Birchmore investigation and how much they're going to be able to talk about, pretty sure that one is still undecided. I haven't seen a ruling on that. And I think that's a very, very legitimate question, because where there are overlaps between the personnel in particular, it does seem pretty relevant to me. Guarino is the big obvious one. It's the big obvious one. You miss 30-some thousand text messages that just happen to come from a police officer to the minor that he had groomed. You just happened to miss that. It's a little bit coincidental, of course. So it goes to bias. It goes to his bias. Does he have a tendency to not find things that aren't helpful to the state's position or to protecting law enforcement people? Does he have a bias in that respect that infects his analytical ability? It goes to just carelessness, quality of his work. And that's more, I think, the Bowden issue that you're talking about. You did cell phone extraction in this case, and you want us to rely on it, but you did a cell phone extraction in this other case, and you missed 30-some thousand text messages that this guy sent to the minor he had groomed and has now been charged with murdering by the feds, while you apparently still maintain that it's a suicide, that it was a suicide. So if you're asking me, yeah, I think it should be fair game, because I think it goes to classic impeachment strategies, things that are allowed. Impeachment for bias is one of the most protected areas for a criminal defendant. Lot of good, very strong case law on impeachment for bias, and how, because that's such a critical issue in the case, a lot of times even stuff that is not wouldn't normally be admissible in court, you can bring it up if it tends to establish bias. So the Commonwealth's gonna try to argue something like, oh, well, is this a 404B issue? This is a prior bad act. You can, it follows these rules. You can't use it for inferences of bad character and things like that. No, but if it goes to bias, you might be able to use it anyway. Pretty good indication from the case law that you can. So if you're asking me, under the law, should you be able to do that? Yeah, you should. Yeah, you should. To the extent it goes to bias, to the extent it might establish a pattern of negligence or just poor performance of your work, yeah, they should be able to go into it. Is she going to allow it? Well, that is the $1 million question, isn't it? Duncan, Idaho. Andrea, can you as an attorney say this judge is crooked? Would you say that in this case, or just so close to crooked as to be scorching? Everything about the Commonwealth and her rulings to me is mind-boggling. I don't know if she's crooked or if she is simply so biased that, you know, she's just a kind of classic prosecutor in a robe. She's bending over backwards to make it as easy for the Commonwealth as possible, as difficult for Karen as possible. She's running interference for the Commonwealth. We see it throughout, you know, the language that she uses. I mean, it's the motion to dismiss that we'll get back to here in a minute. Is she crooked? I mean, to me, a lot of this is it's got a specific meaning, right? And I don't know. I don't know if she's crooked. When I say a judge is crooked, what that is, you know, meaning to me is like she's on the take, she's getting paid off, she's doing, you know, quid pro quo, something like that. I don't have proof of that. So I don't know that that's the case, but I think that's kind of been the issue with this whole system. And it's the issue that is kind of often an issue in small communities. It's just how they tend to work. The power tends to aggregate. You have the club, you have who's in the club and who's not in the club. If you have ambitions, you tend to be in the club and you tend to play the club games so that you can advance your way up the ladder. Use that club membership to your benefit. So that is not unusual at all. Is that crooked? If that's crooked to you, then yeah, I think this is crooked. But it's because the system is crooked. She's just one more participant in this wheel that will continue to turn with, you know, new players, new judges, new cops, new prosecutors, new governors, you know, all of the people that have influence over these types of positions and these types of decisions. You want to be a part of that. There's kind of a role you need to play. You need to make the right friends, have the right alliances, all of that type of thing. So yeah, I mean, the whole system is crooked in that way. And you really see it. You really see it in the small towns because you have so much more just proximity. You know, a big city, a judge might not see the same prosecutor, you know, for months on end. But in a small community, you see the same prosecutor every day. You see the same cops every day. And so it's just a different dynamic when it comes to playing the game. So that's kind of how I see it. Hopefully that's you know, clear. But I don't know. I don't know that she's taking money, but is she part of a corrupt, what looks like a, you know, kind of classic old boys club in a small town? Yeah, it looks like that to me. She's got her alliances and her side that she's on, and she's going to use her position to influence the outcome. Kristen, could you instruct jury only convict if you yourself would be willing to serve the same sentence as Reed if she is proven not guilty or similar to Hammer reasonable doubt? I mean, I think if you, it's touchy, you know, anytime you're getting into kind of trying to explain reasonable doubt or compare it to other types of decision-making processes, put yourself in the shoes of people. These are all arguments that potentially can be a little bit problematic, because the other way to think about it is, would you want the prosecutor to be able to make the equivalent kind of argument on their side? And so if you're saying basically put yourself in Karen's shoes and would you be happy with your verdict? You know, you don't want the Commonwealth you don't want the Commonwealth to be able to be like, well, put yourself in the family's shoes, and think about, would you be happy with the verdict? Like, it's just, it's a little close to opening a door that you don't necessarily want to open. When I would talk about reasonable doubt with jurors, I would try to keep it clean. I would just express that, when you have a reasonable doubt, it's because there's a reasonable alternative explanation. And that's usually the way that I would approach it in a trial. If there's a reasonable alternative explanation, then that's a reasonable doubt. And the alternative explanation, it can be because I put evidence on, but it also can be because I've pointed out to you, here's the defects in the state's case, and they haven't ruled out, X, Y, or Z. And so the goal is then to elicit that during your cross-examination. You didn't do this. You didn't follow up on that. This person, whatever. And so you can tie it up in closing. Look, it's a reasonable alternative explanation. They didn't rule that out. And that really kind of goes hand in hand with the Bowdoin defense. That's really what it's getting at, is because the police didn't do an adequate investigation, they didn't rule out the reasonable alternatives. Therefore, there's reasonable doubt that the defendant is guilty. So that's how I would typically approach it, to just try to keep it clean. I think what this is maybe getting at a little bit more is the definition of reasonable doubt having that moral certainty quality to it, an abiding conviction to the level of a moral certainty, something like that. And that's a tough one. That's a tough one. I'm not, just thinking about myself and kind of my style in trial, and just my style in general. I tend to be very analytical. If I was going to try to get into a moral argument, with the jury, I'd probably have to think that one through a little bit. It's not going to come naturally to me. The other thing that jumps out about this question, though, is the jury explicitly told you're not to consider punishment. You can't consider that. So in that sense, this question is probably going to be considered inappropriate. All that they can consider punishment for is just the fact that there might be some. Should help them be cautious in their decision making about whether they did it or not. But what punishment she might be subject to is not something that they're supposed to consider when it comes to is she guilty or not guilty. So in that respect, this question probably would not be allowed. That said, yeah, can they get into definition of reasonable doubt, moral certainty, what that means? They can. It's just that can be a little bit risky, and you want to think it through pretty carefully to make sure that the Commonwealth isn't going to be able to flip that and use it to their own advantage. Zencat, I had jury duty in Boston. Jurors were asked if they had any prior experience encounters with the police. I didn't hear Bev ask that question. I think that one is on the questionnaire that they were asked to do. We saw a few versions, I think, of the questionnaire floating around. Of course, I don't have it handy right now, but pretty sure that question was on there about you or anyone have any prior experience with criminal things, something like that. So that is a pretty routine question to ask. In part, in a small community, it may shed light on what sorts of relationships they may have with prosecutors, law enforcement, defense and defense witnesses, and everybody involved in the case. But also too, just because of the potential for bias. I was a victim of a crime, and Mr. Lally was so nice to me. I'm going to give him every benefit of the doubt. Versus, the police pulled me over and harassed me and, gave me a ticket without cause, and I had to go to court and it got thrown out, and they're terrible. So those types of things, yeah, you typically ask that question to flesh those types of things out. So I do believe that's in the questionnaire in this case. Melinderp, Carl Steinbeck had said that not having case law about someone like Easter being an expert in a trial in Massachusetts does not mean there are no trials where this has occurred. How would you find those trials? Well, see, that's the trick of the standard that Judge Cannoni has set. She wants precedent from Massachusetts on this very specific question that an expert is allowed to testify to these issues. And so the problem is the only way that question makes it up to an appellate court is if a court makes that decision, makes it against the defendant, and the defendant then loses at trial and has to appeal. So it's a very narrow set of circumstances that are going to prevent this anyway. So what are the possible options when a defendant wants to present expert testimony? The court can let it in or not let it in. We can already rule out all the cases where the court let it in. That's not an error. That's the defendant isn't going to argue that's an error on appeal. It's not going to get raised. And the reason why I'm bringing this up specifically is the defendant, because it's only the defendant that gets to appeal. Okay, like 99 times out of 100, the state doesn't get to appeal. Very limited range of things that they get to appeal on. So it's nearly always the defense that's going to be raising this issue. If the court lets it in, it's not getting appealed. So no, those questions, those cases aren't going to make it up to a court that has the ability to make binding precedent. So only the ones where a court said, no, you can't do it. Only ones where the defense lost after they said, no, you can't do it. And only ones where the defense specifically argued that issue on appeal, that this was an error to not let me bring this in. So, certainly a possible set of circumstances that would explain why there's no appellate case law on this precise issue. Is an expert allowed to testify to this? Is because it's routinely let in. It's routinely let in. So it's not a question. And the case law that I looked at, that I saw, that other people had found as well, Ali Mata had found an excellent case where they actually faulted the defendant for not calling an expert to testify about what kinds of police procedures could have been employed, were necessary, etc., under the circumstances of that case. Other case law that, brother counsel had found some, like there's plenty out there addressing the circumstances of expert testimony in this context. So kind of a conceivable state of affairs is that nobody but Judge Cannoni has it in her mind that this is somehow inappropriate for juror testimony. As far as like trials where that's occurred, I mean, you'd probably have to do word of mouth. You can't really do a search of trial cases like that. They don't maintain those kinds of records, really. It's very difficult to search trial court decisions, trial court processes, because they aren't precedential. They just matter for purposes of that case. So they aren't really made to be easily searchable and stuff the way that appellate decisions, especially published appellate decisions, are. So yeah, I mean, Mr. Steinbeck is absolutely right. It does not mean it doesn't happen. You cannot draw that inference from it. It means that issue has not squarely been presented to the court, and that could very well be because nobody has found this to be an issue before. It's understood that if the expert has information that is specialized and that would be helpful to the jury, they can bring it in. Question I saw a lot after we got this ruling yesterday. So we're talking now about the order excluding Michael Easter. In fact, maybe I'll pull it up. I do have that one. Here. Let's see. Let me go ahead and share that. Get it up here. Yeah. Excluding Michael Easter. So here's her statement of the law, right? They have the right to base their defense on the failure of police to adequately investigate. And the defense may present evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated in circumstances in which it was reasonable to expect that the police should have conducted such tests, followed such procedures, or investigated such information. So, very conceivable state of affairs is that because the statute specifically says the defense gets to produce this evidence, they get to present it at trial, that when they offer an expert to present it, courts go, yeah, the statute says they can do that, so we'll let them do that. This does not say the defense gets to argue based on whatever the common law chooses to present and whatever they're able to achieve through cross-examination. The defense can argue that the investigation was insufficient. That's not what it says. It says they get to present evidence that it wasn't done. How are they going to do that? How are they going to do that without an expert to testify about what's normal, what's available, what's possible? How are they supposed to do that? An expert may, when appropriate, be used to support a Bowden defense on matters beyond the common knowledge of the jurors, and looking at these, different issues. Role of expert testimony is to assist jurors in interpreting evidence that lies outside their common experience. Yes, that is indeed what the role of the jury is, or the role of the expert. Thus, the first foundational element that the proponent of expert testimony must establish is that the testimony will assist the trier of fact to understand the evidence or to determine a fact in issue. Yeah, you don't need to bring in an expert to testify about, the fact that people need to breathe to live. Just for example. But you might need to bring in an expert to testify about how certain injuries could affect a person's ability to breathe, and based on that, what the death process might look like under those types of circumstances. So, little bit of the distinction there. You don't need to establish the general thing everybody already knows. You need to breathe to stay alive. But how can that be affected by circumstances? Just by way of a hypothetical here. That is the type of thing that can be very, very appropriate for expert testimony, because people wouldn't be expected to know that because you were not able to breathe, your death occurred in this manner. There were these mechanisms that took place, etc. In support of her Bowden defense here seeks to admit expert testimony from Michael Easter, a retired agent of the Federal Bureau of Investigations, to opine on law enforcement's failure to adhere to standard investigative policies and protocols in this case. Standard investigative policies and protocols. Standards. He's here to testify about standards. More specifically, Easter's expert report indicates that he will testify that the investigation in this case was not reliable due to the lack of a secured crime scene, absence of a detailed crime scene log or evidence chain of custody, the failure to separate witnesses, and the premature categorization of individuals as witnesses, and potentially biased based on failure to investigate other suspects and obtain their cell phone records. Yeah, so things that they could have done that didn't follow up on. The jury needs to know what sorts of procedures are available and why might they be necessary. the case that Allie found very specifically faulted the defendant for not bringing exactly that kind of expert testimony. What was necessary under these circumstances, given the standards that should apply to investigations? The court cannot find, nor has defense counsel cited, one Massachusetts case where an expert was permitted to opine on the general competency of a police investigation. So let's go back here about what he's saying. This is not about the general competency of a police investigation. These are specific actions that they failed to take. And we know his testimony is going to be about the failure to adhere to the standards. So it's not a generalized, they did a bad investigation. This is, here's the standards that apply. Here's what they could have done. Here's what they failed at. Here's what they did improperly. Here's what they, failed to pursue. Why? Maybe because they're biased. That is not a general competency of a police investigation. So then she has to footnote this case here where defense counsel, through cross-examination and the calling of its own expert, extensively challenged the adequacy of the forensic investigation conducted by the police. So got to call an expert for purposes of challenging the forensic investigation. The court acknowledges that some forensic matters are beyond the common knowledge of jurors and therefore appropriately explained by expert testimony. That is not what the defendant is seeking to present through Easter's testimony. Well, you haven't given a fair characterization of Easter's testimony, because after you describe very specifically that it's about standards and it's about specific actions that they took, that they messed up, that they did not take, you then say, well, it's just about the general competency of a police investigation. Yeah, that's not a fair characterization. The lack of authority suggests, does it, that during all the jury trials where the defense has been inadequate police investigation based on Bowden, expert testimony has not been needed for the jury to be able to evaluate the reliability of, get to the next page here, the Commonwealth's case, and whether any failures in investigatory steps are sufficient to create reasonable doubt of the defendant's guilt. No, it doesn't suggest that at all, for the reasons that we have just provided. If the motion is granted and the expert testifies, there's no error to complain about. That's why it wouldn't get raised. Not because no defendant has ever proffered an expert. That's insanity. She's so unable to get out of her own perspective. It's a very arrogant perspective on her view of the law, her view of the case, her view of the facts, et cetera, et cetera. Just so assuming that anyone would see things the way that she did. And we, see hints of this with like the, oh, counsel, you should already know what the basis for the objection is. And that type of thing, those little comments that she makes, that arrogance, that her perspective is the true and right one. And therefore anybody who's following along will naturally share it. She can't see past the fact that a lot of people might disagree with her. And that's why it doesn't go up on appeal. She just automatically assumes, well, if the defense tried to, surely it would be refused. And there would be an appellate decision. No, that's definitely not the only option or even the most likely one for why there's no published case law on this. Why? Because there's a statute that says they get to do it. And statutes are good law too. They're also good law. Easter's proposed testimony concerns basic aspects of a police investigation which are within the common knowledge of a layperson. No, this is factually incorrect. It's not correct. You already stated and acknowledged he's there to testify about the standards and the specific actions. The standards are not common knowledge. In fact, when this came up in the first trial, how many times on cross-examination did we hear either they don't know the standards or they aren't familiar or that isn't their job or it all went out the window because it's snowing anyway? This came up. This came up during the last trial. The fact that they didn't do any of these things, didn't secure the scene with the crime tape. Why is that important? Is that in fact a standard? Just try to nail down. Just try to nail down cops on something like that. You think they're going to volunteer? You think they're going to volunteer? Oh yeah, when I was in basic academy, I learned that, XYZ is critical because da-da-da-da-da. They're not there to help the defense. They're going to instantly, I don't know, I don't remember. And let's say you even have the policies. You've gone and you've printed out the standard policies that the Massachusetts State Police has adopted for specific investigative practices. And you go in and you're going to impeach, I don't know, Buchanan, Proctor. Proctor's the case agent. He's the lead investigator. So he's the one, that should have the ultimate responsibility for making sure that those standards met. You go ahead and try to impeach. Go ahead and try to impeach Trooper Proctor with that document. You're going to hand him that document and he's going to say, I don't know what this is. I haven't seen this before. I don't know. It's something you printed out. I don't know if it's complete. I don't know if it's accurate. I don't know if you changed it. He's not going to authenticate it for you. He's not going to do your job. Cops are not there to be helpful to the defense. So that's why you need an expert, because you have the right to present evidence, not just to cross-examine what the cops want to tell you or not tell you about how they conducted their investigation. Oh, they'll rely on their training and experience to push all kinds of bullshit conclusions that they reached or decisions that they made. And that makes them experts, but only up to the point where pointing out their training and experience might be helpful to the defense. Yeah, that's where the line is drawn. Through zealous cross-examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures. How are they to do that, Judge Cannoni, if they can't establish what the standard practices and procedures are because you're not allowing them to present an expert? You're not allowing them to do what the statute says they can do and present evidence as to the standard practices and procedures. They have the right to do that. They are not required to rely on cross-examination to get that done. And can raise the issue of potential bias by police action or inaction, as counsel did effectively during the first trial. Did they now? Because if I remember the outcome of the first trial, if I remember that outcome, yeah, it didn't convince the jury, did it? It wasn't that effective, was it? So now they're tweaking their approach, learning from the past process, and doing what the statute says they get to do. And you're going to say no. You're going to say no. Like we don't remember how that all went during the first trial. Why didn't you put up crime scene tape? Well, it was really windy. It was really windy, so we couldn't. So we just threw up our hands, and you didn't station anybody there. It was snowy, it was snowy. Did we mention that it was snowing a lot? Did we mention that? Yeah, we remember very well how that went during the first trial. The court finds that expert testimony is not needed for the jury to determine whether or not the investigation was compromised by any failure to follow procedures or pursue other suspects. So the jury, according to her, can evaluate whether they followed standard practices, procedures, protocols without knowing what those standards are. That's the conclusion that she's reaching. The defendant is undoubtedly permitted to pursue a Bowden defense, and the court will give the jury a Bowden instruction if requested. However, jurors are perfectly qualified to, last page here, evaluate the adequacy of the police investigation in this case without the assistance of expert testimony as proffered by the defendant. For the foregoing reasons, Commonwealth's motion is allowed. Yeah, this one is quite bad from my perspective. This is a terrible ruling. This is one that you just add it to the stack. Add it to the stack of the impairment of Karen Reed's rights. Right to present a defense. The statute makes it clear that means present evidence. Judge Cannoni likes to rely on her discretion a lot when it comes to evidentiary rulings. Oh, the judge has broad discretion to find this or not. But I think she might have gotten out over her skis on this one. I really do. Because to the extent that this finding that the jury, the standard investigative procedures and policies and protocols are within the understanding of an average layperson, she doesn't have a record for that. That's not a reasonable conclusion from the information that she has to base her decision on, given what Mr. Easter is, going to testify to and what he's bringing to the table. Standards, what they are and why you have them. Terrible, ridiculous ruling. What are they going to do about it? I know that's kind of $1 million question that everybody wants to know. What are they going to do about it? They might move to reconsider. I don't know. It's possible. Meaning like right away they might do that. But I wouldn't be surprised if they don't. Trial's getting underway. They've got kind of more important priorities right now. They got to be focused on what they're going to be doing on a day-to-day basis. And the reality is that it's not going to matter until it's time for them to put on their case anyway. So for practical purposes, if this was me, I'm running the team and I'm making the decision about what to do, I'm not raising it right away. I'm going to go ahead and go through my cross-examination. I'm going to, do it the way she says I'm supposed to do it anyway, because it's not actually an either or. You do get to do both. You get to do both. You get to both cross-examine and put on your own evidence. And it's wild how that works, isn't it? You get to do both. So I'll go ahead and go through and do my cross-examination, and I'll watch them wiggle, and I'll not watch them not acknowledge that there are any standards, and I'll watch them pretend not to know why it's important to do certain things. I'll watch them make excuses for why the snow made it impossible to do effective police work in a state where, snow is routine 6 months out of the year. I mean, snows a lot. Snows a lot in Massachusetts. Somehow that just throws the ability to investigate crimes out the window. So I'm going to go ahead and just make a record of all that. And then when it's time for me to put on my case, that's when I'm going to revisit it. I'm going to point out, here's the stuff that Mr. Easter is now going to offer that wasn't addressed through cross-examination because they all pretend not to know anything. That's standard. That's what they're going to do. We saw Trooper Buchanan do it at the last trial. Proctor's handwriting, right? Never seen it before, doesn't recognize it, can't authenticate, won't authenticate stuff the defense is offering because he's just not sure. The ring, there was a log, an activity log from Ring that came back with the search warrant return. This was kind of important because the state, the Commonwealth, is arguing that Karen Reed somehow got into John's computer and deleted Ring footage. They had to acknowledge as the trial went on, they have no evidence of that. They can't prove she had any access to his computer. She didn't have his phone. Clearly didn't have the Ring app on her own phone. So how exactly would she have accessed it? Yeah, they didn't make a very good case for that. But they got the activity log from Amazon, from Ring, in their search warrant return. But no, Sergeant Buchanan never saw it before. I've never seen that. I don't know what it is. I didn't see the return. Not his job. That's what they do. They plead ignorance. So they're going to do that here. Let them do it. Point out what you haven't been able to elicit. Here's what Mr. Easter offers. He's going to establish these are the standards in MSP. These are the standards that are taught in basic academy. Here's the standards that are taught when you take the detective's exam. These are all things that are going to be formalized somewhere. Where? Well, I don't know. That's beyond my expertise. Even as an attorney, I don't know where they are. I could hunt them down and probably find them and make, public records requests and so forth. But the very fact that you would need to do that tends to show these are not within people's common knowledge. The fact you have to take a detective's exam to show you understand how to lead an investigation, how to conduct it, that should tend to suggest that it's beyond not just the knowledge of ordinary lay people, but even ordinary law enforcement officers, because the training you get in basic isn't enough. You gotta have more education and pass another test to be a detective. That's what he's going to bring to the table. Here's how he's going to establish it. Just make a very crystal clear proffer and readdress it at that point in time. You typically have to do that with motions in limine anyway. I started going down a little bit of a research rabbit hole yesterday that I was never able to finish because, there are like 15 things that came in this case I had to catch up on. But I was looking at whether Massachusetts is a case that considers a motion in limine to be preliminary and therefore not a ruling that you can appeal. There's quite a few jurisdictions, including my own, where that is the general rule. They're like a motion in limine is advisory. It always depends on how things flesh out at trial. They're always subject to being revisited. So if you do not re-raise your objection in the trial itself, at the point where you want to offer this evidence, you haven't preserved it for appeal. So I don't know if Massachusetts follows that rule or not. I wasn't able to really hunt that one down in the brief time I spent on it yesterday. But that is kind of a standard argument that gets made. So it's never a bad idea. Make your good record, make your proffer. And, she wants to continue to not allow what seems to be a pretty reasonable proffer by the defense, then you've made your record for the appeal, and that's what you get to do. Michael Muddragon, defense, motion to dismiss. Bev, how dare you? Minus 10 points from Gryffindor. Hank Brandon, Honk Brandon, misrepresents facts with every breath. Bev, how sweet, 50 points to Slytherin. It shouldn't be funny. It really shouldn't be funny that we can do a caricature of this trial with this, the sorting hat and the participants in the houses and everything. It shouldn't be a Harry Potter joke. But it is. It's just so crystal clear. It's really crystal clear that The same standards don't apply. They don't apply. Oh, I'd like to, before I lose my train of thought too much, get us back to that motion to dismiss where we left off. Pretty sure this is where we left off over here. Go ahead and pull it up. Yeah, the Commonwealth, how could they have known that any of this was relevant? They know that the defense is arguing that that Karen Reed was framed, and so their access to her car, how should he have how could they have anticipated that once the Canton Police Department had been recused out of the investigation because of their relationships and the car was then brought to that facility, how could they foresee that that might be an issue? That the access to it might be something that the defense would have an interest in? How could they have possibly foreseen that? Yeah, who knows? Completely incomprehensible in Judge Cannoni's world. She's got to footnote this, right? Had no reason to inquire as to whether any relevant video footage existed. Not just one footnote, but she's got to footnote this twice. Okay, so we got to address Higgins in a footnote. Could have been used to show Higgins perjured himself before a federal grand jury when he testified that he did not call anyone on the night in question. That argument fails for several reasons. No, actually, it doesn't. It's impeachment evidence. He said he didn't call anybody. A jury could believe from this evidence that he did. That's impeachment. And you get to confront him on it. You said you didn't call anybody, but here you are on your phone. You didn't remember that? You don't remember who you were talking to? You don't remember what you were doing? Oh, conveniently, you were checking your voicemails. You didn't turn over your phone records to substantiate that when you went and selectively chose the text messages you wanted to provide to police. You didn't mention that either. You didn't include this in your time frame of your activities before you went home to drink more and go to sleep on the couch in sandwich. Yeah, it's impeachment. First, it is not at all clear how within the bounds of admissible evidence the defendant could introduce evidence of this alleged perjury at her criminal trial. Well, you get to point out that either he said the same thing in his grand jury testimony as he said at trial, if he said it at trial, which maybe you wouldn't ask him because they hadn't provided you with the information that would tend to contradict the testimony he gave at the grand jury. So maybe he gave the same testimony, in which case you just impeach him on what he said in this particular trial, or he said something different, in which case you impeach him with his prior testimony, and then you point out, ain't this you on this video? Not hard to do. Definitely not rocket science. What's happening here is she's skipping over the step where you don't even know this is an issue because the state has concealed the fact that there's this evidence that has the potential to contradict what he testified to under oath. So you don't ask that question because you don't know. You don't know because they didn't give it to you. That's the problem. That's the problem. But she just skips over that part. Second, even a cursory review of Higgins's grand jury testimony reveals that he said that blah, 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 blah. Don't know. Third, the video at issue, a 4-second silent clip showing Higgins walking across the parking lot holding a phone near his face, does not clearly show, as the defendant represents, the witness speaking to some unidentified individual on the phone. Well, I don't know what it says, and this is argument. This is argument. She's really going out of her way here to try to suggest that the defendant arguing the facts is somehow a representation of facts. She's trying to keep their arguments in line by trying to remind them, I already found you in contempt. That's what she's doing here. This is the courtroom equivalent of the Overton window is shifting. She's shifting it now. These are your representations. Clearly show, of course that's argument. Of course that's argument. And we don't have the video, so I don't know. I don't know what it shows. We didn't get to see it in that first trial. I don't know if you see his lips moving and him talking, him gesturing. I don't know what you might be able to see that would suggest he's engaged in a conversation. I don't know. And the bottom line is it's really not for you to decide. When he said he didn't make any phone calls and there's a video of him on the phone, it's potential impeachment. It's potential impeachment. They get to bring it up. The clip does not reveal how Higgins is utilizing the device, and it in no way establishes that he perjured himself before a federal grand jury. Well, it could, because a jury could decide that it did. The jury could look at the video and decide. He said he didn't make any phone calls, but he's right there on the phone. That's a lie. Jury can decide that. It ain't her call to make. Finally, in this regard, the remedy for non-production. Not the remedy for the Brady violation for withholding impeachment evidence that the defense is entitled to. Not that. No. Remedy for non-production of this video clip is not dismissal because the defendant's rights are fully protected by her ability to use it for all it is worth at the retrial. Yeah, doesn't matter. It doesn't matter because they can just try again. They can try again until they convict her. They can just keep trying. Pretty wild standard, isn't it? Second footnote that she has to make. Okay, so first off, drops the entire Higgins impeachment evidence, Brady, all of that in a footnote. It's an afterthought. It's an aside. She can't even include it in the body of her opinion. Why? Because it's really damaging. It's very damaging, and her reasoning on it is very, very problematic. But a second footnote, even with respect to the main driveway side exterior Sally Port camera, even if Proctor should have turned it over to Lally prior to trial, the quality of the footage is so poor that it is impossible to tell the condition of the taillight or how close anyone was to their right taillight. You don't know what the defense might be able to do with that video to make it more visible. You don't know. You saw the Commonwealth was able to enhance video to make it more visible. You don't know what the defense can do with it or not do with it, or what their use of it might be. Even if he should have turned it over, I mean, what even is that? Even if he should have turned it over, he should have fucking turned it over. Why don't you just go ahead and say that? These guys should have turned it over. You won't even tap them on the wrist. After they certified, swore under penalty of perjury, while we're talking about representations, that they had produced everything and they had diligently searched. And they somehow, weren't able to come up with this until into the trial and after. Yeah. Oh, I'm a little outraged now. I got to see what page I'm on. Okay. So this is not to say that the Commonwealth had no duty to turn over the Sallyport interior back wall footage before the first trial. Oh, because you just spent 2 footnotes telling us they really didn't. Nothing. The production during trial was undoubtedly late. Yeah, it was. And it was post-certification, wasn't it? That your own case law that you found before, when it was time for you to smack the defense, your own case law established, yeah, that's a violation. That's a problem to certify falsely and then produce information after the fact. However, the defendant received the video more than a month before it was submitted into evidence. Yeah, well, you have tons of time while you're in the middle of trial to actually do stuff with it. And because she has advanced no argument as to what, if anything, her counsel would have done differently if the disclosure had come earlier, the defendant has not shown she was prejudiced as a result of the late disclosure. Let's say it's just the minimizing. No harm, no foul. I mean, you had a month. Well, we've already gone through several examples right here. You might have asked Higgins about that grand jury testimony about not being on the phone. You might have followed up on that. And then you might have impeached him with that video. Just an example. Were you actually ever a defense lawyer, Judge? Like, were you ever? I can't get the impression that she was much of one if she can't see how the defense might use that video. So then she's, just going through some more of her case law, detailing the manner in which, had he been timely informed of the witness's statements, he would have altered his defense tactics. The defense also argues that the Commonwealth has violated Rule 14 by failing to preserve all footage with the metadata. There is no merit to this argument. Really? Really? Because wasn't it just a few pages back? Oh. But that was because this isn't the crime scene. It was only crime scene photographs and videos that require the metadata. Other video, it doesn't matter. They didn't need to produce any of that. The defendant did not make any specific request for the original footage with metadata before the first trial or before it was overwritten. When was it overwritten, Judge? Is the record clear about that? When exactly was it overwritten? When? Because that would be helpful to know, wouldn't it? We don't actually know when it was overwritten. We don't know if it was only overwritten after the defense's expert, I think it was Matt Nodell, showed up at the Canton Police Department to do the extraction that was supposed to have been available, and only then learned, oh, it's on a 30-day overwrite. Oh, and by the way, all of the activity logs, yeah, they're also unavailable. Those shouldn't be overwritten. It's the whole reason you have an activity log. Was it then? Because I'm pretty sure that's after they requested that the metadata be preserved, turned over. A little timeline would be helpful, wouldn't it? No, according to Judge Cannoni, in that respect, the record is not unclear. Before it was overwritten, I'd say that's not established. That is not established by the evidence. The defense certainly did not concede that. And so that's a fact that required an evidentiary hearing. There is nothing in the version of Rule 14 then in effect, or the current version, that entitles the defendant to the metadata or log files underpinning surveillance footage in the possession of the Commonwealth, and the defendant has not directed this court to any authority suggesting preservation of such evidence is required. Nor has the defendant demonstrated that the metadata would have been exculpatory evidence. This is the classic catch-22 with Brady. You catch them sitting on something or destroying something. They get rid of something. And now suddenly you have the burden of proving what that was and how it would have helped your case because of the fact that they destroyed it. You can't do that. It's a wild standard. It's a wild standard. This whole harmless error issue. If they successfully destroy it, you will never win a Brady claim because you will never be able to prove what it was and what the impact would have been. Isn't that nuts? Wild incentives. She offers no evidentiary support for her argument that the metadata would confirm her theory that members of the CPD or state police doctored the footage to prevent jurors from seeing the condition of the defendant's taillight before it was within the custody of law enforcement and from seeing proctor damage to taillight. Yeah, because the Commonwealth destroyed it and didn't turn it over. That's why. That's why she can't make that specific showing, because they destroyed it. A defendant who seeks relief from the loss or destruction of potentially exculpatory evidence has the initial burden to establish a reasonable possibility based on concrete evidence rather than a fertile imagination that access to the evidence would have produced evidence favorable to his cause. That's some nice language there. Isn't that nice language? Reasonable possibility based on concrete evidence rather than a fertile imagination. What concrete evidence do we have here? We have all of the different stories about the provenance of the video, what they did with it. We have the problems with the timing on the 30-day overwrite. When exactly did that start? We have the problems with the log being deleted when there's no reasonable explanation for why that would happen, other than trying to conceal something about who accessed the system and when. We have the late piecemeal disclosure of bit by bit of this information. We have the misrepresentation of the evidence in court. Oh, and by the way, that's on top of just the shady, on its face quality of this evidence with the 43 missing minutes and the ghost apparitions in the Sally Port that are explained as because it's motion activated and yet it's flickering in and out while people are in movement and apparently recording in 6-hour chunks, regardless of whether people are there moving around or not. That's the evidence. That's the evidence. Doesn't take a fertile imagination to conclude. Yeah, I'd say there's a reasonable possibility that the reason why it looks like they're scrambling to hide something here is because they were scrambling to hide something here. Doesn't take a very fertile imagination to see that. But I guess if there's one thing we cannot accuse Judge Cannoni of, it's of having a fertile imagination when it comes to the defense case. That is, the defendant must establish a reasonable possibility. Yes, no, this is not a probability. This is not a more likely than not. This is just a like, hey, decent chance of this based on the evidence. Yeah. Based on the evidence, the reason why it looks like there's something to hide here is maybe because there's something to hide here. That standard is met. Lastly, as to this claim, to the extent that a defendant claims to have rights based on the Commonwealth's handling of metadata, she'll have the opportunity to seek redress in the context of the retrial. Well, you haven't ruled on her motion yet. Ms. Little brought that up specifically at the end of the last hearing. By the way, Judge, you still haven't ruled on this one yet. That one's been outstanding for a while. And when it comes to priorities and what needs to be done before the trial gets started, things that relate to discovery and production should really probably be on the top of the list, because that's the type of thing that can influence who you call, how long your case is going to take, whether there's going to be delays while this is being sorted out. Hypothetically, If Proctor is the very first witness that the Commonwealth calls, and you haven't dealt with this yet, you're putting us at a risk that you're going to have to delay things so that they can get access to this and be prepared to use it when they're cross-examining the guy in whose custody it was. The guy who appears to be pictured near that passenger side taillight in the Sallyport. Yeah, that guy. Probably going to want the metadata and time to analyze it and what it shows. Compare that to the exhibits that are presented at trial and their metadata. See what you learn from that. Still hasn't ruled on it. She'll have the opportunity to seek redress. Yeah, if you do your job, she will. But you're not in any hurry to do it, are you? Terrible, terrible decision on the Sallyport video. Just in so many respects, the minimization, the bad characterizations, just the double standard, the no harm, no foul. Well, they didn't convict her yet, so you get another try. No penalty at all, no consequence at all, no disincentive at all to not just keep doing exactly the same thing over and over and over. I can try to make this a little bigger if that will help. Does that? Yeah, I think that works a little bit better. Withholding of exculpatory statement by Jen McCabe. So first, the factual background. Defense produced reciprocal discovery to the Commonwealth regarding the location information of Jen McCabe's cell phone. Yeah, they had to produce their rebuttal evidence, which is not standard, not the norm. Now, I don't know about Massachusetts. Definitely not the norm in my jurisdiction. Location data showed that on January 30th, the very next day, McCabe went to the home of Canton Police Sergeant Michael Lank, who was one of the first police officers to arrive at the scene on the morning of January 29th, 2022. So, during the trial, okay, because remember, it was during the trial that the defense produced this. So in anticipation, while they're prepping her, the Commonwealth met with her. Lally, ADA McLaughlin, and Massachusetts State Police Lieutenant Brian Tolley were present. Who else was present? Judge, is the record clear on that? Is the record clear on that? I'm not real sure that it is. Not real sure that it is, because pretty sure Jen testified that Allie was there. But then Tolley's report says that Matt was there. So were there two meetings or somebody mistaken about that? It'd be nice if we had a clear record about that, wouldn't it? Nah, I guess it doesn't matter. Tolley asked McCabe why her cell phone would have been in the area of Lank's house on January 30th. McCabe said she was with Carrie Roberts, who was picking up her daughter at the residence, and she did not speak with Lank while there. The Commonwealth did not turn over the substance of this conversation to the defense prior to McCabe taking the witness stand. Tolley wrote a brief report on the meeting, but it was not produced to the defense until May 29th. So, continuing to interview their witness, getting more statements from their witness that they anticipate eliciting at trial. Do they reciprocal discover that to the defense? No, they don't. They don't. They play the sandbag game. Oh, she's going to call him out on that, isn't she? Yeah, let's see. Didn't even produce Tolley's report until we're like almost at the end of trial. On May 21st, 2024 now, so we got this right. 2 weeks before is when they produced it. So 2 weeks later, they've already had time to set this up. Attorney Jackson cross-examined McCabe on behalf of the defense. He asked McCabe if anything significant happened on January 30th, and she explained that she went to Lank's house with Roberts to drop off Roberts' daughter, and Lank's wife came out of the house to talk to them. Jackson questioned McCabe as to why she did not report the fact. Bring up the next page. That she had met with one of the first responding officers on the case. Further questioned her on the length of the conversation, who else she talked to, where she was during the conversation, and if she went in the house. So remember, picking up the daughter, dropping off the daughter. Stories changing apparently only matters if you're a defendant and you use slightly different words or provide slightly more detail, in a subsequent version than in an initial version. I guess if you're just a witness describing why you were at the responding officer's house, the guy that showed up to interview people, why you're at his house the next day, change in that story doesn't really matter. During cross-examination, Jackson also questioned McCabe about the details of her discussions with Lally, McLaughlin, and Tully about her trip to Lank's house. She testified that when Tully asked her if she went to Lank's house on January 30th, at first I said, no, I've never been to his house. Then I thought about it and said, oh my gosh, yes, I did go there. And that was the extent of the conversation. On June 18th, 2024, after the defense had received Tully's report of his meeting with McCabe, Jackson raised the issue of the Commonwealth's failure to disclose McCabe's statements during the meeting prior to her testimony. During trial, they interviewed her, apparently had a full interview with her. Tully took a report, dated the report. The Commonwealth held onto that report until after she testified. The interview, the report, and the completion of her report were all done before her testimony. Yeah, that's what happened. The court offered to allow Jackson to call McCabe back to the witness stand, and Jackson declined, stating, no, Your Honor, that's not and I think the court understands. That's not my point. My point is not that I need to call Jennifer McCabe back. I've done the damage that needs to be done. I don't need to call her back. He did have the opportunity. He did. After he had the report, he did have the opportunity and he did decline it. It's not a good fact for the defense. Defense argues that in violation of Brady and Rule 14, the Commonwealth withheld the May 10th, 2024 false statement given by McCabe to Tully regarding her visit to Lank's house, which the defendant claims she could have used to impeach McCabe. Yes, it's impeachment. It's a prior inconsistent statement. She said something different. You may not think it's that material, but it's a change in the story. And with a witness who, set some kind of record for being squirrely on the stand, not wanting to be pinned down on things. Show me what I said before I answer any questions about it, that type of thing. Yeah, could have mattered. The version of Rule 14 then, in effect, required that the statements of persons the party intends to call as witnesses are subject to automatic discovery. The Commonwealth, therefore, should have provided McCabe's statement to the defendant after meeting with her and certainly before her testimony. Wow. She actually acknowledged that they should have done that. She won't go as far as to saying they violated the rule. Therefore, they violated the rule. They withheld it. No sanction for it. Just they should have. Would have been better if they did. However, the defendant cannot reasonably claim that she suffered any prejudice. Once again, he had the opportunity. He expressed satisfaction with the damage he believed he had inflicted. We're overlooking the entire issue here of the prepping of the witness and the sandbagging. The fact that they took the evidence, they discussed it with the witness before she testified, they prepped her on it. How are you going to deal with this? Oh, yeah, I totally forgot about. I'd never been there, but I just didn't remember. Wasn't she telling us about like how she'd never forget? You know, this is burned into her memory because of the shock and horror. No prejudice. They should have done it. I'm not going to go so far as to say they did in fact violate the rules. But, and you know, Brady, the whole Brady thing, it is impeachment. Brady material, you withheld it. I'm not going to go through that analysis and make those findings on the record. Just, yeah, they should have. Would have been nice if they did. Remedy for discovery violations. As noted repeatedly herein, the defendant has not demonstrated that she suffered any actual prejudice based on the Commonwealth's late disclosure or failure to disclose evidence before the first trial. Yeah, because you're going to apply the standard of, since the Commonwealth didn't convict her, there's no harm for them playing foul. No foul is going to be called because they didn't successfully convict her. However, even if the defendant were able to show prejudice, dismissal would not be the appropriate remedy under the circumstances of this case, where there was a mistrial and the defendant now has the, let me get to the next pages. Wait, am I in the right spot here? I think I am. Now has the evidence at issue prior to the second trial. She cannot show she suffered irremediable harm to her opportunity to obtain a fair trial. Well, the first time, yeah, she did. You're just saying this is good enough. The fact that they didn't convict her. So we'll just keep giving them bites at the apple, no matter how foul they play. That's good enough. Too drastic a remedy if the error can be remedied and the defendant can still obtain a fair trial. Indeed, even in cases where the withholding of evidence is brought to light after a conviction, the remedy is most often a new trial, not dismissal of the charges. Yeah. Yeah. But when it gets to the level of destroying evidence, deliberate withholdings, futzing about with stuff, that's a little bit deeper than we just forgot to turn this one thing over and it might have been helpful. And that's why you have the sanction, because at some point there have to be consequences if you're going to disincentivize this type of behavior by prosecutors. But she's not even going to say they did anything wrong. Oh, they could have done better. That's as far as she's going to go. It's unbelievable. Nor has the defendant shown that the Commonwealth's conduct was so egregious, deliberate, and intentional that prejudice should be presumed. Such a theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. The facts before the court, well, which facts, Judge? Because it sounds like the record is quite unclear as to some of the material ones that relate to this specific issue. Like when the 30-day override happened, when and where these different videos were, how they managed to come up with them. Record's unclear about that stuff. And you had absolutely no curiosity about getting that sorted out. The facts before the court do not depict a concerted and intentional attempt by the prosecution team to deprive the defendant of discovery, which would have aided her case, really, because quite a lot of evidence of that we've already gone through. The missing logs, the 43 minutes, the sketchy videos, the misleading about the video being inverted, the trickling in of the production, the inconsistent explanations, for how this video was obtained, the quality of it, where it was stored, in what format it was stored, etc. Quite a lot of evidence of some really, really squirrely behavior. Even if the defendant were able to show that the conduct at issue here on the part of members of the prosecution team was intentional, the remedy would be new trial with the timely disclosure of the evidence, not dismissal. Well, no, because you just cited all this case law, right? You just cited this one. That if the misconduct is really bad, if it's really bad, you have to impose a stronger sanction as a deterrent. And so if the Commonwealth did, in fact, and let's not forget, the investigating officers are members of the prosecution team for purposes of Brady. They're an arm of the Commonwealth. So if they did, in fact, go in and delete the 43 minutes of the Sally Port video where the taillight would be visible, if they did, in fact, start overwriting the 30-day overwrite only when they knew the defense was going to be coming in to ask questions, if they did selectively hand out little pieces of it in drips and drabs to conceal the full scope of what they had, if they did alter any of these videos in a misrepresenting way to try to make them show something that's not there, if they did all of those things, is dismissal warranted? Fuck yes. And it's not even close. It's not even close. What an absolute ridiculous conclusory statement here. Even if it was intentional, the remedy would be a new trial? No. When they're falsifying evidence and destroying evidence, that's when you dismiss. That's when you dismiss. See? Misconduct is catch such doubt as to poison the entire investigation. Yeah, if they're out deleting the stuff that makes them look bad, that goes against their case. Yeah, that's when you dismiss. In this case, defendant's right to the disclosure of evidence pursuant to Brady and the rules of criminal procedure are fully protected because no verdict was returned at the conclusion of the first trial and a retrial is about to start. She suffered no irremediable loss of any constitutional right, and her motion for dismissal on these grounds must be denied. Conclusory. It's just conclusory. This is Bev adopting the Ipsy Dixit now. The remedy wouldn't be dismissal because I said so. Even if they did it all. Even if they did it all, I'm not dismissing the case. She's telling us outright. Even if they did it all, she's not dismissing the case. We all knew that that's what the outcome was going to be. But, you know, how underhanded and two-faced about it she was going to be. The one face towards the defense activity, the other face towards the Commonwealth activity. I gave her too much credit, thinking that she would do a better opinion than this. This, I think, is why. This is why she got her back up. A judge who is strategic and cold about it, rational about it, maybe not emotional about it. If there's something that they're really touchy about, maybe they think they might have got this thing wrong. It's a little bit of a sensitive issue. One of the ways that you avoid getting there is you decide the case on one of the other issues. I'll give you an example. I had a case on appeal. It was back in the day when we had this judge on the Division III Court of Appeals up in Spokane, where I routinely practiced, who was very much a prosecutor in a robe, complete prosecutor in a robe. You do not get defense rulings from this judge unless you can kind of navigate him into having to do it. So I had this case where a guy was charged for giving false information to a law enforcement officer, giving basically it wasn't even a bad name. Like, he gave his true information. The story was he was caught with a syringe, caught with like a loaded syringe in a gas station. And he claimed that it was his testosterone that he had a prescription for. And so somehow the police got a hold of the guy's prescription. Okay, how this is not a big HIPAA problem, don't ask me, but HIPAA doesn't affect admissibility at trial. It just gives you a civil right of action, I guess. Apparently, the doctor is only too willing to tell law enforcement that his prescription had expired like a couple weeks before. I am very long ago. It's a very, very thin case. So then based on this, they arrest him for that. They search him, incident to arrest, and they find he's got drugs on him. It's a relatively petty type of case. But it went up on appeal, and I argued a few different things. And one of the things that I argued was that Washington's statute for criminalizing false statements, it's actually false statements to a public official. It violates the Constitution. It violates the First Amendment. Talked about many times, if you're going to restrict speech based on its content, you have to either have an established exception to the First Amendment, one of the things like the incitement, the fighting words, defamation, so forth, or you have to have a clearly established government interest, and what you're doing here has to be narrowly tailored. It cannot be, catch up too much speech. It can't, not catch the right people. It has to be very specifically tailored to the harm that you're trying to avoid. I maintain to this day there is a very, very strong First Amendment challenge to Washington statute, because first off, false statements are not prohibited by law. There's actually a U.S. Supreme Court case, U.S. versus Alvarez, where they come pretty close to saying pretty clearly that just saying false things is not a constitutional problem. But we could grant that there's a government interest in discouraging people from lying to the police. The problem is that the way that the statute is written in Washington, it applies to lots more than police. It applies to any public official. It applies to things that are, just misleading, not necessarily, flat out false. Like there's a lot of issues with it that would make it both over-inclusive and under-inclusive. And I maintain to this day that's a very viable challenge. And the reason why I say that is because rather than decide my case on this issue, the judge decided, I'll just say they didn't have probable cause to arrest the guy, because no reasonable police officer would rely on that statement. The accused's representation under this circumstance. No reasonable officer would rely on it. Therefore, there wasn't probable cause to arrest him. Well, that's a reach. I mean, that's a reach. The probable cause standard is a very low bar. And of course, the cops arrest people all the time for statements they make during an arrest. People give a false name, etc. You run and check it. They gave you false information. They charge, they'll charge you. They'll charge you for that. They do it all the time. But that was the easier pathway to deal with my case, because if you cleared that hurdle and said, yeah, police had probable cause to arrest, everything up to that point was fine, now you got to engage with my constitutional challenge. And you really didn't want to do that. You didn't want to do that. So you just give them a smaller bone. That's the way to get around issues that you don't necessarily want to engage with as a judge. So the easy solution here would have been, go ahead and grant them some relief on, Proctor. He's been a great scapegoat. He's going to continue to be the scapegoat. I bet we hear a lot about Proctor as a scapegoat in this upcoming trial, because they're going to try to contain the damage. They're going to try to limit the conclusions that can be reached about how dirty this entire town is by just laying it all at Michael Proctor's feet. He's an easy scapegoat at this point in time. He's already getting impeached. We all already know that. So the more we can make his fault, the more we can try to preserve the shine of the other witnesses. So it would have been really easy to grant the motion just on Proctor and his own activity. And then we're done. We're done. We don't have to deal with this issue that she is really touchy about. So let's look at it. During trial, 2 issues arose with jurors. The first occurred on June 14, 2024, when one juror, Juror A, reported to the court that another juror, Juror B, had made some comments about the evidence and the defendant. The court has omitted identifying information about the jurors. It's not necessary. Now, as I recall, it was not just Juror A that made this report. It was 4 jurors, I believe. It was not just Juror A that made this report. Multiple people reported it. The court called Juror B to sidebar and questioned her about what she had said and if she could keep an open mind and consider the evidence in a fair and impartial manner. Despite her representations that she could, the defense expressed concern that the comments had been one-sided and against the defense and asked that Juror B be excused. The court then inquired of Juror A, one of the ones who made the report. Juror A stated that Juror B had made comments to her about the defendant's facial expressions during the trial. The court then questioned 2 other jurors whom Juror A said was sitting close by. Both jurors stated they had not heard what Juror B said directly, but that Juror A had mentioned it to them. The court then called back Juror B, who denied making any negative comments. About the defendant. After questioning the jurors, the court consulted with counsel. The Commonwealth expressed that if the court struck Juror B, it should also strike Juror A. No basis for that. No basis for that. Why would Juror A be stricken for doing what you are supposed to do and calling potential misconduct to the attention of the court? The court defense disagreed as to Juror A. Yeah, of course they did, because it's not appropriate. And the court ultimately decided to dismiss just Juror B from the jury. Handled it correctly there so far. On June 25th, 2024, just before closing arguments were scheduled to take place, the court received information from court security about another issue involving Juror A. A member of the Massachusetts State Police had contacted court security and said that he received information. Okay, we see the telephone game now being laid out right here in this decision. Court received it from court security. Court security got it from MSP. MSP got it from where? I don't know. The record seems to be unclear on that point about where the Massachusetts state trooper got that information. That a juror thought to be Juror A was at one of the local posts for the American Legion talking about the case and that there may be a recording of her doing so. Oh, where is this recording? Is there or is there not? There may be is not evidence. It exists or it doesn't. Would be nice if the record were a little clearer on the point of whether there was video. At roll call for the Dedham Police on the morning of June 25th, 2024, a number of officers confirmed that they had heard similar things about the juror. Where did they hear them? Where did they hear them? So far, we've got court, got it from security, got it from MSP, got it from somebody else. And simultaneously, Dedham Police are also getting it from who knows where. We have no attribution for this claim at all. None. None. We have no investigation. We have no substantiation. There may be a recording, but apparently nothing anybody bothered to get or secure. So we have an unattributed claim of juror misconduct. The court called a sidebar to discuss this new information with attorneys. Defense counsel asked for the name of the Massachusetts State Police officer who had received the information. A court officer stated it was Lieutenant Fanning. He's a supervisor in the detective unit during the investigation. He was Proctor's supervisor, one of the recipients of the group texts circulated by Proctor that included reference to looking for nudes on the defendant's cell phone, as well as a reference to defense counsel's retarded client's phone. Defense counsel represents, and for purposes of this motion, the court accepts that Fanning also interviewed some witnesses in the case. Fanning was not himself a witness at the trial. Pretty sure he was on the list, though. They just didn't call him, but I'm pretty sure he was on the list. I could be misremembering that. After explaining to the attorneys the situation, the court called juror A to sidebar. The following exchange occurred. Now, these are, I'm going to assume, from the transcript, and we already have some cause to be a little bit skeptical of the transcript, because we've already seen a situation where the defense had to cite to the YouTube stream, the video stream, to capture a statement that was made that was not included in the transcript. That's not supposed to happen. That's definitely not the standards for how transcripts are supposed to be prepared. But when you have a sidebar, you don't have any other record. Unless they got an FTR recording going on in there while they are also doing the live reporting. Maybe they do. Maybe they do. But just bear that in mind. This sidebar, presumably from the transcript, we've already had reasons to question the transcript. The court, it's been brought to my attention that you might have been out recently at an American Legions or a Knights of Columbus or someplace like that in Dedham, and someone has reported that you may have been recorded talking about this case. That's the information I received. What can you tell me about any of that? I don't know. Yeah, I wouldn't know either. When you're saying you might have been somewhere and you might be recorded saying something, how am I supposed to know what you're talking about? You don't know because you haven't bothered to substantiate or even get attribution for these claims that have been brought to your attention. It might help the juror know what you're talking about if you, in fact, know what you're talking about. That a specific person made a specific claim based on their personal knowledge of what they witnessed, and not just there's this unattributed information that's floating around in all of these different sources. The court, have you been at an American Legion Hall? The juror, like a month ago. Okay, at the time, were you at all talking about, not that I remember? No, that's a denial. That's a denial. Not that I remember. No, I was not talking about the case. No. Do you remember if people there mentioned to you anything about this case? I was drinking. I don't remember. I don't know what somebody might have thought that they said to me. Maybe I wasn't paying attention. Maybe they were saying something over there and it was near me, but I'm focused on something else. I didn't hear it. I don't know. Okay, the further information I have is that this morning, several Dedham police officers said that they heard the same thing. The juror, okay, people are reporting a rumor. All right, could it have happened? The juror, I don't know. The court, okay. The juror, I really don't know. I don't know what you're talking about. They heard the same thing, that at some point you were somewhere talking about the case. I don't know what you're talking about. Maybe before the trial? I don't know what I supposedly said that would lead them to think I was talking about the case. I don't know what I'm supposed to have overheard. I don't know. This is all pretty reasonable. But the specific allegation here that goes to the heart of whether there was juror misconduct, jurors are instructed not to discuss the case with anybody. You violate that rule, that is juror misconduct. That's grounds for you to be removed. That specific question, no. Denial. I did not violate the order of the court. Court asked the juror to step aside and then discuss the matter with the attorneys. The Commonwealth expressed concern that the juror had been involved in the previous issue and requested that the juror be excused. Commonwealth expressed concern that the juror had brought up good reasons, what were accepted as good reasons for getting rid of another juror, misconduct. That should be a reason to get rid of this juror too. It's unbelievable to me, the arguments that came out of this Commonwealth that she not only entertained, she praised them for. Such a good argument you made about how her calling an attorney is maybe a evidence of consciousness of guilt. Not in the American legal system, that's not a good argument. Any more than suggesting a juror should be excused for drawing misconduct, substantiated misconduct, to the attention of the court. Not a good argument. Defense objected, arguing that the previous incident was unrelated. I suspect their argument might have had a little bit of a different characterization than she's putting on it. Focusing on the instant incident, the court conveyed a concern that the juror did not deny the incident, except for the part where she did, but instead stated she had been drinking. No. When she asked if you remember if people there mentioned to you anything about this case, that's when she said, I was drinking. I don't remember. I don't know what I'm supposed to have overheard. The defense responded that the court should consider that no other juror had been affected and that the source of the information was a Massachusetts State Police officer. Therefore, a discussion about Lieutenant Fanning ensued, with the defense counsel suggesting that Fanning and the MSP may be targeting potential jurors for the purpose of trying to get them excluded from the jury. Court allowed defense counsel to make its argument about why the court should not dismiss the juror. Again, none of this is in the transcript. We're just have to accept her characterization of it because for some reason we're not being allowed to see the sidebar transcripts. For some reason that's impounded, even though it's a record of a public trial. ADA McLaughlin then explained to the court and defense counsel Lieutenant Fanning's role. He's the commander of the extensive security operations. He received the information. He did not investigate. He had no evidence. If he did investigate, that could have been considered improper influence. What he did is reported it to the chief of the trial court security to make the trial court aware it is as yeah, it's your job to follow up on this, to get it substantiated, attributed clear enough that you can actually ask the juror something meaningful about it. Commonwealth then made its argument why the court should dismiss juror A. Court then conveyed its decision. I believe there is credible evidence that this juror has had conversation about the case. There's no evidence. You didn't take any evidence. You have unattributed gossip that has been relayed to you like fourth hand. You have the juror explicitly saying, no, I didn't talk about the case at the American Legion, whatever the hell you're talking about. And I don't know what all these other things are that you're asking me about because I don't know what people's perceptions are, what the claims are. And you don't know either because you didn't do any of that. She did not deny it. She did. It's up there in the transcript. No. I find that there has been a violation of the court order for failure to report it. On a repeated basis, on a repeated basis? Is this based on that every morning when they come in, they ask, she would ask them, have you, had any improper, her list of questions that she went through. I guess that's what they're saying. She didn't report it. Well, that's because she denied that it happened. You're saying she didn't, but she did. It's right there in the transcript. Juror A had no problem reporting the other juror, but then at the time also did not tell us that she spoke to the other two jurors I inquired of. You said she said they were there, and that's how you talked to them at all. You didn't find them out through some other type of investigation. She told you. She told us they may have overheard, and then it was another juror identified by seat number who ultimately told us that this juror had reported to her what the other juror had said. Juror A may not remember whether she spoke about this case, but I wouldn't be surprised if she remained as a juror, if we did hear from somebody who was at the VFW that night after all of this. It's not your job to speculate on what might happen. It's your job to make a record supporting your decisions. You don't predictively remove somebody from the jury. You do your job now. You get the information now. And it's really easy to do. Where do you start? You put Lieutenant Fanning on the stand and you ask him, who told you this information? What specifically did they tell you? And then you follow up on that until you find somebody who's willing to give you an original source, somebody with firsthand knowledge. Then you get that person on the stand and you make the record. Oh, you were at, now it's the VFW. She can't even remember where we're talking about. No wonder the juror doesn't know what she's talking about. She's at the American Legion Hall. That was the accusation. I wouldn't be surprised. You should have had that person on the stand already. That's your responsibility as the judge. And then you would know, I saw this, I heard it, here's what it was based on. Now you have evidence. Now you have evidence that you can find credible or not credible and weigh that against the explanation that you have gotten from this other juror. And frankly, you're in a better position to be able to clarify with the juror what it is that you're talking about. Because you don't even know. You don't even know where. Minutes later, you don't even know where you're talking about still. You just think probably there would be a record at some point if I don't remove the juror. It's unbelievable. Unbelievable abdication of her responsibility to base a finding of misconduct, which is what this is, find that there has been a violation of the court order. That's misconduct. Based on nothing. No evidence. Juror denied it. Third-hand gossip. Once again, she didn't want to know. If you put Trooper Fanning on the stand and you make him give up the name, if it turns out there is no name and this has all just been circling in the ether and you follow it back around and it ends up being a circle because Dedham heard it from Fanning, for example, and Fanning heard it from somebody else and that person says he heard it from Dedham police, just for example, gossip goes in a circular pattern. Now we have a record that they're kind of making shit up, don't we? And she doesn't want to know that. She doesn't want to know that. That's why she doesn't put them on the stand. So this is a huge mistake from my perspective. This is an issue. I've been starting to go down this rabbit hole too. Got a little distracted in Vegas, so I still have to finish it. But I want to put something out on Substack because this is not how easy it should be to remove a sworn juror. The right to a jury trial encompasses the right to be tried by the jury that you have selected. That's part of the whole nature of the double jeopardy and the reason why that exists. That's why it attaches once the jury is impaneled, because you're entitled to that jury. There's a constitutional magnitude to this type of right. So to just be able to dismiss a juror because I think there was some gossip that might be true, and I wouldn't be surprised if it turns out to be true. I do not see a universe where that meets the legal standard. So I want to do some more digging into the Massachusetts legal standard and see exactly what it is for removing a seated juror. So I have a very hard time believing that this is going to pass muster. So Moore McLaughlin, I said that he's Fanning as the lieutenant commander. That's been his role, and not for the jury, for trial support and security. So this is really what she's pissed off about. She's pissed off about the defense putting Fanning on the spot, and the fact that once again she failed to ask the questions that needed to be asked of Lieutenant Fanning. She needed to ask hard questions. She didn't want to, so she didn't. So she cut a corner. And it's a corner that may very well come back to bite her. Because she didn't have a factual basis for any of it. And the juror denied it. It's there in the record. Said no. Time to switch to my tea now. Argument. She's entitled to trial by an impartial jury. Yes, she does. She argues that her Sixth Amendment and Article 12 rights have been violated by the court's dismissal of juror A. Constitutional magnitude. According to the defendant, the court's dismissal of this juror was improperly based on the juror's views of the case. Well, it might have been, or it might have just been baseless. Specifically, the defendant contends that juror A appeared sympathetic to the defense, and therefore the MSP, who have an interest in the defendant being convicted, targeted the juror to get her dismissed before deliberations. Yeah, we don't know where this rumor originated, do we? Because we never clarified the record on that point. The defendant also argues that the court failed to employ the proper process before dismissing the juror. These arguments have no basis in fact or law. Well, we shall see about that, because I'm definitely not taking her word for what the law is in the state of Massachusetts. The defendant's first argument relies on a significant claim to clairvoyance about juror A's sympathies at the time of the sidebar conference. Here we are with the straw manning. You can't deal with the defense's argument as they've made it. So you've got to try to characterize it in this frivolous kind of way. No, it does not require clairvoyance. The issue is what might have been perceived based on observations from the courtroom. It doesn't matter if she actually was sympathetic to Karen Reed or not. The issue is, might MSP have thought she was and targeted her because of that? That requires no clairvoyance. It's premised on unsubstantiated claims regarding Fanning's involvement with the jury. Okay, they may have raised some questions about exactly what his role was. Why did this information go to him? How does the courthouse security interplay specifically with the trial security? Because surely there's coordination between them. How's that happening? I don't know. The record is unclear. It's just very unclear on that point. Despite being specifically informed, ipsy dixit, I said so, therefore it is, that Fanning was not in charge of security for the jury, and without providing any evidence that Fanning ever interacted with any member of the jury, defense counsel repeatedly claims, without any evidentiary support throughout their memorandum in support of the present Hang on here. Why does it not want to share this now? I just lost it for some reason. Oh, Lord. And now I got to try to find which one it is. Give me a second here. Sorry, this is, and you got a million tabs open. It gets a little trickier to navigate. So I'm going to just go through and close a bunch of the ones we've already looked at. Okay. The motion that Fanning, they repeated throughout their motion that Fanning was commander of jury security or in charge of jury security and had access to and control over the jury at the first trial. In fact, as made clear to defense counsel at the sidebar, Fanning was a commander of security operations during the trial and not in charge of the jury. We got a footnote here. Couple of them, actually. Defense argued in the hearing on this motion that it is reasonable to assume that Fanning had access to the jury because he apparently knew or became aware that the person involved in the incident at the American Legion Post was a juror in the Reed trial. In fact, this is the very opposite of a reasonable assumption. That's it. Ipsy Dixit. In fact, because I say so. Reasonable question. How did the information make it to Fanning, to court security, to the judge, based on whose knowledge? And how would that person, some random person who's sitting in the AFW, is not, or the American Legion, see, we don't even know where we are now. In the American Legion Hall is, how are they going to know that this person's a juror or what they're talking about? If we had a record, we would know what the basis of their knowledge was. But we don't have that record. So how do we know what Fanning knew, whether this was valid or whether to bother court security with it at all? It's certainly a possibility. Certainly a possibility. He had access to the jury. There had to be some coordination. Sorry, I'm not buying that the total courthouse security that he's in charge of is somehow completely independent and separate from the security for the jury. When they need to come and go from the courtroom, where they're going to be, how long it's going to take, what door they're going to use, et cetera, that's coordinated with the rest of the security. It would have to be. But we don't have a record about any of that. Then defense counsel submitted an incomplete transcript of the June 25th sidebar discussion, omitting the part where ADA McLaughlin states, in no uncertain terms, Lieutenant Fanning was a commander of security operations, not for the jury, but for trial support and security. She's using her footnotes now to try to chastise the defense once again for their arguments. Commonwealth, worst case scenario, they maybe should have done things differently. When we're talking about a frickin' Brady violation, maybe should have done that differently. Yeah, they maybe should have followed the due process requirements of not sandbagging, withholding the stuff that tends to exonerate the defendant. Yeah, maybe they shouldn't do that. Maybe there's a word for that. Maybe when you certify that you fulfilled your duties and you haven't, maybe there's a word for that too. But we wouldn't know, because the problem here is really the need to emphasize how much issue she takes with the defense making these arguments at all, and to try to keep them in line. Remember that contempt finding I made against you? Might want to rethink these arguments you're making from the facts. Fanning's role at the first trial related to the significant and unusual security concerns caused by large crowds to ensure the immediate defendant's right to a fair trial, free from outside influence. Court instituted a buffer zone. Massachusetts State Police, local police enforced the buffer zone. Fanning, a supervising officer, was one of the commanding officers outside of the courthouse. Now, once again, what's this based on? Is this based on the state's representations? And that's it, because you might remember that statements of the attorneys, they're not evidence. Yeah, they're not evidence. So that's not a basis to decide anything. I think the real problem here is that this is based on her own knowledge. She's just saying, I know this stuff because I was the administrative judge. I'm in charge of the courthouse. I needed to be familiar with all this stuff. That's my suspicion. She's saying, I know this. But she's not under oath either, is she? The trial court is responsible for jurors, court officers employed by the trial court, and only those officers are, quote, in charge of the jury. We don't need to be semantic about it. We don't need to put things in scare quotes. We don't. It's not necessary. Because if there's interaction between those, contact, opportunity to influence, observe, any of that, potentially problematic. The only people with, quote, access to the jury at the courthouse, but what about not at the courthouse? We just established Fanning's outside the courthouse. What about contact with them outside the courthouse? Well, while they're in the courthouse, the only people with access are the court officers of the trial court. Court officers have a sworn duty to watch over the jury. That responsibility was not and cannot be transferred to the Massachusetts State Police. No, but they can coordinate with the MSP, can't they? And they probably had to, didn't they? And you probably know that because you're basing all this on what you already know, what you believe the facts to be in the case. Thus, counsel's claim that Fanning was in charge of the jury and was directly involved in efforts to have one of the jurors dismissed is simply false. Well, maybe him being charge of the jury is not correct, but being directly involved in efforts to have one of the jurors dismissed is plainly true because he's the one that reported it to court security. So he's plainly directly involved in it. I don't know how you get around that. It is, of course, required that lawyers present only good faith arguments to the court under all circumstances, but the failure of counsel to take care with the truth of their assertions in this regard has particularly damaging consequences. Here we go. The only people that get chastised in this entire order over government misconduct that she acknowledges happened, just not going to do anything about it because it doesn't really matter because they didn't convict her. Didn't work. Maybe next time it'll work and then we don't have to worry about all this. Not them, the defense. The defense for arguing for their client. This case has generated substantial public interest locally and nationally to suggest without factual support that a Massachusetts State Police officer had influence over the court and the jury in the first trial is to invite unwarranted public speculation and distrust about the integrity of the Massachusetts judicial system. Seems to be taking this a little personally, doesn't she? Seems to be taking it a little personally. Do you not think we already had a lot of distrust for the MSP and for you yourself, Judge Cannoni? Did you not already realize that? Maybe you might realize that. Might be worth your while to have some insight into that. There's a reason why they moved to disqualify you, which I'm sure you haven't forgotten that either. How that stung. Touchy point, huh? That was a touchy point. It's already tainted by distrust of you and the MSP. That's a done deal. This is a drop in the bucket. It's been their own conduct, their own dishonesty, their own tolerance for what should not be tolerated in law enforcement officers, their willingness to make excuses. They're playing the game. That's the reason why we distrust them. And your unwillingness to hold them to account for any of it, to even acknowledge that there is reason to believe there's a problem here, yeah, that's why they don't trust you either. Has nothing to do with this. Okay? This is a symptom, not a cause. Think about that for a minute. It can also be seen as an improper attempt to influence potential jurors in advance of the retrial. Now she's got a fertile imagination, doesn't she? How is this an improper attempt to influence potential jurors? How? One, it's made in court. These are in court pleadings. These are not extrajudicial statements. These are made in the course of court proceedings. You don't think they're substantiated because they're not just taking your word for it. They want a record. And that's fair. It's fair for the defense to want there to be evidence on which to base court decisions. That's very fair. Thus, the court takes this opportunity to make clear that neither Fanning nor anyone else from the Massachusetts State Police interacted with members of the jury or influenced the court's decision to dismiss Juror A in any way. How do you know that? How do you know that? What are you basing that on? Ipsy Dixit. She says so. She says it didn't happen. Therefore, it didn't happen. That's all we need. Apparently. There's no record. Very imperial, this tone. I say this is how it happened. Therefore, you may ask no questions. You may not advocate to the contrary. Very, very alarming. While we're on the topic of distrust. When Fanning became aware of information regarding Juror A, he turned it over to the court officer assigned to the case because it was a matter to be dealt with solely by the trial court. Yeah, and then you failed to deal with it. You didn't deal with it. You didn't find out where the information came from, who the source was, what the actual information even was. You never found any of that out. You just took, there's this rumor that's floating around and treated it like it was fact. Defendant also argues the court failed to employ the proper process. The argument is based on an incorrect understanding of the law with respect to the process the court must undertake when presented with an issue as to a sitting juror. Let's see what her version of the law is, shall we? Because this is what I'm kind of going over and double checking a little bit. Judge has discretionary authority to dismiss a juror at any time in the best interests of justice. This is this one particular part of a very extended statute that's about hardship exemptions. Hardship. A little bit of a peculiar thing to hang your hat on as far as trying to establish you have total discretion to decide if a juror should be booted for misconduct. Pretty sure that's a different situation than, hey, the juror has had a hardship come up and needs to be let out in the interests of fairness. When there is an indication that a juror is unable to perform his or her duties, a judge may properly discharge that juror. An indication based on what exactly? How is that indication brought to the court's attention? Does it require evidence? Because typically it does. For the court to find things, usually needs to be a record. Usually needs to be a basis, factual basis. Where a judge has reasonable concern that a sitting juror cannot comply with a court order to not discuss the case, the judge, after individual voir dire, may dismiss the juror. See Commonwealth v. Hampton. Judge's decision to remove juror after jury had been sworn was not an abuse of discretion. Where a trial judge found that juror had violated court order that jurors were not to discuss the case with other jurors. I wonder if I look at Hampton and I look at the facts of that case, I wonder what kind of record there's going to be of this conduct. Wonder if it's just going to be gossip. Or I wonder if those judges will have brought in the jurors and questioned them about this activity. Can't wait to find out. When alerted that Juror A might have been talking about the case at a local American Legion post, the court explained the situation to the attorneys and then called the juror in for... I gotta find what page we're at now. Almost at the end of this motion. It has been rather painful for us to all go through. Questioning. Juror A did not deny that this occurred. Yes, Juror A did. Juror A said no. But rather stated she did not remember and that she was drinking. The court then heard argument from counsel. So she doesn't remember an unspecified thing, a generalized thing that you have no evidence ever took place. That's the record she is relying on. That the juror didn't deny something you have no evidence of. And that is a sufficient basis to remove a sworn juror to whom Karen has a constitutional right to decide her case by the jury she picked, barring extraordinary circumstances like misconduct. This is what you got, and you think you've got the understanding of the law? Yeah, I'm not so confident about that. And maybe that's the need for the tone, the overcompensation. Oh, you guys are idiots. You don't even know the law. Obviously, the law is this. While you're searching, you're reaching so hard for support that you're looking at the hardship statute to give you your authority. Yeah, she knows she's on thin ice. That's why she's so touchy here. In deciding to dismiss a juror, the court considered Juror A's equivocal answers to questions about the incident. What incident? What incident? Wasn't even established. You weren't even able to identify the when and the where. Or the what. The what was supposedly said, what was supposedly heard. None of it. What incident? As well as the fact that there was a previous incident involving Juror A during which she was not entirely forthcoming about her communication with other jurors about Juror B. She brought them to your attention. Not entirely forthcoming? She brought it to your attention. She's the one who let you know these other people. These other people were also potentially there. Thus, the court considered the American Legion Post incident to be a second failure by Juror A to comply with the court's order not to talk about the case. Based on the totality of these circumstances, the court decided in its discretion to dismiss the juror. It's a pretty weak basis. Pretty weak basis. Defense cites several cases in support of her argument that post-impanelment but pre-deliberation, if a judge is alerted to potential misconduct of or affecting jurors, the judge must first determine whether the material raises a serious question of possible prejudice. If she so determines, she must then hold a hearing to inquire further into the alleged misconduct. Based on the cited cases, the defendant argues that the court's questioning of Juror A was insufficient. The juror, however, misunderstands the law. The defendant misunderstands the law. Yeah. Is it the defendant that misunderstands it? Commonwealth versus Tennyson concerns information the judge received about a claim of extraneous influence on the jury, which the co-defendant's counsel raised after the jury had begun deliberations. So I guess that doesn't apply because of the timing. Not sure why the timing is critical here. It's a sworn juror. It's a sworn juror. The other cases cited by the Commonwealth also concern the potential discharge of a deliberating juror. Okay, why is this distinction material? Is there case law? Case law that you found that establishes? Let's go. General Law 234A, Section 39, which governs the dismissal or discharge of a juror. No. It talks about hardship. Draws a distinction in the process required for deliberating jurors and non-deliberating jurors. See, e.g., Section 39, the court shall have authority to excuse and discharge a juror participating in jury deliberations after a hearing only upon a finding of an emergency or other compelling reason. Yeah, because we're talking about hardships. So if it's before deliberation, you can just do it in the interest of justice. If it's after deliberation, got to have a little bit more of a stronger showing. That's the way the statute is set out. It's not setting out some fundamental difference for all purposes and all inquiries between deliberating and non-deliberating jurors. And with respect to for cause challenges, dismissals based on misconduct, what's the justification for distinguishing between them? What's the reason? A court who can't follow the court's order, that's a problem, no matter what stage of the process that you're at. It doesn't require a hearing if you're not deliberating. It doesn't even make any sense. It really doesn't even make any sense. Well, the defendant appears to recognize there is a difference between a juror who has been sworn in but is not yet deliberating and a deliberating juror. She confuses the distinction in her discussion of the law. No, it may be that the distinction doesn't matter in this context. You haven't provided me with authority to show me that it should. It should matter. That all of this case law that they've shown you that clearly established the deliberating juror engaged in misconduct needs to have a hearing. You haven't established any Massachusetts case law on point establishing it's a different standard to dismiss a juror for misconduct when they're not deliberating yet. See how that works? The employment, the strategic deployment of the law, right? The defense can't come up with it. It's because there is no law. When she can't come up with it, well, it's just because it's obvious and because this, statute that's talking about something else in a separate context suggests there might be a distinction for that purpose. You see how that works? Very, very outcome determinative. She confuses the distinction. Well, maybe she just thinks it doesn't matter because there's no case law that establishes that it does or why it should. Defendant also fails to cite any authority suggesting, as she contends, that the court was required to engage in an evidentiary hearing with Lieutenant Fanning before deciding whether to dismiss the juror. The court here called Juror A to sidebar to conduct an individual voir dire, heard from both defense counsel, and explained that the juror would be dismissed based on credible evidence that this juror had conversations about the case. There was no credible evidence. That's the entire point that she's deliberately refusing to see. There's no credible evidence. There's no evidence at all. There's no evidence. There is a report to the court from court security, from Fanning, from an unspecified source. Fourth hand, unsworn information is not evidence, let alone credible. That's the whole problem. Defendant was afforded all the procedural protection she was entitled to. Basically, as long as I ask you, that's her version, as long as I ask you what you want me to do, then That's it. That's all you're entitled to. Whether I actually do what the law requires me to do, that's not something for you to complain about. So I'm just going to share this tab out of relief that we didn't finally got to the end of that very painful ruling. Very hard to read that. It really is. Yeah. Boy, you want to talk about why the distrust for the court and the system that she's overseeing? Make this order Exhibit A, because this is why. This is why. The absolute refusal to even ask a hard question of the Massachusetts State Police or the prosecutors or the Canton Police. The absolute refusal to ask them any kinds of hard questions. The minimizing and bending over backwards to excuse their repeated ongoing violations of the rules when they have sworn under oath, certified that they have complied with the rules. How this bothers you not at all, but you'll take the opportunity to chastise the defense for advocating for their client because you didn't do your job and make a record. Yeah, Judge. Maybe that's why there's distrust. Maybe this right here is Exhibit A. You know, you want a judge to have some insight. You want them to have the capacity to learn and improve, because as we know, everybody makes mistakes. Everybody makes mistakes, including judges. And the only real sin in that is not learning from it and not being better as a result of it. So when you simply cannot acknowledge mistakes on your own part or the part of the prosecution team, it just doesn't speak well. Doesn't speak well of your qualities as a judge. Maybe she'll reflect on that someday. Maybe. I don't know. What do you think? Am I being overly optimistic? Oh, we've had a few more comments come in, so let's go ahead and check some of those out. Pro Gamer, in the suburbs, a dead, beaten, assaulted Boston PD on the lawn of another BPD. First thing, especially with dark house staying dark. First, cops will clear the house to verify the safety of the cop family living there. Duh. Yeah, you know, that's a good point. I hadn't really thought about that. The idea of a welfare check. The idea of a welfare check. I mean, the stage for how all of this was set was just it was so bizarre anyway. You know, first off, Jen McCabe, who is supposedly loves John. He was a dear friend. And yet when she calls 911, there's a man in the snow, unresponsive in the snow. Not, this is my good friend, not this is John O'Keefe, not this is the Boston police officer, not it's this guy that was out at the bar earlier with me and my friends, and he was supposed to come to this house for a party, but he never showed up. It's none of that. It's a man, an unresponsive man in the snow. So right off the bat, trying to kind of distance and de-emphasize who he is and what he's doing there, and certainly her connection with any of it. But yeah, the fact that this is a police officer and it's outside the front door of another police officer, this is a very good point. Wouldn't you want to check on the well-being of the other officers that you know to be there? Because you don't know if this person is targeted because they were an officer. And police can be a little paranoid about that kind of thing. I mean, geez, we even heard from Higgins about how so important he had to change his number once his informant that he gave his number to kept contacting him. I don't know, it was a weird story. It wasn't quite clear to me exactly how that went down. But yeah, security is very important. There's a reason why when she read that witness list, the law enforcement officers, she just identifies them by the department that they're from, not their community. So if you don't know Trooper David DeChico, I'm just using a hypothetical, making this up here, okay? If you don't know Trooper David DeChico because he works for Massachusetts State Police, but you know David DeChico because he lives in Sandwich where you live and you go to the same church, might not make the connection that it's the same guy, because they're not going to tell you where he lives. They're not going to tell you that. They get all kinds of this, operational security because of the fact that they're concerned that they might be targeted. So how would that not be right in your mind when you know, yeah, this is a Boston police officer that is dead out here on the yard, and there's other Boston police officers that are supposed to be inside that house, but you don't even go check on them? I think that's a very good point. Welfare check would be a not bad idea under these circumstances. Sky is a neighborhood. Serious Q, what is Lally doing / his role this time? Like I said, as far as I can tell, he's doing the Marshawn Lynch. I'm just here so I don't get fined. I don't know. I have no idea what he's there for. He hasn't done anything. He hasn't contributed anything. Like, the one thing he's done is added his electronic signature to Commonwealth pleadings, into that joint affidavit. Is he the institutional memory of the first trial? I don't know. Is he going to do any questioning? I don't know. I have no idea. As far as I can tell, his job is to sit there with the 1,000-yard stare, communicating to everybody with eyes how much he hates being there and doesn't want to be there, and is just there so he doesn't get fined. I guess we'll find out as things go on if there is any more to it than that. Kristen, wow, thank you. I didn't think about the other side. You are so smart. I just saw the jury interview and I was shocked. It seemed they had reasonable doubt, but didn't see it. Reasonable doubt is always a tough issue with the jurors. It's always tough. And that's why it's, something you have to be going into your trial already having an idea of what you think the reasonable doubt is and where the jury should be looking to find it, because you got to be hammering it home from the very outset. In voir dire, if you can, in your opening, certainly, here's the problems that you're going to need to focus on that are going to come up during this trial, and they're going to add up to reasonable doubt. That's why you're going to need to acquit her when everything is said and done. You then follow up on those commitments you made in your opening by showing them the problems in the evidence. And then you conclude by showing them you did it. Tell them you're going to do it, and tell them you did it. Pretty common strategy. Pretty common strategy. But yeah, the jury interview, I understand it's hard. It's hard for people to watch that. And knowing what we know about the evidence and about the standard and so forth, and what their job really is supposed to be. Their job is not supposed to be to solve the crime. No, it's not supposed to be to solve the crime. It's not supposed to be to choose between, is it the Commonwealth's version or the defense's version? Which one do I believe is true? That's not their job either. It is literally just, has the Commonwealth proven theirs beyond a reasonable doubt? Defense is giving you a possible alternative, but it's not the only one. And the issue isn't have they proven it. The issue is there enough there that it gives you doubt about whether she committed the crime? So from a standard of just understanding the law, yeah, it can be difficult to see stuff like that. But the reality is the jurors are going to do what they're going to do, and trying to kind of fight that reality, it just isn't helpful. It's really not. They're not attorneys. They're going to be acting, the way that they think they should, the way that they think is natural, the way that it occurs to them to generally problem solve, because it is ultimately a problem solving exercise. The question is just, how do you get them to narrowly focus on what the actual question is that they're being asked to answer? It's a very, very slippery slope to navigate. Pro Gamer, feds provided the evidence Karen is not guilty to the Commonwealth. Then feds just watch the Commonwealth continue prosecuting. I hope FBI is still watching how far the corrupt will go and how many they can catch. The feds have to have a federal crime that they can charge. And even if they did that, they don't have direct authority to come in and say you can't prosecute Karen. They don't have that decision. That's not within their jurisdiction. Yeah, if they came through and they charged some people, prosecutor, witness, law enforcement, whoever, with some type of crime, it's probably going to damage the Commonwealth's case, but not necessarily. Not necessarily. No guarantee the jury would even hear about it. How depressing is that? Till there's a conviction, no guarantee the jury would even hear about it. And I've talked before about how, if it's true that the federal investigation is concluded, which I'm still skeptical of. Sorry, I'm not taking Hank Brennan's word for it. I'm not taking Helena Rafferty's word for it. I'm not taking their word that even if they were told that what they were told was the truth. It doesn't have to be. You don't have to tell the targets of your investigation, if they are the targets of your investigation, the truth about the status of your investigation. You get to lie. You get to lie. Thank you, Fraser V. Cup. So yeah, I'm still skeptical about that. But even if it is true that the federal investigation is over, does that mean that's total vindication for everybody and they found no wrongdoing? It means they can't prove a federal crime. And what I've brought up before that is the problem in this particular context, when you're looking at corruption, it's establishing the benefit, the quid pro quo. If you don't have something fairly explicit, I'll do this for you if you do this for me, very, very difficult to make that case. And the problem that we seem to have in Canton, the appearance that we seem to have in Canton, is a systemic problem. Everybody is simply playing the game because they know what it is. They know what the rules are. They know there's no explicit guarantee that once I have your back, you'll have mine, but it's implicitly there. And so they already know what their job is once the circumstances present themselves. So being able to establish a federal corruption crime based on a good old boy club, that's tough. That's tough. And you might not get there. Does that mean this isn't happening and it isn't a problem? No. Does it mean it's not corrupt in the colloquial sense of the word? No, definitely not. Just means they can't establish the elements of the crime, or they don't think they can. So, yeah, I would like to think that the feds are still watching and paying attention. I don't know. Idiot Win, can defense appeal on issues where judge has denied their motions based on erroneous legal reasoning if they didn't point out difference in what cases stand for during trial, or is that waived? Okay, so typically, if they cite the case, they can rely on their citation for, pretty much all purposes. when an issue goes up on appeal, what they're really looking at is the nature of the argument that you raised. And so if your argument was, for example, you followed an improper process when you disqualified this juror, you didn't apply the standard that you needed to, to get evidence to justify a finding that warrants removal. That's the issue that has been preserved for purposes of appeal. So their basis, their arguments supporting that issue, you generally have some flexibility with. You're not limited to like just the cases that you raised during trial. You're not limited to just the portion of the case that you cited. Like, no, you raised the issue and you brought the law that supports the issue to the court's attention. You brought the facts to support the issue to the court's attention. That's all you're required to do to preserve it. So they have flexibility around the edges when it comes to things like using the case law. If she, doesn't follow it for some reason, that issue is still preserved. What they can't do is change the issue. They can't shift from you didn't have a proper basis for discharging the juror to, I don't know, you improperly relied on your own personal unsworn knowledge, your ex parte information about the case in deciding the issue. You decided that Trooper Fanning had no contact with the jury based on information that the parties weren't privy to and didn't have the opportunity to explore. You don't get to switch the issue to that. You got to raise that with the trial court, unless there's sometimes exceptions for certain issues that can be raised for the first time on appeal. Oh, that was a big yawn. I don't know if you guys heard that. Victor Man 7777. Can defense voir dire jurors about knowledge of police process and ask for reconsideration of Easter? Well, they can try. Is Judge Cannoni going to let them do that? I say that's maybe a $1 million question. I think this is kind of clever. I like the thought process. I've seen a few different suggestions now about how to respond to this. One of the ones that I liked very much was to ask every single law enforcement officer that testifies about the fuck ups and ask them, is the fact that this is a fuck up, is that the type of standard knowledge that any reasonable layperson would have? Use that language that she put in the order against them and go ahead and slap them with it a few times. Okay. Not only so the juror hears it, but the jury hears that this is so basic, so easy for anybody to understand that even a layperson gets it. Put them on the spot with it. I love this idea. Yeah. You want to talk about some rigorous cross-examination, Judge Cannoni? The issue with juror voir dire is that it tends to be a lot more circumscribed by the court. The court has a lot more power to limit it than she does limiting the scope of cross-examination. So asking the potential jurors, they can try, but there's no guarantee she's going to let them. They had to go through the whole vetting process with the questionnaire. It sounds like there are some kind of limits in place in the Commonwealth when it comes to the scope of exactly what attorneys get to ask about in voir dire. I don't know if this falls within that or not. So from a legal standpoint, I don't know your question. I don't know the answer to your question, but I think the bottom line is that not if Judge Cannoni has anything to do about it, because she's going to take it personally. She's going to take it personally. She's going to see it as the defense being snotty or something, instead of just literally making a record, doing their jobs to substantiate the error that they perceive that she has made. She takes that very, very personally. So no, I doubt she would allow it. Peggy Riordan, can the defense appeal this ruling to the SJC at this time? So they can ask for interlocutory review, for discretionary review. They do not have a right to it at this time. They can ask. The standard for interlocutory review, meaning deciding an appeal issue before the trial is concluded, is extremely high. And it's very, very unlikely to be met when you're talking about an evidentiary ruling. A couple reasons for that. One, because they're discretionary. Broad deference to the court has to be pretty crystal clear on the record that there's been an abuse of that discretion, that, you know, no reasonable judge would disagree with the idea that this is an error. It's a very, very tough standard. And because it's interlocutory, you typically have to show you need this to be able to have a fair trial. They don't like to make those kinds of determinations ahead of time. Like, their view is that appeal is an adequate remedy. Worry about it if you get convicted. If you don't get convicted, then it doesn't matter. It clearly didn't affect your ability to get a fair trial. So let the process play out and then decide if there's a problem with it. So it's extremely rare that interlocutory appeal gets granted at all, let alone over an evidentiary ruling. So because of that, I'd be really surprised if they did. They have better stuff to do right now. You know, they got other stuff that needs their attention. They have, like I've mentioned, other ways to address this in the short term. And those things will help their record and ultimately put them in a better position if she maintains that he still can't testify. You know, if it does get into a situation where she's convicted and has to appeal. So I'd be surprised if they do it. Yes, theoretically it's possible, but it's not likely to be granted. And given the time pressure that they're under and what they need to focus on and everything, I'd be very surprised if they did. Cat, QQQ, can the defense ask potential jurors in voir dire if they're familiar with law enforcement SOPs? Yeah, same question. If the judge will let them, and I'd be a little bit surprised if she did. I wouldn't be surprised at all if at the end of the day, the transcript, although if that's all going to be, it shouldn't be impounded. Okay. All of this stuff should eventually be public record, names redacted, addresses, personal information, clearly stuff like that redacted, but everything else should be public record. Whether it will be, though, I don't know. We've already got impounded sidebars from the first trial. Is that permanent? I have no idea. So I don't know if we'll ever find out if the defense tries. And if they do try, you know, what happens? If they're doing this up at sidebar, then it's probably not going to be something that people present in the court are going to be able to report upon. The whole reason they're doing it at sidebar is so that the other jurors can't hear what's going on. If the other jurors can't hear what's going on, the rest of the audience presumably can't hear what's going on either. So I don't know if we'll ever find out, but I'm sure if all you guys are having this idea, you know, it will have crossed the mind of the defense. Maybe give that a try. Michael Lawless, would you include investigation procedure questions in your voir dire? Either prove the point or put it on record what jurors actually know. I would definitely give some thought to, you know, whether it fits within my approach already, whether this is appropriate, whether I need this particular information. There's always trade-offs in trial, right? And certainly one of the trade-offs you have to consider is, do I want to piss the judge off even more? Do I want to piss her off even more? Maybe I've just established that I can't piss her off any more than I already have. So, you know, what's wrong with going ahead and giving it a shot? Maybe that's how I'd come down on it. If it doesn't really integrate well with what I'm already planning to do with my voir dire, I don't necessarily want to shift everything up just to accommodate this. I don't necessarily want to have it kind of out of nowhere as a thing that's unrelated to the rest of the questions that I'm answering. So I'm going to give some thought to that. Like, does it integrate well with my overall strategy? But really, is it necessary? Do I need to do that, or can I just establish that with my proffer? It may be a situation where show don't tell is better. I don't necessarily need the jurors to tell the judge this is beyond their expertise. I can present what my expert is going to testify to very specifically in a proffer, what the basis for it is, and I can show how and why it's beyond the expertise of ordinary jurors, ordinary lay people. I mean, at the end of the day, I think part of the question is juror responses in voir dire. Are those going to provide a factual basis to challenge her ruling anyway? I'm not necessarily convinced that it would. I mean, it's not being done for that purpose, right? It's being done for purposes of qualifying the jurors, determining are they eligible to serve. That would be kind of the line that the judge would draw if she's going to cut off these questions. So you can't ask that. That's getting into litigating the facts of the case. Has nothing to do with jurors' qualifications to serve. It's kind of right, although, given the finding that she's made, seems like they need to know it if they're going to be able to be effective in this case without expert testimony. So it is a little close, though. It is a little close to kind of pre-litigating factual stuff. So me personally, I'm probably going to stay away from it unless I can find, a particularly oblique and, concordant way to get to it that fits with my voir dire strategy as a whole. But by and large, I'm going to rely on the expert to do the proffer. Pro Gamer, can the defense use the training manual for the detective exam to ask each law enforcement witness if they agree? Thanks, Andrea. This is possible, but they have to be able to authenticate what it is that they're handing to the people. And so this is the step. Like, okay, you've got everybody who has, passed the detective exam on the stand. I don't know who all that is, but I mean, presumably it's Lank, it's Buchanan, it's Proctor, Tully, I don't even know who else. First thing you have to do, you gotta lay your foundation. Did you take a detective exam? As part of that exam, were you required to learn about the importance of securing the scene? Yeah, you can get through some preliminary stuff, but when it gets to enforcing the actual standard, you're likely to find the police to be resistant to that. Oh, I don't remember the exact words, or there's a lot of reasons. There's exceptions to everything. They're going to try to wiggle around it. So at some point, you're going to want to try to confront them with this actual manual, right? Well, okay, you're saying it depends, but according to this manual, here's, the so what and why. You have to have this manual authenticated before you can rely on it to question witnesses about it. And the cops are not going to authenticate it for you. That's what I was saying before. They're not going to say, oh, sure, this thing that you're handing me on the stand, I'm familiar with it. I remember it. It's completely accurate. You haven't changed it in any way. You haven't omitted any pages. It all looks good. They're not going to do that. They're going to say, I don't know what this is. I've never seen it before. I don't know if this is the same as the one I took. So that's going to be your problem is getting it authenticated to be able to present it to them in the first place. That's where going through the process of cross-examination, showing that you can't do that, you actually need to be able to call your expert to authenticate this document, right? The evidence that you have a right to produce, the standards that apply. You have the right to do that under the statute, which apparently only matters when Judge Cannoni thinks the statute matters. That's what he's there for. That's like a big part of what he's there for, is to talk about what the standards are, how he knows about them, how the law enforcement officers involved would be expected to know about them, why they exist, and so forth. So if they can go through and if they can get that done through one of the law enforcement officers, sure. It's just unlikely. It's unlikely that you get there. By the time you get to somebody, a cop who's passed the detective exam, he's testified enough times, he's learned how to be squirrely. He's learned how to not do you any favors. So I don't know why Judge Cannoni seems to think the police are going to be helpful to the defense on this. It's like she's never cross-examined a cop. It's like she's never cross-examined a cop. It's not how it works. That's why you always have your expert in reserve in case they don't give you what you want. I had a situation, this is slightly different, but it's kind of similar. This came up because one of my clients, I was checking this out the other day because Kara Weinecke had posted about Richard Allen's appeal and the length of time that it's likely to take, and the fact that you could be looking at 5 years before the post-conviction process even gets started. I was thinking about that because I have a client who got his decision on post-conviction just last year, and I tried his case in 2017. So it took 7 years for his case to make it to that stage. Now at the point where the door to the federal court is potentially open through the habeas process. So yeah, these are very extended, lengthy periods of times. But anyway, so I was kind of looking over that the other day, kind of reminding myself of what happened and the timeline and everything. And so one of the issues there had been that I had hired a DNA expert, not a DNA. It was a ballistics. It was a ballistics guy to basically just talk about a lot of the stuff that we talked about in Richard Allen, the junk science that is ballistics, the problems with it, the subjectivity, the lack of objective standards, the lack of, replicability and falsifiability and all that stuff. The standard is sufficient agreement. And what's sufficient agreement? It depends on what the examiner thinks is sufficient. Like, it really should say enough to say this is not a science. This is just a judgment call at best. So anyway, I had hired an expert to help me challenge it pre-trial and try to keep it out of evidence on the grounds that it wasn't reliable. That motion was denied. So we go into trial, and in trial, I cross-examined the experts, and to my surprise, because it never happens, they agreed. They agreed with all these criticisms. Yes, has been brought up by the National Academy of the Sciences, has been brought up by PCAST. Yes, it is subjective. Yes, there's these concerns about it. They just acknowledged all that. So I didn't need to call my own expert. But you better believe we had him in reserve in case that didn't happen. And so that's why you do it, because if any of those guys have said, "Oh, I don't remember exactly what the National Academy of the Sciences report said about ballistics," I'm going to have somebody in the wings to tell the jury exactly what the National Academy of the Sciences said about the reliability of ballistics. So that's why you need the expert. That's why you need the expert. Let's see. Track worker, sickening that Judge Bev can allow this Salem witch trial. They picked the witch, didn't they? And they are bound and determined to see her burn. No concern at all for the process. It really is. It's very disturbing. It's very disturbing, the cavalier attitude towards this type of misconduct, and the lengths you have to go to not see what everybody else can plainly see, which is that this activity, these decisions by law enforcement, these are sketch fuck. That's why there's distrust for you, for this court, for this system, for these officers. That's why. We can all see it. You're just choosing not to. John Beattybot, isn't the sum of destruction, blur, inverted, retention, metadata, timing, all consciousness of guilt, together with Easter denial, ripe for appellate? Yeah, you can definitely make that argument. But her point is all that they get to bring that out during trial. They get to raise all that during this retrial. And yeah, they can argue it's consciousness of guilt. And that's why I'm not going to do anything about it. I'm not even going to say they were bad. I'm just going to say, maybe they should have on this one thing. Maybe they should have done that differently with that Jim McCabe testimony. Heard about Higgins. We'll just drop that in a footnote. The potential impeachment value there. We'll just drop that in a footnote. But, with Jen McCabe, yeah, all right, they should have. Okay, twist my arm, make me say they should have done something different. Was it bad that they didn't? Not even gonna cross that Rubicon. Not even gonna do it. So yeah, they can raise all this in the retrial, and I expect that they likely will. It's quite a sum of circumstances, quite a sum of coincidences. 43 minutes missing, all these other shenanigans, all the changing stories, all of it. Yeah, it's an issue. I am hearing that we might have a decision on the audit. The Canton Town audit report is released. Goodness. Let's see what we got here. Okay, looks like there's a nice shareable piece right here. If I can just find it. Is this it? Here it is. Evidence and crime scene protocols. This is like a little summary that has been prepared. So I'll look at that first. The whole report is 206 pages. Oh, my goodness. Well, we got time. Do we have that much time? I might have to take a break if we're going to go through that whole thing, but I'm not necessarily against it. The audit team reviewed a series of crime scene incident reports spanning over a decade. While some investigations were found to be in line with established guidelines. You mean to say there's established guidelines? There were cases of policy breaches mainly related to the use of digital photography for documenting crime scenes as required by the Canton PD's evidence collection and preservation policy. Oh, you don't say. They have an actual formal written policy. Do you think that's in the common knowledge of the jurors, that there is a policy and what the policy calls for? Somehow I doubt that. Additional shortcomings were identified in the areas of crime scene preservation and detailed incident documentation. Our evaluation included a detailed analysis of the Canton PD policy and procedure, with a specific focus on evidence collection number 6.01, dated October 31st of 2013, over 10 years. This has been the policy. Policy outlines the responsibilities of first responders in evidence collection, crime scene preservation, and documentation. Why would you need a policy if this is all just common stuff that lay people will know? Initial recommendations were for the sergeant or shift commander to take charge of crime scenes and for additional training for Canton PD personnel to handle or supervise evidence collection. Yeah, that might be a good idea. During the examination, the audit team assessed the response and crime scene procedures carried out by Canton PD officers on January 29, 2022, involving the tragic death of Boston police officer John O'Keefe at 34 Fairview Road in the early morning hours. These actions were compared against existing policies, regulations, and requirements to determine compliance. The review of this major incident encompassed crime scene investigations, police reports, evidence collection, crime scene security, interviews, and evidence documentation. Policy violations were identified and are detailed both below and in the final report. This specific case first responding officers should have photographed Boston police officer John O'Keefe at the location of where he was found before fire and rescue moved him to the rescue. Would have been helpful information, wouldn't it? Wouldn't that have been good evidence instead of just trying to look at where there are, tramped around areas in the snow to figure out kind of generally where he was? All interviews of critical witnesses, including Jennifer McCabe and Carrie Roberts, should have been conducted at Canton PD on January 29, 2022, after John O'Keefe was transported to the hospital. Should not have happened at home, should not have happened on site, should have been a follow-up in a formal interview setting. Consensual recorded witness interviews should have been conducted, recorded. They should have been recorded. The MSP, along with Canton PD, should have maintained a police presence at 34 Fairview Road pending the secondary search conducted by MSP crime scene units. Yeah. The crime scene folks from MSP really are the ones that should have responded, aren't they? CERT's crowd control. CERT's crowd control. I don't know why they're the one who is coming out to look for the taillight when there's a whole crime scene collection assistance organization group of the MSP. Why is it not the evidence collection people? I don't know. All video footage files maintained on Canton PD's computer systems of Karen Reed's Lexus SUV while it was housed at Canton PD from January 29 through February 2nd, 2022, should have been requested and turned over early in the Karen Reed case to lead investigators for any action as deemed appropriate. Would you look at that? Would you look at that? Didn't we just finish reading? We just finished reading the order where she said, how could they have possibly been expected to do that? How could they have possibly been expected to do that? How could they have been expected to do that? I didn't realize it wasn't necessarily that visible, so I'm going to go ahead and zoom it up while we're still kind of taking this in. Oh, man. Go back down to this specific case. Based on the policy, the review of the policy, they should have done that. Based on Canton PD's policies, they should have done it. This is outside of the expertise of Judge Cannoni. Not even a layperson. She couldn't, with her selectively fertile imagination, she couldn't come up with any possible way that Canton PD should have known that they should preserve this stuff and turn it over. And yet the auditors who are looking at the policies, they're able to figure out that this should have happened. They're able to figure it out. Oh, all right, guys. We're going to have to take a look at this report. I cannot get around it. However, I'm going to need to take a little bit of a quick break before we do that. We are 5 hours into this live stream and still waiting to see if anything comes back in the courtroom at some point. So we definitely have some time that we can go ahead and take to go over this. But yeah, let me go ahead and put this back at the top so it's there. Guys, give me a few minutes here. I'm going to go ahead and step off, do my routine. You guys know the routine. We got checks to do. It is starting to be bonsai watering season. Once you repot, especially, things dry out a little faster. They start moving water more. So got to check the trees, the animals, all that stuff. But I will be back shortly, and then we will take a little bit of a closer look at this police audit and maybe brainstorm a little bit about how helpful it could be. Okay, guys, gonna quietly unmute and try not to jump scare here. Everybody's in good shape. Chickens are fed. Everyone's happy. We are in good shape here. So, I've been hearing that there's not really much substantive that's coming out of the courtroom right now. The folks that are present are basically just describing the fact that questioning is happening up at sidebar. But as we kind of expected, it's not anything that that folks in the audience can hear. So we don't really have, insight into what exactly the jurors are being questioned about. I know we've got some more questions and comments and things like that to get through. And boy, I want to get through those. But guys, this is pretty breaking news. This kind of a big deal. Let me just zoom this right on up. Oh, look at that. 206 pages of this report. We got so much. I'm going to just go ahead and thumb through this. I'm not going to sit and read the entire 206 pages word for word. I want to kind of take some time to digest what exactly we have here. So, Five Stones Intelligence did it in accordance with the scope of work order detailed within. So that will be specified exactly what their charge was. They don't make findings of fact or conclusions of law regarding ongoing criminal investigations or pending legal matters. So, disclaiming that they have any authority when it comes to making these types of conclusions. This is purely informational and for the use of the town of Canton. Dear Police Audit Committee. All right. Constructive collaboration between Canton Town stakeholders, the public, and the Canton PD. Cooperation, transparency, and efforts of the Canton PD, specifically its leadership, are a testimony to the power of collaborative change. You kind of always expect these sort of flowery introductions. 5SI's audit included the evaluation of the department's organizational culture, policies, procedures, regulations, crime scene protocols, professional standards and accountability, organizational structure and governance, citizens' privacy protections, management and operations, hiring and training standards, citizens' complaints, the internal affairs process, evidence handling and processing, financial resources and budgeting, and the effectiveness and the transparency of the department. Our final report has identified opportunities for improvement in several areas and offers key recommendations as set forth. Thank you for everybody for letting us do this. Yeah. This is, it's an audit. So it's a review, but it's by a, reasonably friendly. Key recommendations. Opportunities for improvement. Not here's where you guys really fucked this one up. Like, God, what were you thinking? Maybe we'll be able to read between the lines. We'll see. Okay, table of contents. An executive summary is always good. We'll probably take a little bit more time going through that because that will give us the real meat of what they did and what their ultimate conclusions were. Section 1, policies, procedures, and regulations. All of these different actions. Some of them are going to relate to this case. Some of them are not. Crime scene protocols. Ooh, whole section on Sandra Birchmore as well. Very interesting. Very interesting, especially considering, as I think is still the case, that motion in limine about mentioning Sandra Birchmore's investigation, that still hasn't been decided. Evidence review, interested in that. Okay, recommend improvements in summary. That will be important too. All right, let's take some time with the executive summary. The town of Canton selected us to conduct an independent police audit. A thorough review of scope of work, which detailed areas for review, including crime scene protocols, professional standards, et cetera, et cetera. Audit included a financial review of overtime expenditures, asset forfeiture expenditures, and police detail finances. Looking a little bit into how the sausage is made when it comes to law enforcement careers and funding. What exactly do they pay for? Residents commissioned the police audit following the tragic death of a town resident, Boston police officer John O'Keefe, on January 29th. Community seeks to comprehensively assess the department's strengths and identify areas where improvements can be made. This doesn't sound good for the Commonwealth, does it? When the fact that the town initiated this audit after this, in response to this, it doesn't say, no, okay, fair, post hoc ergo propter hoc. Just because they're telling me it's happened following his death doesn't necessarily mean they're telling me it happened because of his death, but it certainly seems to be implicitly there. This was the trigger. This was why they did the audit. And if that's the case, I got to wonder about the trend of these opinions that we heard from the first jury panel. I got a lot of opinions about this case. Gotta wonder about that. It was enough to spawn this audit. It was conducted from November 18th to March 30th. So about 4 months it took. That's not too bad. From 2015 to March 2025 at Canton PD, they were on site for 12 weeks evaluating day-to-day operations, department's adherence to internal policies and procedures, as well as compliance with applicable laws and regulations. Now, this is always going to be a little bit of an issue when it comes to validity. The people know that you're there. You know, it's not like you were hidden behind screens or they put in hidden cameras or something like that and didn't know they were being monitored. No, you were there. And the very fact that you were there is going to change behavior. It's going to change behavior. So I'm not going to put a lot of weight, more than likely, into the 12 weeks, but I am interested in what they did as far as their review of the past cases. Conducted interviews of all members of the Canton Police Department, including over 40 police officers and other town employees. Many of the interviews were completed under the condition of anonymity. Our team examined more than 98 policies, procedures, rules, and regulations. You know, all these things that are supposed to be within the common knowledge of lay people. Recommendations were put forward in various aspects of the project, such as professional standards, civilian grievances and accountability, crime scene protocols, advanced training, and compliance with the Massachusetts Police Accreditation Commission. Interesting. We received full cooperation from Chief Helena Rafferty, other members of the police department. None of them had met anybody. Nobody got the report beforehand. And their contact was the chairperson on the police audit committee. Our team conducted an interview with all Canton PD employees. The officers who agreed to be interviewed were candid, cooperative, and forthright. Each officer was interviewed in private. So now, okay, they conducted interviews with all Canton PD employees, but they're suggesting the officers who agreed to be interviewed. So I guess I'm to infer that all of these were by agreement, because if you interviewed everybody, then there were no officers who did not agree to be interviewed. Each officer was interviewed in private with no supervisors present. Yeah, well, that means they didn't coordinate. Of course not. No senior member of the Canton PD command staff or town officials interfered with or attempted to influence the information and or findings. Audit team operated with independence and autonomy. They have extensive experience in investigative processes with expertise in conducting internal investigations, compliance, and inspection-related issues. So trust us, bro. We followed the rules. We didn't do anything improper. Given the interest in this audit, it is important to understand what is included as part of this audit and what is outside the scope of this audit as summarized below. Included: assessment of policy compliance with standards of law enforcement accreditation organizations. There's the standard. Assessment of the application of policy in recent investigation. Assessment of the written policy and protocols as applied in recent investigations. And presentation of findings and recommendations. What is not included: reinvestigation of any cases or finding of fact. They're not going to say Karen Reed didn't hit John O'Keefe with the car. They're just going to tell us why the police messed up so much that we may not be able to know that that happened. Analysis of evidence collected in ongoing or prior criminal cases, rendering any opinion of guilt or innocence of a party. Yeah, they're not here to decide cases. That is very much the case. Just looking at the process. The audit was conducted in accordance with established criteria such as U.S. GAO government auditing standards, post-commission standards, Commission on Accreditation for Law Enforcement Agency standards, to ensure rigorous assessment of the department's operations. Assessment entailed a thorough evaluation of the Canton PD across a broad spectrum of operational and administrative areas. The audit team's focus extended beyond mere compliance to encompass the department's effectiveness and efficiency in implementing policies, procedures, rules, and regulations. We reviewed a total of 98 Canton PD policies, governing procedures, rules, and regulations, as well as reports of investigation, crime scene preservation, and training opportunities provided by Canton PD command staff. The audit team ensured a comprehensive and unbiased assessment was completed in each section as outlined in the scope of work. Additionally, employee interviews, yes. Covering leadership, patrol officers, and detectives. Yes, we know when you say all members, that means all members. In addition to key town of Canton department heads, including the town administrator, superintendent of schools, and select board members. These interviews highlighted areas of strength and efficiency, areas for potential improvement, and illustrated the professionalism of the Canton PD officers during what has been described as a tumultuous time in the town of Canton's history. As the audit team worked through the scope of work, numerous findings highlighted discrepancies between written policy and implementation. The audit team has put forth recommendations in the body of this report in an effort to assist the town of Canton in enhancing policy compliance and operational efficiency. Do you like the euphemistic speech here? Do you like it? I rather enjoy it. I find it, I just find it entertaining how easy it is to, dress up these findings as if they're opportunities. As was it MacArthur in Korea? We're not retreating, we're just advancing in a different direction. Was that I forget who that was. Anyway, we're not retreating, we're just advancing in a different direction. That's kind of my read on this. This isn't about your fuck ups. It's really not. It's about your opportunities to be better. Maybe that's all the defense needs to do with Judge Cannoni. Instead of pointing out how she's messed up in her rulings, just point out, Judge, we're just giving you the law here in an effort to help you improve. Do you think that's going to work? Yeah. No, because everybody sees through it. Everybody knows the euphemistic language is just what you do in this type of context. It's the formality of the process. But what you're actually saying is you guys have a problem with policy compliance. The audit team has put forth recommendations, yes, enhancing policy compliance and operational efficiency. While the audit covered 20 sections, the areas of crime scene protocols, professional standards and accountability, organizational structure and governance, management operations and culture, hiring, training, and equipment and evidence are the main areas in which the audit team identified immediate action and development items. These are the big problems. Everything else is kind of a problem, but these are the big problems. You really need to focus on this right now. Let's get the details, shall we? Evidence and crime scene protocols. The audit team reviewed a series of crime scene incident reports spanning over a decade. While some investigations were found to be in line with established guidelines, there were cases of policy breaches mainly related to the use of digital photography for documenting crime scenes as required by the Canton PD's evidence collection and preservation policy. Yeah, this is because forensic photography is a skill. It's not something that's within the average experience and knowledge, understanding of lay people. People who understand photography often don't understand the full extent of why forensic photography is very specialized. Because unless you're pretty into it, you know, you learn about things like focal lengths and shutter speeds and how the length of the lens distorts the perspective of the image. And you get different effects by employing different photographic techniques. People think, you know, a photograph is just like a straight mirror image of reality. No, it's warped. It's like going through an eye. There's a perception type of quality to it. And so the art in forensic photography is being able to capture it in a way that is as close to reality as possible. It's not misleading. It gives you the right perspective, gives you the right, you know, orientation of things to each other, to the scene as a whole, and so forth. So yeah, it's a very specialized technique, not something that average jurors are going to be familiar with. Additional shortcomings were identified in the areas of crime scene preservation and detailed incident documentation. Our evaluation included a detailed analysis of the Canton PD policy and procedure with a specific focus on evidence collection number 6.01 dated October 31st, 2013. This policy outlines the responsibilities of first responders in evidence collection, crime scene preservation, and documentation. Initial recommendations were for the sergeant or shift commander to take charge of crime scenes and for additional training for Canton PD personnel to handle or supervise evidence collection. Who was the shift supervisor when this call came in? Wasn't it, boy, now I can't remember his name, but he was the guy that was sitting down there and took the 911 call. Good? Was it Good? I think it was Sergeant Good. So he's the one that should have taken charge of the crime scene. Maybe, I don't know. Additional training for Canton PD personnel to handle or supervise evidence collection. Yeah, well, that seems pretty clear from what we saw they did in this case. Well, let's talk about this case. During the examination, the audit team assessed the response and crime scene procedures carried out by Canton PD officers on January 29th, 2022, involving the tragic death of Boston police officer John O'Keefe at 34 Fairview Road in the early morning hours. We got to keep saying it's the tragic death of Boston police officer John O'Keefe. These actions were compared against existing policies, regulations, and requirements to determine compliance. The review of this major incident encompassed crime scene investigations, police reports, evidence collection, and crime scene security interviews and evidence documentation. Policy violations were identified and are detailed both below and in the final report. So these are the things that we already saw. They should have photographed John O'Keefe where he was found. They should have interviewed the critical witnesses at the police department after John O'Keefe was transported to the hospital. So immediately before they've had a chance to get together and communicate with each other and so forth. Consensual recorded witness interviews should have been conducted. Yeah, they should have been recorded. Should have been recorded. MSP, along with Canton PD, should have maintained a police presence at 34 Fairview Road pending the secondary search, should have secured the crime scene, and all video footage maintained on Canton PD's computer systems of Karen Reed's Lexus SUV while it was housed at Canton PD should have been requested and turned over early in the Karen Reed case to lead investigators for any action as deemed appropriate. Just as a matter of policy, not anything that they needed any great clairvoyance to be able to anticipate. Their own policy. Their own policy, apparently, makes it pretty clear that this should have been done. Professional standards, internal affairs. In evaluating professional standards and processes, the audit team conducted an examination of internal affairs investigations dating back to 1991. That's quite a few. As a result, we found that there was a lack of organization and consistency for the investigative files and for investigative efforts, particularly during the tenure of 4 different Canton police chiefs, namely John Ruane Jr., Peter Bright, Kenneth Berkowitz, and Helena Rafferty. Lack of organization and consistency. We examined 75 IA files over a 20-year period. The 75 actions resulted in 63 clearances and 12 acts of sustained violations. So 5-to-1, 5 clearances for every 1 sustained. The 12 sustained violations resulted in 4 suspensions, 1 demotion, and 7 counseling/training sessions. The audit team determined that post requirements were met as they related to these inquiries and subsequent disciplinary actions. The most recent action occurred on October 2nd, 2024. 2 complaints and results were sent to post in accordance with policy. So I'm sure they'll follow up on this in the body of the actual report. But it sounds like what Post sets a standard for is simply for the reporting of IA processes and not what the IA processes themselves need to consist of. That's why we have all of these, these inconsistencies and lack of organization and so forth. Just depends on who's in charge. Things get handled differently. That's really not the way it's supposed to be. Nothing about, were these good and valid findings? Were these appropriate? I'm interested. Maybe we'll see some more in the full report. It was noted that due to the department's size, establishing a designated internal affairs division or the designation of a full-time internal affairs investigator is not practical. The audit team found that complaint files were not maintained in a consistent manner, as methods of investigation, documentation, and processes were varied. While the Deputy Chief of Operations and Investigations is responsible for overseeing internal investigations, we found some complaints filed by residents and or violations of policy and procedure by officers were handled directly by the Chief of Police, creating a conflict. Yeah, that's really not so good. That's really not so good. I mean, I can't help but be a little bit concerned that in 75 actions over 20 years, okay, back to 91, over 20 years, not a single person got canned. Nobody got canned. Am I to believe nobody did anything can-worthy? But nobody did. Yeah, Chief of Police handling it would be a conflict. Observation and findings, a Canton PD's internal affairs process is inconsistent regarding investigation and documentation methods. The audit team found no instances where complaints were intentionally ignored or officer misconduct was arbitrarily excused, but the consistency in how cases were handled varied greatly. Well, I would imagine they have a little bit of expertise like we have seen from Judge Cannoni about knowing what you don't want to know. And so you can avoid having the problem of needing to excuse egregious misconduct if you simply don't bother to inform yourself about the fact of the misconduct occurring. You structure your investigation in such a way that you're not going to find out about that information. Willful blindness can really pull a lot of weight in terms of driving the outcome. So I'll be interested in seeing the specific parts of this section. Several misconduct complaints were handled directly by the chief of police. The audit team recommends hiring outside firms for IA investigations where conflicts and potential conflicts exist or cases where multiple officers are involved. Everybody's always happy to spend money to build more jails, to prosecute more people, to pass more crimes. And when it comes to spending money to keep police in line, strange reluctance to do that. Organizational structure. I don't know if we are super concerned about this, but let's see. Framework and chain of command are well defined. Of course they are. It's a semi-military style institution. Assuring that communication follows the appropriate channels to reach supervisors. The question is, what do supervisors do with that information? Information flows smoothly to the necessary authorities when senior decision-making is needed by bringing in additional civilian staff members such as intelligence analysts. The department could greatly improve communication capabilities, leading to increased efficiency and effectiveness. The audit team found that the Patrol Division and Investigative Division frequently collaborate on crime prevention and provide effective support to each other's efforts. Teamwork and synchronization are evident in their combined responses to incidents such as a non-fatal shooting event in November 2024. Yeah, when you have a small town and a small town department that only has 40 cops, it's going to be an all hands on deck situation when you have an emergent crisis type of response. You have a bomb threat, you have a fire, you have a hostage situation, you have a use of force, a shooting, obviously. So, I mean, that seems kind of normal. I don't know that necessarily relates to their division as patrol and investigative. That's just your law enforcement. That's what your job is. During this occurrence, both divisions swiftly reacted, apprehended the shooter, and gathered crucial evidence, including the weapon used. Their cohesive approach involved conducting interviews, examining evidence, and liaising with prosecutors to file attempted murder charges against the offender. So they didn't get in each other's way, is kind of where the bar seems to be set here. The unity and coordination between the patrol and investigative divisions were outstanding and played a crucial role in the successful resolution of the case. Patrol officers are actively engaged in cases and maintain close collaboration with the detective division. Additionally, all details and activities were promptly communicated to senior management and town officials, guaranteeing appropriate notifications within the organization. Well, that's great that they're able to respond well in a crisis. That really is the minimum. Like, if there is one thing we should hope and trust that our police departments will do, it's keep back the wolf at the door. Like, just the one thing. Just the one thing. If somebody is out shooting, could you deal with that? That'd be helpful. That'd be real helpful. Glad to know that they are clearing that bar. Canton PD patrol officers are tasked with handling both 911 calls and other calls for service, dispatching calls for service to patrol units. The audit team recommends that the Canton PD should consider transferring their dispatch and 911 responsibilities to the Holbrook Regional Dispatch Center. The relocation of dispatch operations to the Holbrook Dispatch Center will not incur any expenses for the town of Canton for a period of 3 years. Furthermore, this transition will ensure the provision of services, maintenance, and upgrades to the radio communication system, such as transmitters and repeaters, be funded by the state. A secondary option would be for Canton PD to hire full-time dispatchers to assist officers in taking calls for service, non-emergency and emergency calls for service, and other administrative tasks. I'm surprised that if there is a central dispatch system available, that they aren't already part of it. That seems very surprising to me because, yes, it is such an obvious efficiency to get rid of one of your desk jobs that can be done by somebody else and get rid of the distractions in the field when you've sent out this call and people realize that it's actually some other service that's needed. You need ambulance. You don't necessarily need law enforcement. You let them handle that at the central dispatch and decide when you need to come out, not default to you come out and then make the decision to call in other assistance. So it's very strange to me that they wouldn't do that. And I'm interested in where they get to with the organizational culture, because to me, the only real reason why you wouldn't has to do with the control freak piece of it. You don't want to give up control over when and how and to what you get dispatched. And that's, a little alarming. Police, as we've talked about before, they don't have a duty to do anything for you. Okay. They don't have a duty under the law to do anything at all. If you call the police and you report, there is a person right now who is stabbing me as we stand here, I need help, and the police do nothing at all. They say, thanks for your call, and hang up and do nothing. They have violated no law, no duty. There is no liability on their part for not doing that. So you can kind of maybe appreciate why it could be helpful for the decision about whether police are going to respond to an incident or not to be made by somebody other than the police. They're like, it's too hard. We're too overstaffed. We got other priorities. I don't like you. I don't want to go to your neighborhood. Things like that might be helpful, might just look a little better, if nothing else, for somebody else to be making that decision. These recommendations are based on best practices and are anticipated to enhance the efficiency of the Canton PD while fulfilling various needs. While the department has established and implemented standards for communicating with the public regarding emergencies, the function that permits public feedback has been deactivated. They don't want to hear from you. They don't want to hear about how they did. They are not interested in your feedback about the quality of their service. That's not awesome, is it? That's not really great. This has limited the possibility of productive discussions, you think? Some individuals in the community, along with social media influencers, have continuously targeted the police department and its personnel with scornful comments, negative personal attacks, and severe critique. Even for the most basic aspect of their duties, this has hampered efforts to establish a constructive dialogue. Well, that's because when you don't listen to the legit stuff, the small things that you should be concerned about that should get your attention, when you don't listen to those, people realize the only way you might listen at all is if you just hear big stuff. If they get madder, maybe now you'll pay attention to the fact that you serve them, you do not rule them. Observations and findings. The Canton PD had 3 IA investigations in the past year as a result of police officer dispatch failures. No civilian dispatchers are employed by the Canton PD, and the Canton PD has only 1 part-time civilian employee. Okay. Police dispatch failures. Interested in that. Management, operations, and culture. The audit team observed Chief Rafferty's leadership style while she knows she's being watched and found her approach and decision-making abilities to be effective. Chief Rafferty is highly respected by the members of the department and colleagues in the law enforcement community. There is a noticeable decrease in morale among department members, largely due to public scrutiny regarding the Canton PD's handling of the crime scene and investigation into the tragic death of Canton resident and Boston police officer John O'Keefe. While constructive feedback is beneficial, the continuation of personal criticisms has transformed from a method for improvement to personal attacks. because people haven't listened. They've chosen to be willfully blind and to flaunt their ability to do what they want without any kind of accountability, which they're certainly not getting from the court. These attacks via various avenues such as social media, phone calls, emails, and public demonstrations have had a significant negative impact on morale within the department. Well, I think that's kind of the point. Like, you should not be happy to work there if this is how it operates. Social media personalities have claimed that the Canton PD deliberately mishandled the crime scene where Mr. O'Keefe was found on January 29, 2022, and implied a possible cover-up within the department to hide the circumstances around Mr. O'Keefe's death. Following her arrest, Karen Reed and her legal team have asserted there is a conspiracy and cover-up involving law enforcement and witnesses. Influential figures on social media from various regions have been tracking and amplifying these claims. Multiple Canton PD officers have stated that they have experienced harassment from the public while working, spending personal time with their families and children, and during off-duty police details. A gathering of individuals supporting the Free Karen Reed movement regularly protest outside the Canton PD. Is that a problem? Is that a problem? Citizens exercising their rights to protest? Is that a problem? There have been numerous accounts of officers encountering harassment, both in person and online, including through emails, voicemails, social media platforms, and YouTube. Members of the audit team have received emails and text messages prompting team members to investigate allegations and alleged cover-ups by police. Not making any findings about any of this. Just saying social media personalities claimed it and that Karen Reed and her legal team have asserted it. Let's hope maybe they get into a little bit more depth when they get into the main part of this report than this summary, because that seems a little bit pat. Seems a little bit pat. We just spent this morning pointing out the reasons why this whole thing looks sketch as fuck. Okay? Deleted 43 minutes of the video. This is just the video. This is just why the video stuff looks sketch. We haven't even gone down the whole road of the poor decision making, the conflicts, the other violations, and so forth. And yeah, people are entitled to, and will have theories about why all of these shortcomings in this particular investigation. And they might think that maybe it has something to do with that text that Michael Proctor sent where he said, no heat's going to come on the homeowner. He's the Boston cop too. So yeah, maybe it's not just a claim and a assertion. It's a perspective that people have based on their familiarity with how law enforcement handled this case. I hope they get into that a little bit, because if this is their attitude to the public perspective, you think that's going to invite constructive dialogue? You're going to just continue to minimize and dismiss the concerns that reasonable people have. So you better address those head on. While tensions are strained within the community, it is incumbent upon the leadership for the town of Canton to remain unbiased and objective. Well, good luck with that. You got an Albert on the select committee. Any lack of support from town leadership, coupled with the vitriol expressed by some members of the public, has negatively impacted the morale of the officers. So listen to that. Any lack of support from the town leadership, if you don't back the blue, you're responsible for negative impact to their morale? Boy. Well, that's quite a Hobson's choice, isn't it? If you criticize the police department and how they handled this case, that is bringing all this heat down on your city because it's inexcusable. It's your fault that there's bad officer morale. No, it's the bad job should be the reason for the lack of morale. Any lack of support from town leadership? Remaining unbiased and objective does not mean you don't get to have opinions and you don't get to express them. Don't know how many times we have to talk about the difference between being biased and being informed. It's a big difference. It's a big difference. When you're biased, you're reaching a conclusion based on a lack of evidence, based on a generalization, based on a presupposition, based on an inclination, a tendency to lean one way or the other. It is by definition something that you're doing not based on the specific facts and circumstances of that situation. So when you know about the facts and circumstances of the situation and you form an opinion based on them, that's being informed. It's being informed. It's not being biased. And it also doesn't mean you're not being objective. It means you've considered the facts and the circumstances and the evidence, and you've reached an opinion. And your opinion might very well be, this department sucks, and some things need to change here. Some big things need to change here. There's a reason why all these people are so outraged. That doesn't make you biased. It doesn't make you not neutral. It makes you informed. The following two quotes given by two separate Canton PD officers during their interviews highlight the chasm that exists between the Canton PD and the town officials. Quote, "No one in this town will care about us until one of us gets murdered. Even then, half the town will probably celebrate that. Elected officials don't care about us. Now the easiest way to gain popularity or get elected is to publicly trash us. They have no political platform. Just trash the police. That's it. It doesn't even have to be true. Just do it." That doesn't sound very good at all for those opinions that have been formed about this particular case, does it? If that's the attitude and that's the consensus, I would expect that to be borne out. I would expect that to be borne out in the opinions. I would expect there to be far more people who have formed an opinion favorable to Karen Read than people who haven't. And if I don't see that, sounds like maybe the police are being a little bit crybabies about being criticized. Maybe they're being a little hypersensitive about taking correction, because cops like to be the ones in charge. They don't like being told what to do. They're the tellers. And if you don't want to do it, they'll make you. They'll stick their knee in your back, get you on the ground, make you do it the way they want it to happen. They don't like being told what to do. So don't know if we'll really get to find that out. We should be able to get to see the jury selection with the identifying information redacted from us. And then we can see how many of these jurors disclosed a favorable opinion towards Karen Read. I don't know. I'll be interested. Observations and findings: the Canton PD has above average morale as it relates to camaraderie and faith in the department. Oh, they have each other's backs, do they? You don't say. Interviews conducted by the audit team revealed the officers do not feel they have the support of Canton town officials. Well, I mean, nobody did say that guy on the town of Canton select board, he's who you'd go to if you want to bury a body. They don't seem to have that type of relationship with the town. The Canton PD officers' morale as it relates to its relationship with the town is low. Yeah, because the town reflects accountability. That's what they represent. is accountability. The audit team has been informed that the town meetings in the town of Canton devolve and become contentious and unproductive. Well, according to who? By whose perspective? Hiring, training, standards, and equipment. The Canton PD is a civil service department which plays an important role in ranking and selecting new officers. Prior to exercising police powers in the Commonwealth, individuals must successfully complete the prescribed course of study for basic police training authorized by the Municipal Police Training Committee. No kidding. Standard policies and procedures that they all have to learn in basic. I mean, we already knew that, right? We know what they all are. That's within our knowledge. The MPTC sets the standards for basic police training for candidates hired by individual police departments throughout the Commonwealth. These police departments submit applications for their employees or sponsored candidates to the recruit academies. Hiring practices vary by department, and certain departments operating by civil service, Canton PD, must follow a selection process set forth by statute. All Canton PD recruits in accordance with state law must 1, be a minimum of 21 years old, 2, be employed or sponsored by the Canton PD, meaning they have to put you up. They have to say, we want to hire this person before you go to academy. They don't hire you out of the academy. And 3, successfully complete the Massachusetts Human Resource Division's physical ability test, PAT, and medical examination before assignment to the academy. So you got to clear all these things before you can go and get your training. The Canton PD hiring process and the standards followed are in alignment with policy, civil service requirements, and industry best standards. Additional training for Canton PD officers is required. While the Canton PD meets training requirements as they relate to certifications and qualifications, our team recommends Canton PD detectives receive advanced training in crime scene photography, crime scene documentation, evidence evaluation, and collection. The audit team recommends further training in the areas of crime scene management, report writing, evidence collection, expert witness testifying, internal affairs, discovery rules, and legal ethics. Additionally, officers have expressed a desire for more training, and while the command staff attempts to fulfill each request, current budget constraints prevent them from doing so. That's always about the budget. The priorities, the priorities. You gotta get a new camera, for that Sally port, not the one that was inverted, some different one. You got to get that camera, not the training. The audit team has pinpointed locations in the town of Canton where the Canton PD portable radios are not functional, given that officers are not equipped with department-issued cell phones, a scenario where a Canton PD officer may be dispatched from their marked patrol car to address an emergency situation on Washington Street, Canton Central, without any means of communication is realistic and concerning. The situation could leave the town vulnerable to legal action. Maybe have to sit and think about those scenarios. Observations and findings. The Canton PD detectives need advanced training in crime scene investigations. That's quite blunt. The Canton PD needs an increased training budget approved by the town. Good luck with that. The civil service standards place a limitation on who can be hired by the town of Canton. Portable radios and their inability to provide complete coverage is problematic, and Canton PD officers are not issued department cellular phones. A list of a few recommendations as they relate to the above observations and findings. The final report contains numerous additional findings and recommendations. So, recommendation 1, interviews conducted at the Canton PD. Interviews of witnesses should be conducted at the Canton PD whenever possible. Those interviews should be recorded and conducted as soon as possible after an event. Seems pretty common sense, but not common sense enough for the officers to know that. All sergeant and patrol vehicles should have full crime scene kits, including evidence collection bags, sealing equipment, and digital cameras. Yeah, you shouldn't be having to hunt for Solo cups in the Stop and Shop bag if you're in a hurry to try to collect some evidence. Department phones or digital cameras should be placed in patrol cars for officers to document crime scenes. The audit team identified that officers and detectives use personal phones to photograph crime scenes. Oh, that's interesting because they really couldn't have been bothered to do that during this whole response. How many officers did we hear from? How many testified? How many responded to different scenes? And how many pulled their cell phone out of their pocket and took a picture? Not a single one. But apparently they do it all the time in other cases. How weird. Patrol officers and sergeants noted that Canton PD has one digital camera assigned to the detective division. Chief Rafferty is aware of this recommendation and is in the process of purchasing additional digital cameras for officers. So in the process of buying cameras, guys, we're totally taking this seriously. Recommendation 3, rewrite Canton PD policy and procedure related to utilization and authorization of personal phones to photograph or video crime scenes. All policy should be changed to mandate the use of only department-issued owned phones to photograph crime scenes. Use of personal phones should be strictly prohibited. Yeah. Yeah, it should for a whole bunch of reasons. I mean, you have chain of custody issues are the most obvious ones. What's your process for keeping this secure? Are you having your phone extracted to get this evidence? How is it being produced? That's a problem. But then there's also just the whole evidence integrity, investigation integrity aspect. When you have somebody like Proctor who likes to be the big man on the group text to his friends, oh, imagine if he had photos, if he had photos of things that he could share. You don't think he would? I definitely think he would. Definitely think he would. That was his whole attitude. I know all this stuff. You're reading about this in the news. It's all over the papers. It's all over the evening news. It's my case. I'm the guy. I know it all. It's been a rough day. Yeah, he would absolutely share photographs of crime scenes if he had them on his personal phone. Recommendation 4, relinquish 911 and dispatch responsibilities to the Hallbrook Dispatch Center or hire full-time dispatchers. Relinquish control. Relinquish the responsibility. Interesting way of putting that. Loosen your death grip on dispatch. In the past 6 months, the audit team identified 3 separate occasions where patrol officers failed to dispatch officers to calls for service. The audit team found most neighboring police departments of similar size employ full-time dispatchers or utilize regional dispatch centers. So in 6 months, 3 times. 3 times. What's the explanation? You got too busy or you just didn't feel like responding to that one? What's the explanation for this failure? That seems like quite a few in just 6 months. These options must be evaluated by the town of Canton as either could alleviate overtime costs while providing an extra police body where needed. The use of regional or full-time dispatchers would allow overtime funds to be redirected towards overtime expenses incurred while attending training. Additionally, the officers covering dispatch would be available to perform police functions on patrol instead. Yeah, this is called highest and best use. Highest and best use of your resources is not sitting one of your specially trained people at a desk to answer the phone and do things that you don't need to have gone to the academy to be able to do. If regional dispatch is the selected alternative, any expenses from radio system upgrades and maintenance is covered by the Commonwealth. It seems like a pretty good reason to go ahead and let go of that death grip and maybe just let somebody else make the dispatch call. Will they be capable of doing that? I think that will say a lot about the culture of this department, won't it? No, you could transition for free and get upgrades, not at your expense, no budgetary implications to you. But you got to give up control. Is that a worthy trade? Recommendation 5, increase training opportunities for patrol officers, detectives, and sergeants. Specific training of note includes crime scene training, interrogation and witness interviews, and evidence documentation practices. More training. Recommendation 6, Chief of the Investigations Division should review all death investigation police reports to ensure completeness, accuracy, and exhaustion of all investigative avenues. Note, a Canton PD detective wrote that Sandra Birchmore died of a suicide in the initial report. It was later determined that she had been killed by strangulation. What an interesting note. What an interesting note. Yeah, we're definitely going to look into what this report has to say about the Sandra Birchmore investigation. Because, it's an intriguing sequence of events, isn't it? We already know from Dr. Scorty Bellow's testimony that when the medical examiner in Massachusetts is making the determination of the cause of death, it's not a black box. It's not a black box determination, cause and manner. They don't just base it on the body and the autopsy. They base it on the information that the police choose to share with them. And we know from Trooper Proctor's text that if you don't jump right on board with their theory, you might be a whack job cunt. You might be. So we already know that there is this collaboration, let's call it, between the law enforcement and the medical examiner when it comes to making this determination. And part of that gives them both some plausible deniability. The medical examiner can say, well, I only said it because of the information that they brought to me that made me exercise my interpretation in this particular way. And the police can say, well, we only said that in our report because that was the finding of the medical examiner. You diffuse responsibility enough, then there's nowhere for it to land. Nobody has to claim any. So I'm so intrigued by this note because yes, the original law enforcement determination was this was a suicide, and that's why the case sat there for a couple of years before the FBI finally brought the charges. And apparently, an independent medical examiner hired by the family is who reviewed the autopsy and said, no, this is not a suicide. This is a homicide. And the feds, looked at all the other surrounding circumstances, like the 35,000 text messages that Trooper Guarino somehow managed to miss in the extraction as to the nature of the relationship between these two people. It was later determined that she had been killed by strangulation, but not by Canton PD. As far as I know, Canton PD hasn't changed their recommendation. And why do I think that? Because there hasn't been a charging decision from the Norfolk County DA's office to charge Mr. Farwell with murdering Sandra Birchmore, which you'd expect they would do. You don't have to go forward through it. If the feds are already taking care of the situation, they get a conviction. You don't have to go forward with it, but you have the option to. You certainly can. You're a separate sovereign. There's not a double jeopardy implication there. Feds in the state are separate sovereigns. They both get to prosecute separately for the same act if they choose to do that. So yeah, that's a very intriguing note, because I don't think the Canton PD has changed their determination that this is a suicide. So recommendation 7, provide prompt, proportional, and consistent discipline across the department. Discipline must be applied consistently to all employees and administered in a manner that prevents the appearance of undue favor to any employee. Was that a problem?
The audit team identified that several internal affairs cases were handled directly by the chief of police in instances where the discipline process was not always applied consistently. You don't say. You don't say. The guy who would help you hide the body wasn't necessarily the best, most consistent applier of discipline. Morale has shifted since then, since this has been exposed. Yeah, none of that seems very surprising. Well, so that's the executive summary. That's the main takeaways from this report. I think there's some intriguing stuff in there. I'm not going to take the time right now to go through the other 180 some pages. I think what I'll do is just work my way through it when we are not on stream, and then find the parts that stand out and come back and talk about those. We definitely saw there's a lot of things that they covered that aren't necessarily particularly relevant to this particular case. But a lot of this stuff potentially does. Yeah, it potentially does. Very specifically with respect to his case, should have photographed him in place. Interview should have been at Canton PD as soon as possible. All the witness interviews should have been recorded. Should have secured the crime scene at 34 Fairview, and they should have immediately turned over all of that video footage to the lead investigators. So what can or will the defense do with this? I see a couple of options. The fact that these determinations have been made through this audit process, while the auditors are going out of their way to disclaim we're not making any findings about any specific case or anything like that. Well, you are actually making findings. It says right here, findings at the initiative of the town of Canton to better understand their police department and how it operates. Through the process, is a jury entitled to hear about this? Yeah, I tend to think they are. It does tend to go to Bowden. The fact that the problems may be broader than these specific findings as to John O'Keefe's case doesn't really undermine the problems as they apply to John O'Keefe's case. Now, these are very specific things having to do with evidence collection. But there's other findings that can potentially relate to this case as well, like discipline. Kevin Albert, he was a member of the Canton Police Department. We saw that one of Trooper Proctor's grounds for being dismissed from duty was the violation of that drinking on staff, drinking while on shift, and then driving the patrol car policy. Kevin Albert's the guy who got so drunk that he thinks he left his gun in the car. Thinks he left his gun in the cop's car. And what did he get? If I remember right, he got some paid admin leave. He got a paid vacation. Yeah, if there's flaws in these IA processes and how they're handled and who is handling them that can potentially implicate the bias in Karen Reed's case, I would think that would be fair game as well. So I don't think they're limited to just these very specific things that relate to evidence collection with John. I think those certainly are fair game. But anything in this report that touches on processes that they would have gone through in the course of this investigation, this production, etc. The testimony, the documentation, all of it. All of it. Seems like fair game to me. Because these are serial shortcomings in the department. And one of the exceptions to, bad act evidence is to establish a habit or kind of your normal manner of doing things, your habitual practices. And so if their habits are bad in a way that affects Karen Reed's trial, yeah, seems like that should come in as well. Even if this report doesn't specifically investigate how did that habit relate to her trial and get reflected in the trial. Yeah, that seems like fair game to me. Then obviously, does this give them more ammunition when it comes to calling Detective Easter? Maybe. I think it might. I think this is a pretty good indicator that it took a specialized auditing intelligence company to be able to go over the protocols and then what they did, the policies, the standards, and then what they did and identify shortcomings. That is what Mr. Easter was proposed to do for the defense. Not just generally criticize. He wasn't going to get on the stand and say these guys did a bad investigation the way that she wanted to characterize it. This is pretty good indication that what those policies are, how they're to be carried out, and so forth, those are not within the knowledge of average lay people, because the town of Canton had to pay God knows how much to this professional organization. These studies cost a lot, guys. These studies cost a lot, hundreds of thousands of dollars to do these kinds of reviews. They had to pay, specialists a lot of money to be able to do the work that she is suggesting the jurors can just do with their common sense. I think this is a pretty good rebuttal to that conclusion. So I definitely see those avenues for this being maybe a little bit helpful to the defense as they come forward. So I'm going to go ahead and go back now to some of the questions and comments that have come in. Desert Quill, official proclamation, exchange the word Karen used to describe an annoying person to Bev, as in don't be a Bev, dude, or what a Bev. Yeah, I mean, especially to the extent that whole Karen insult, I'm gonna, I'll talk to the manager. It's control freaky kind of thing, does fit the glove maybe a little bit when it comes to Bev and just her insistence on deciding how things need to be done when it's not really in her lane to be making that type of decision. John Beattybot. Bev writes, picking up daughter 2 lines before McCabe, quote, says, dropping off. The lack of clarity in record is in your face. Amazing. So bold. Well, she just doesn't care. It's clearly impeachment. It may not be the most material impeachment that there is in the case, but it is impeachment. And so because of that, it falls under Brady. And she can't acknowledge that and minimize it at the same time. She can't pass it off as, well, it could have been a little bit better. Maybe it would have been better if they'd done it this other way. Yeah, it's right there. It's right there. Edward Kirkpatrick. Only sworn facts around tampering is the sidebar testimony of juror. The rest is all just supposition from Judge Bev. George contradicts Judge Bev's version of Juror B, Juror A, dispute in Vanity Fair. That's interesting. I haven't seen the Vanity Fair piece. So I do remember that, yes, Victoria George had commented about it. And I think I remember saying that that's how I knew that there were four jurors involved. I think 4 jurors involved in making the report. So this wasn't like juror A is trying to be a troublemaker and is going and stirring up dissent, to be difficult. There's multiple people that came forward. So yeah, making the findings on this again without having a hearing based on this is what she knows and she thinks and she remembers, it's problematic. It's problematic. And yeah, I agree. That is the only sworn evidence that there is. So when she says there's credible evidence of a violation, no, there isn't. There isn't, because what you have is the juror denying it and saying no. No. Didn't discuss the case. Canoni's baloney. I read this, I don't know, as no, I don't think I did, but you're telling me cops are saying I did and there may be video, so maybe I'm the crazy one. Yeah, this is exactly the process that people go through when the cops lie to you, when you're like being interrogated. This is one of the big contributors to false confessions, and not just false confessions, but the specific subset of them that the folks who study this stuff call internalized false confessions. They come to believe that they must be crazy because they believe the police so much. It's not able to be reconciled in their minds that the police are lying about what they have. That's incomprehensible, and therefore their memory must be wrong. So they will come to doubt their own memory, their own reliability, and then it's a whole technique that they use in Reed, where then they'll suggest, well, maybe you were just minimally involved. They'll offer ways that it could have been that doesn't tend to put you at the center of responsibility, and then they'll try to encourage you to imagine that, yeah, maybe that was possible, because it really wouldn't be that big of a deal if it did anyway. I mean, it's not like you were the ringleader or something like that. That's how they get people to implicate themselves. And it all starts with this, well, maybe it's possible. If you're saying you have video, then that doesn't line up with my memory. And so video is better than my memory. So my memory must be flawed. And if I can't rely on it, then I don't really know what happened. And I just have to trust you. Don't make that mistake. Don't ever make that mistake. Police absolutely will lie to you in an interrogation. So yeah, this is a very, very similar type of process here. Video evidence, I don't know. I don't know what it is. I don't know what you're talking about. I don't know what's on video. If you're saying I'm on video talking about the case, I don't remember that. I don't know how that could be. These all seem like personal, these all seem like perfectly reasonable interpretations of what the juror is thinking and how they're responding to this whole line of questioning. That's just it's so ambiguous. Not detailed, not substantiated. She doesn't have the information to be able to provide specifics. You don't even know when we're talking about. You don't know if we're talking about during the trial or not. We haven't even nailed that down. If the juror was talking about the case at the American Legion a month before trial, she's not in violation of anything. We don't even have a when this happened. Greg, this was the second time they tried tossing this juror. They weren't successful the first time. This juror reported another juror for criticizing Karen. Yeah, I mean, it sounds like she was not the only one that was involved in making that report. And her report was clearly substantiated because they tossed the other juror. They did the inquiry and they tossed the other juror. And how on earth anybody would think we should toss this one too for bringing it to our attention? It's just mind-boggling to me. Mind-boggling. You weren't forthcoming about your own conversations with the other jurors. Well, you weren't discussing the case. You weren't discussing the case. You were discussing the other juror's behavior. So not seeing how there's a particular violation of the rules here. Hang on. Had to do a little minor scold here. So yeah, I mean, the Commonwealth seems to have made it pretty clear that they had it in for this juror. They were going to, try to get her off. If they're going to rely on her doing her job, doing what she's supposed to do in reporting misconduct, then that makes it pretty clear. They're just gunning for her. Sentient Dreamer, under oath? Since people lie under oath, how is being or not being under oath material in holding anyone to account? What actually changes? Well, according to old Judge Nicol over in the UK, not being under oath is absolutely critical, because it's the only way that you can assure that the reliability of what people are saying when they are audio recording themselves in the act of abusing their, soon-to-be ex-spouse. That's not reliable because it's not under oath. Pardon me for, still having a little residual incredulity over some aspects of that UK case, the Johnny Depp case. The idea is that the oath raises the stakes. It raises the stakes. Even though we know as a practical matter, people almost never get prosecuted for perjury. As a practical matter, there are almost never any consequences for lying under oath. That doesn't mean that there aren't, in fact, any. There can be, especially for law enforcement witnesses, a situation where they could get caught. They could get caught lying, being deceptive, contradicted by, other types of evidence. And then that potentially becomes Brady material that needs to be disclosed. This officer, lied about this particular situation, or misrepresented the facts, misrepresented the evidence, something like that. So it can happen. But that's the idea, is that yes, people will be impressed by the solemnity of the oath. And so they will take it more seriously than if you're just casually offhand commenting to your friends. By and large, I mean, I think it's like directionally true. I think it's generally true that people are going to be more cautious about what they say under oath than when they're not under oath. But does that mean they're necessarily going to be more truthful? I don't know about that. I just think they are, they're going to be more careful about exactly what they say. They're going to use the wiggle words. They're going to qualify things. They're going to, use other tools to kind of work around what they don't want to acknowledge, that they don't need to bother to do with a friend. They don't need to try to protect themselves. If they want to lie to the friend, they'll just lie to the friend. So how is it material? I mean, in theory, because you might be charged with perjury, it's just that the reality, as we know, is that almost never happens. James Casatelli, why is there no mechanism to remove judges like this mid-trial? Why is there no oversight? Appeals afterward are not enough. Because that's, I don't know what to tell you. That's the way the system is set up. We give judges a lot of discretion to be able to make judgment calls along the way. If we allowed, every decision that the judge makes to be criticized, to be appealed up to a higher court and reviewed before the case can proceed any further, it would delay cases, even more than they already are. They can move to disqualify her again. They can do that. They can do that at any point. It's just that the standard to do that is extremely high. And that's an issue where it's not about the law being good or being bad. It's just the law is what it is. And so if the law needs to change, people need to start from the standpoint of understanding what it is, where it is. And the reality is, if you cannot establish actual bias, and actual bias in the context of a judge means they got a personal relationship to this case, a close personal relationship to the case, meaning usually family, or they have a financial interest that's somehow implicated by the case. That's pretty much it. That's pretty much it. Oh, I mean, if the judge has actually decided, what they think and who they want to rule for and who they don't want to rule for, that would count, but you're never going to be able to prove that because the judges aren't going to say it from the bench. And so it all just comes up in the context of the rulings that they make. Now, Judge Cannone has this rather bad habit of, taking these shots in her written rulings, in her oral deportment in court. That's not particularly helpful. It doesn't shed a very good light on her judicial demeanor. But, having a bad judicial demeanor that's not actual bias. Might be evidence of actual bias, but it's the fox guarding the hen house, guys. If you expect judges to say that other judges, shouldn't behave in a certain way because it looks bad, they don't want to do that. They don't want to do that. It's another club. It's another club that's happening at a different level. They know that if they apply that type of standard to their other judges, the other judges will then feel free to apply it to them. So the best thing for everybody is to just be really, really hands off. We'll all mind our own business, do things our own way, not call each other out. We'll call that professionalism. And then the reality is that you get judges that run amok, that do things that it shouldn't be hard to look at and say, this really looks terrible. Like it's really clear at this point. It's really clear. You are running interference for the Commonwealth and you are impeding the ability of the defense to proceed. That's what the standard is supposed to be for recusal, is the appearance of impropriety. But that's not the standard that people are held to if you're trying to get the judge booted off your case. It's not appearance of impropriety. It's actual bias. Why? Because appearance of impropriety, it's harmless error. Oh yeah, they should have recused themselves, but the only way it's not harmless, the judge is actually biased. So that's why. I mean, that's what the legal standard is. Is it a problem? Should it be revisited? Yeah, maybe. Yeah, maybe. Especially in jurisdictions like this where you don't really have accountability for judges. You don't have accountability to the electorate, to the people that, again, you're serving. Remember, that is your job. You are a public servant. You are not a monarch up there on the bench dispensing your justice. But when you don't have accountability, it's very easy to act that way. So who is her accountability to? It's to her political allies that put her there in place. And just like the judges aren't going to criticize what the other one is doing, that's not how the game works. It's not how the game works. We will all just mind our own business and let you do your thing, and you'll do the same for us. That's the trade-off. It's just the nature of power in a system. And when you have it, how you'll preserve it. It's probably not a very satisfying answer, but that's just the reality of it. If you want a mechanism, there needs to be a law to make that happen. Lawyer Nurse, did anyone see that Proctor's wife and sister are on the witness list this time? Any ideas why? I did hear Courtney. I think I would suspect that the reason for that has to do with the whole issue with Proctor testifying before about, the false testimony that he gave about Yannetti and Loughran going to the school, and asking about Courtney Proctor and just whatever, like it's some sort of intimidating thing. And in reality, it was nothing like that. They had just literally gone there to meet up. They didn't have contact with anybody. They, didn't ask about anybody. They just met in the parking lot and went about their business. So it might have something to do with that. Her understanding of the situation, maybe that she communicated to Michael Proctor. So it's not that he was actually lying on the stand. He was just misinformed. He was just relying on bad information, maybe, could be something like that. How else is she involved the relationship, right? Isn't she one of the connectors between Trooper Proctor and these other McAlbert figures? Doesn't that go through her? She's the one who's friends with, was it Julie Albert? Babysat the kids, stuff like that. There was some type of relationship there. So it could have to do with that as well. Elizabeth, I would suggest, I would assume, has to do mostly with the Commonwealth wants to get into, we've been so intimidated and all of that. The witness intimidation stuff that they want to try to use to suggest that's why Karen Read killed John O'Keefe, because, people have said mean things about the people that they think are really the ones that are involved in this incident and the cover-up. That's my best guess. I don't know. The defense knows because it has to be disclosed, like we just saw in the opinion. The substance of their statements needs to be disclosed if they're going to be called as a witness. So they'll be prepared for that. Elizabeth Proctor testifying to how intimidated she is not going to be a good witness for a Commonwealth. There's far too much impeachment material out there about her being combative and, engaging in her own little bit of muck throwing and so forth. So those are my best guesses. But that's really all they are, is just guesses. Janelle Woodward, brother counsel's brother Solomon indicated defense could get judge disqualified, I think, by repeatedly asking for mistrial outside of jury presence. There should be a way to get rid of truly bad judges. I haven't seen. I know that brother counsel did that interview with his brother. Haven't watched it. Maybe I'll go back and do that. I did hear good things about it. I heard people really enjoyed that. So I don't know exactly what his theory is for how this would work. The problem is that generally just showing a pattern of ruling for one party or against a party is not going to establish bias, because you have to rule for one party or the other party in the course of overseeing a trial. So the issue is really more like erroneous rulings, a pattern of erroneous rulings in favor or against one of the parties. But you don't know that until you've gone through the appeal process, because they're the ones who decide if it's erroneous or not. So I'm not necessarily seeing a direct pathway towards moving for mistrial, frequently, or even necessarily if they want to do that. That's part of the issue with the strategy is you got to make sure that if you ask for something, you actually want it. What if they get a really good jury? What if they get a really good jury? They have juror after juror after juror coming up to the stand saying, yeah, I formed an opinion about this case. I think that it's probably a frame job. And I think Karen probably didn't do it because I don't think they ever proved that she hit him with a car. But I can be open-minded. I can consider just what I hear at this trial. Most jurors are qualified. Jurors are qualified if they can be fair and impartial, even if they have opinions about it, as long as those opinions aren't fixed and they remain subject to being changed. So if you have a jury like that, you don't necessarily want a mistrial because you don't want to roll the dice on being able to get another good one. I learned that one the hard way. One of my very first jury trials, I had a really good jury. I had a kind of, nitpicky basis to ask for a mistrial. I did just because I could. Hadn't really thought at that point about, the possibility I might get a really bad jury panel the next time, which is what happened. I got a really bad jury panel the next time around. You don't always want the mistrial. So you got to be very careful about asking for it because you might get what you asked for. That's, one potential issue with the strategy. But how that would lead to a disqualification, I guess I need to watch what he says about that because I'm not necessarily following that line real clearly. But yeah, I mean, the standard is and always should be the appearance of impartiality. And if there's a reasonable basis to think the judge is being unfair, that should be enough to get the judge booted. And how do you establish that? I don't know. Maybe go and do a survey, something. If it reaches a certain point. I mean, how big of a deal is it really to change a judge? The judge is literally just supposed to be the referee. They're not supposed to have any significant influence on the outcome of the case. So they really should be pretty fungible. They really should be. It's just we know that they aren't. And so that's kind of the risk of it, is if you make it too easy to get rid of a judge, it's hard to do that in a way that isn't going to make it easy for the prosecution to go ahead and get rid of a judge they think is too favorable to the defense. So it is one of those situations where the rule would very likely cut both ways. Yeah, there should be a way to get rid of truly bad judges. I'm not against things like maybe having a review, independent review, retention, people who practice in front of her, people who have observed her, people who can compare her to other judges. I mean, we've now seen this judge, what's his name, Sisitsky, a couple of times. He's the one that's come in and handled the hearings when Mr. Bradel is bringing stuff up on behalf of Turtle Boy, Mr. Carney. Very different demeanor, very different perspective. Saw that one of the things that came up, oh gosh, was it yesterday, the day before? I don't even remember, but he granted that protective order that Turtle Boy had requested, finding there's substantial, compelling reasons to be concerned about leaks of information from the Commonwealth. Yeah, kind of a different perspective. So, things like that, where somebody's actual performance on the bench matters. There's some kind of metric to be able to evaluate it and determine if it's passing or not. If this is somebody that should continue in that position. It should not be something that's just appointed as a political favor, and then you get to hang on to it because there's no way to get rid of you. I don't like that system at all. I don't necessarily love judicial elections either, but at least we have the opportunity occasionally, every so often, if there's a really bad judge, we can just get rid of them. We can vote them out. Erica M. I hear a lot of solo cups, but never about why they were photoed in the Sally Port at all. Blood scooped at 6 a.m., car towed at 5 p.m. Someone had to bring the blood to her bumper to be in that photo. Why? Yeah. It's a great question. Why is it even there? If it needs to be documented by the Massachusetts state, the police, the lab people that came out, I think they're the ones that came out on the 2nd, did the whole, deconstructing the taillight and stuff like that. If we needed to wait for like the specialists to photograph it, okay, it's obviously not ideal, but yeah, that doesn't necessitate getting it out of evidence and bringing it into the Sally Port. You would just go into the evidence room and photograph it there. So it's a very, very strange series of decisions that were made all throughout this. And why? I don't know. Was somebody hoping to splash a little on the bumper? Maybe. I don't know. Doesn't look like they did. At least not as far as we know. I don't know what the thought process is behind that one. Bird, are any of the rulings favorable for Karen on appeal if she's convicted? Yeah, so any motion that's in her favor, there have been some, the whole like her opposition to redacting the manner of death from the death certificate. The Commonwealth, wanted their own expert to be able to testify about the manner of death, but not the medical examiner who made the actual determination in the case. Not her, just their guy. That motion was denied. So that's in Karen's favor. That's a ruling in her favor. She can't appeal that. She's not aggrieved by it. And there are decisions like that here and there. But any decision that the court has ruled against her, it's an option. It's a possibility. It's something to evaluate as a potential issue for appeal. One of the things that, I would like to do at some point is just there's so much. Sit down and compile some sort of a list, even if it's just like a top 5 appeal issues that I see so far in this case. There's a lot. There's a lot of appealable decisions that have been made. I would put the Betterow decision quite high on the list. I would put the discharge of the juror A, I would put that pretty high on the list. And the reason why is because those are essentially structural types of errors. It doesn't go to prejudice. You don't look at would the jury have returned a different verdict if you had followed the right process, if you had required there to be actual evidence in the record before you found that this juror had committed misconduct. You don't go back and try to evaluate that because, number one, that's trying to get into the mind of the jury and the preferences and so forth. The whole thing that Judge Cannoni has just called the clairvoyance. You're not going to get into clairvoyance to try to evaluate that. But the other reason is because that's not the point. It doesn't matter. The point is that she's entitled to this jury, whatever they would have decided. And so because those are really favorable from a standard of review standpoint, those are very high on the list. But there's so many things that go to the right to present a defense. Again, some of these we're going to have to see how they play out in the actual retrial, like with Mr. Easter. If she reconsiders and he gets to testify, well then, no, you don't challenge the ruling in limine because it didn't end up being final. It didn't matter. At the end of the day, it didn't determine what happened in the case. So some of it is a little bit of a wait and see. Some of the things that happened in the last trial are moot. They're moot now because they get a new trial. They get to try it over. Discovery issues, those can continue to arise, things that she should have gotten access to but didn't. Those just are difficult from an appellate standpoint because they tend to relate to things that are not in the record. Like the whole point is the judge said you didn't get to go and get that information. And so you don't have the information in the record to be able to show here's how the information would have affected the outcome of the trial. That's the type of issue that if you're able to get a hold of that information, you need to get it into the record. So you need to follow a post-conviction process, not a direct appeal, something that's more akin to a habeas petition, a motion for a new trial, something like that. Shaylin, love you, Andrea, fellow Pacific Northwestern here. I'm in Federal Way. The Canton Police audit is in. Yes, it was. Yes, it was. Still quite a lot to get through, but definitely some good juice there with respect to their examination of this particular investigation. Lawyer Nurse, love your work, Andrea. Yannetti stated his entire file has now been requested by the feds. Carl Steinbeck stated this means that they are not finished and most likely investigating the entire Commonwealth DA. I don't know, because the whole timeline of all of this is not particularly clear to me, and the basis for it is not particularly clear to me. The impression that I have is that the original subpoena that Mr. Yannetti got back last year or even before that, he understood that to be a continuing subpoena, meaning that he had an ongoing duty to produce information, consistent with what it was asking for. And so because of that, as he would receive new discovery from the Commonwealth, he would turn it over. It wasn't that he would get a new subpoena each time and then produce new information. It was that he understood that original subpoena imposed a continuing obligation. Now, if he's continuing to produce, that means that the Commonwealth has not released him from that subpoena, or not the Commonwealth, but the feds. The feds haven't released him from that subpoena. Usually if you have a kind of outstanding legal obligation out there that you're no longer needing to enforce, you do the person the courtesy of letting them know you don't have to comply with this anymore. This is done. I'm withdrawing it. You're under no more official obligation. So that is one more reason why, yeah, I kind of would expect the defense team to be informed by the feds if this investigation is being terminated, because the defense seems to be under some legal obligation. Now, maybe the feds see it differently. Maybe they never thought this was a continuing subpoena. It was just a one-time thing, and that's just Mr. Yannetti's interpretation. And so, they're not necessarily going to correct it. I don't know. I really don't. But I certainly think it's consistent with the possibility that the investigation has not, in fact, terminated, that it is continuing to move forward. Definitely think it's consistent with that. Does it prove it? Not necessarily. I just think we don't have quite enough information to be able to say that. But I do think that is a good insight. And yeah, especially if he is continuing to turn stuff over as he gets it from the Commonwealth, then at some point, somebody would probably pick up the phone and tell him, hey, you don't need to do this anymore. So the fact that hasn't happened suggests he's still doing it for a reason. It's not an inconvenience at this point. Hank's gaslighting methodology. After Fed's done rumor came out, Karen Reed was leaving a hearing and popped on a live stream on the courthouse steps, said, the investigation is not over. I would know. I saw her. I don't know if she would know or not. I really don't know if she would know or not. I don't know how she would know. I don't know. I don't know how to evaluate it. Maybe she thinks she would know. She's very confident that she would know, but she could be wrong. I don't know. Maybe she's right and she would know. Somebody would have told her why. I'm not sure. I'm not sure. You know, I tend to be a pretty talk is cheap kind of person, you know, like, okay, it's nice that you say that and that you think that, but you could be wrong. You know, words don't always necessarily have a lot of value. It's just too easy to misinterpret them. It's easy for people to be unclear and imprecise. It's easy for people to over emphasize, you know, what they know versus what they think they know, conflate those things and so forth. So I really don't know. I would want to know what's her basis for saying this. Why would she know? And if she's got a reason, good reason for why we should know, then I would put a lot more weight on the statement. That's just me personally. You know, I'm a skeptic. I am a skeptic. Can the defendant ask ARCA who they've done work for in the past who tends to use their expert opinions? Under the ruling in limine, it seems pretty clear that the defense is not allowed to elicit the fact that it was the Department of Justice that hired ARCA to do this investigation. And they're not supposed to really elicit that at all. So I would suspect that if they did this, they will get their wrist slapped. They'll get a talking to. It's in violation of the ruling in limine. You're not to elicit that, and they can't just get around that by, like, you know, pretending they were trying to get at something else. Like it's a little bit too obvious. If it were to come out incidentally, not because the defense is asking a question where that would be a responsive answer, the Department of Justice, and it just happens to get mentioned or it comes out or something like that. Or if Hank Brennan goes down the road of trying to do the impeachment for bias, very difficult to see how that's not going to open the door. Very difficult to see how that's not going to open the door. Because if they want to try to imply the defense had control over this, they had input into it and stuff like that, then the defense has the right to counter that and to say, no, we didn't even hire these people. This was part of the FBI investigation, and the Commonwealth knows that perfectly well because they know we both got the report at the same time from the feds. We both had equal opportunity to use the information at trial, present it to the jury, and only one of us was interested in the jury hearing that information. Find it very difficult to see how you can't go too far down that road of trying to suggest that they have some bias or some interest in the outcome with not opening the door to clarifying the situation. Now, will Bev see it that way? I don't know if her imagination is that fertile. I really don't. Seems to be awfully limited when it runs counter to what she wants to do in a particular case. So no, I don't think they're going to do this. It would be improper. It's eliciting information that they've been specifically told they're not allowed to elicit. Sentient Dreamer, Richard Allen, I realized how horrified I'd be after trial. I'd do research after the fact and would have found the state's case false at best. Sentencing an innocent person to jail like Richard Allen appalls me. Good. Good. It's an appalling case. It really is an appalling case on so many different levels. I do wonder about the jurors in that case. I think it's natural on the one hand when you have spent that much of your life on something, you don't necessarily have a continuing interest in it. You know, it's a big chunk of their lives. They want to break. They want to not think about it for a while. You know, maybe never again. It wouldn't shock me if there are jurors that never, ever go and follow up on anything that happened outside of court, any subsequent proceedings, any preliminary stuff, none of it. But yeah, if any of them do, what's that going to be like? What's that going to be like? I mean, if their basis was we didn't have an alternative explanation, and now you find out the defense actually had alternative explanations, you weren't allowed to consider that. You weren't allowed to weigh, here's how much evidence they had against these people. Here's how much evidence they had against Richard Allen. Is it really that much stronger what they have against Richard Allen compared to what they have against these other people? If that was a big part of the basis for your decision and you find that out, might you be a little disillusioned? Maybe. I would be. Definitely. How could you not be? You've been used as a tool. You've been used as a tool to achieve an outcome. You weren't trusted to be able to do the right thing based on complete information about the case. So you were just kept in the dark about stuff that might have mattered a lot. Yeah. If there are any jurors who did subsequent research, maybe they'll have some of that, but I don't know. Maybe they won't. Maybe they won't. Maybe they will have the perspective that they're so imbued with their own authority and their own power to decide whether he did it or not, and the process that they went through, and the reaching the unanimous decision, that no room to entertain any doubt, even at this point in time. People are remarkably good at rejecting information that tends to undercut their belief system, their worldview. Idea that they were wrong, people are really remarkably good at not considering that possibility. Time to get an audit for DA office and MSP. Yeah, those are probably up to the state. I'm not sure about the DA office. How exactly that works jurisdictionally, does the state have the authority to do that, or do the counties are they like independent branches of government that can't be told what to do by the state and stuff? I'm not sure. I don't know how it's set up in Massachusetts. Here in Washington, you wouldn't be able to do that. The counties are their own independent bodies, so it would be up to them. If the county, by way of the county commissioners that we have that run the county here, if they decided they wanted an audit of the DA's office, they could do it just like the town of Canton did. I'm not sure about how it works in Massachusetts, though. MSP, that would have to come from the state. Probably not a bad idea, though. Canoni's baloney. Bev's order on motion to dismiss. Trooper Proctor did shady shit, but we aren't going to ask him why. But Trooper Fanning, he'd never do shady shit. We won't ask him. He's an MSP, for God's sake. MSP would never accept Proctor. Yeah, I mean, you can kind of watch the outrage build to that crescendo at the final, and how dare you, because now you're getting close to accusing the court of improperly supervising or allowing these types of arrangements to be made where he might have access to information about the jury and the jurors that he shouldn't have. It's not his business to have it. Don't know how you're in charge of all the courtroom security without coordinating with those court officers. Sure don't know how. But we're definitely not going to ask any questions. I mean, that's what came through loud and clear, even to the point of acknowledging the record is unclear because we're not asking questions about this, but we're still going to decide it anyway because we don't really want to know. We don't really want to clear up that issue. This was very amusing. Thank you for that comment. Tracy Collins, can you explain how Brennan can introduce Karen Reed's statements without her on the stand, if not to impeach? Can he play the video for the jury? Can AJ cross with his own Karen Reed quotes? Is this a workaround, perhaps? So Karen Reed's out-of-court statements are hearsay. They are, under the hearsay rule, it's presumptively not admissible unless it falls within one of the exceptions. And one of the exceptions in Massachusetts is statements, admissions of a party opponent. And since Karen Reed is the party opponent of the Commonwealth, it's her name up there on the caption as the defendant, the Commonwealth gets to use her statements that are made out of court. So that's the hearsay element of it. That's how they get past it. It's an exception. Now, how is a practical matter? Do they do that? They have to authenticate, the video or whatever it is that they want to use to impeach her somehow. And so it just really depends on what exactly they want to do. What do they want to use? The challenge, I think, with the interviews is that at least the ones that were televised is that they're edited. It's not the full uncut interview. So you don't know if it's in context. You don't know if it's been altered. You don't have a good basis for being able to opine. Like you can say, yes, this is Karen and this is Karen's voice and it appears to be Karen's words, but you really can't speak to the authenticity of the video itself. So they would potentially need like somebody from production to come up with that, to establish that, this is the video footage, this is the raw video footage, and hasn't been altered. We didn't alter it. We provided it in this format, whatever, something like that. So that's one way that they could do it. We know they got transcripts of I don't know if they got of the like full uncut stuff, not for all of them. I mean, they're still asking for the ID, the one that just came out. But some of the earlier ones, like the Gretchen Voss interview, we already know, they were provided the off the scenes material. They have the transcripts and so forth. So for things like that, they might just be able to get it in through an officer. It's not real clear. I would kind of need to see the provenance of what exactly they have and what exactly they're relying on. But if they're in a position to say, we were provided the uncut video, we turned that uncut video into a transcript. This is the transcript. This is, statements made by Karen Reed reflected in this transcript. That might be enough. It might be enough to authenticate it. It's not typically a super high bar. There just needs to be some basis to conclude that this thing is what it's supposed to be. So that's two pieces of it. Third question here, can AJ cross with his own Karen Reed quotes? Well, that's always the $1 million question, because remember the hearsay exception is for statements of a party opponent. And Karen is not her own party opponent. So she doesn't get to introduce her own statements. That's how this game works. The Commonwealth gets to use it and they get to cherry pick what they want. Now, are you allowed to put it into context? The only way that typically comes up in a trial is under what they call the rule of completeness. And that pretty sure did come up. No, I'm thinking about Koberger. I've been reading so much. I had a lot of reading to do over the last couple of weeks. And so some things might be running together. But the rule of completeness is basically a rule that just says that if a party wants to introduce a part of a statement, the other party can ask for any other part that in fairness should be included with it in order to give it its proper meaning and make sure that it's fully in context and so forth. So that's really your only counter to the states cherry picking whatever they want to use. And so this happens all the time. It happens all the time. You might get an interview. You might get an interview where a guy says 10 times, I didn't do it. And then on the 11th time, he says, I did it. And all the state wants to put in front of the jury is that 11th, I did it. Whether you get to introduce those other 10, I didn't do it, depends on whether the judge thinks it's necessary for the jury to hear that in context, whether that's fair. Another area where there's just a lot of room for discretion with the judge to decide what's fair, what's necessary context, what is, adding to the statement versus clarifying the statement, et cetera, et cetera. So what the Commonwealth is allowed to do here is a lot more defined, a lot more clear and predictable than what the defense is going to be allowed to do. Their only avenue there is to argue these other statements that she made need to be considered to put, whatever statement she made in the interview in context. And it's up to Judge Canoni to use her fertile imagination to see if she can see that line of reasoning, see that fairness, and make the decision accordingly. Gwynne Garnett, can the defense use any of the report at trial? Maybe, and one of the ways that they can potentially get it in, if it's the type of thing that somebody like Mr. Easter would ordinarily consider is part of giving his opinions in a case like this, then he could get it in. If we're going to, reconsider, which we should anyway, and allow him to testify about the specific policies and procedures and so forth, then yeah, I would expect he should be able to get that in if he reviews it, if he incorporates that into his analysis, if he relies on it, and if it's the type of thing that that people would reasonably rely on to make judgments about the propriety of police investigations. Yeah, he should be able to do it. Anybody else? Maybe. The people who actually, did the things that are being criticized in this report, should the fact that the report found that these things were improperly done be able to be used against those people? In my opinion, yes, it should. This is a public document. It is a, business record. It's one of the hearsay exceptions. This is something that Canton produced for their own business purposes. It wasn't made, for purposes of this litigation. It's not like an exhibit that they prepared or something like that. It's something that they were doing as part of their own public business. So it should fit within the hearsay exception. So then why are you using it? We're using it to impeach. We're using it to impeach the investigation, which the statute says we have the right to present evidence on. So I would think that they should be able to. Mama Bear, the audit seems for only crime scene handling and image, not much else. A lot of we took their word for it, was hoping actual concerns looked at. Yeah, I mean, the executive summary did seem to leave a lot of stuff on the table. Maybe there's more, in the body of the report when we get a chance to dig into that and see if they flesh any of that out a little bit more. I mean, I definitely agree with you that when it comes to their specific criticism of the John O'Keefe investigation, they focused that on crime scene handling and so forth. But like I said, it doesn't necessarily mean that some of these other failings aren't implicated. I don't know if Kevin Albert's IA process is, it's part of the review. It's within the time frame, within the scope of what they were doing. Is anything particularly problematic about it? I don't know. I'm going to have to get into the body of the report to see if any other details, can flesh that out. But again, bear in mind too, this is just a critique of the Canton Police Department. It's not a critique of MSP. It's not a critique of MSP. It's not within their scope. They are just reviewing Canton and their roles. So, the big concerns for me, definitely whatever role the Canton PD had with the Sallyport stuff, the footage, and whatever happened to the footage and when did it get overwritten and by whom and so forth. Yeah, those things are quite concerning, even though the actual person that has been thrown under the bus as, you know, the wrongdoer, I guess, in all of this, even though we wouldn't even go that far. We wouldn't even go so far as to say Trooper Proctor should have turned this video over, just that it was inexplicably lost in his file and, you know, would have required clairvoyance on the part of the Commonwealth to know, to foresee that that this evidence should have been turned over as potentially material. So there might be other stuff, you know, that has some applicability to this investigation, but we just don't really know. Casey Catt, in a short period of time, the Reed and Birchmore cases show a real pattern of bad, corrupt, shoddy, and repeated inappropriate investigations. Some same people involved. Audit didn't mention that. Well, at least the executive summary didn't. The very fact that they're looking at the Sonder Birchmore and the John O'Keefe cases in particular, the ones where we know specifically that the feds got involved. We know that they got involved because we've got all the TUI stuff that they did in this case, and we have the fact that they are the ones who are prosecuting Matthew Farwell in the Sandra Birchmore case. Does seem to be a little bit intriguing. Like that would be a pretty obvious reason why you would focus on these two cases, because, you know, you're so bad that the feds are departing from your conclusions and your processes and so forth. They're not buying what you're laying down. That's not normal. It really is not normal for law enforcement to question other law enforcement. Remember, we've been talking about this club all day. And all the different clubs, they all work the same way. You mind your own business, I'll mind mine. Really not in the habit of getting in and criticizing what fellow police officers are doing. So the fact that they are doing that they're breaking ranks in this situation, is that in and of itself some cause for alarm? Yeah, maybe. Yeah. I mean, it certainly got my attention. Certainly got my attention when I found out the feds are doing this whole parallel investigation and not doing it hand in hand with the Commonwealth. We're having to go through TUI here to get the information. I mean, yeah, that gets my attention for sure. But yes, a lot of the same people involved. Again, the fact that we're limited to Canton Police Department in this audit is it kind of minimizes the scope of what the audit can really accomplish, because part of the problem here is that it seems to not be limited to the Canton Police Department. It isn't just them. It's how they're interacting with MSP, how they're acting with interacting with the Norfolk County District Attorney's Office, these other parties that are not subject to this audit, and the influence that they have potentially over how these things are unfolding over in Canton. So that is beyond the scope of the audit. And, you know, that's going to necessarily paint a picture that minimizes the significance of what's concerning here when you look at these cases in their total context. Edward Kirkpatrick, auditors consider video physical evidence. I didn't catch that. Did they say that in the report? They maybe did. I don't know. Or did they list it out? I'm not sure. I'm not sure. I have to go back and double check. Yeah, I mean, it's a fairly fine distinction. Like, usually if you can watch it with your eyes, you're going to consider it physical evidence, even if it's captured in a digital format. A lot of different ways you could look at that. So the fact that they had to, really scrape the barrel of the case law to try to find substantiation for that distinction, it wasn't helpful. Kaylee H., but they called the snowblower innovative. They did, and they were very impressed with how well it worked. They couldn't believe how well it worked. It did a great job. It cleared the snow all the way down to bare ground in a, 12 foot by 12 foot area, approximately. Big area right where John was. Found him that tumbler glass, that broken piece of glass. Weird they didn't uncover any plastic. Not a single one of the 47 pieces. Or those mysterious missing pieces that are still missing from the reconstructed taillight after the lab people went and put it back together. They did. They called it very innovative. Honestly, of all the things they did, the snowblower is probably one of the ones I have the least issue with. No, it's not ideal, and no, it isn't how you should do it. But relative to blood evidence in solo cups in a Stop and Shop bag, no, don't even get me started. Relative to the chain of custody, the logs, the evidence logs, the lack of them until the evidence makes it over to the lab, that's a much bigger problem. Much bigger problem to me than the snowblower. But a lot of that stuff was, MSP. Wasn't Canton PD. Casey Cat, Bev admitted to knowing the Alberts and McCabe's at the first, I think that's recusal hearing, but said she could still remain unbiased. Yes, she did. She searched her conscience thoroughly and is left with an abiding conviction that she can be fair and impartial. She won't be affected by any of that. Yeah, that's how difficult the standard is to establish actual bias. The fact that it's a good friend, probably not going to be enough. It should be enough if the standard is impropriety, appearance of impropriety. Would a reasonable person looking at this situation think, oh, these are the judge's childhood friends. They hang out socially. Of course she can be fair and impartial. I think most people understand that you're probably going to give the benefit of the doubt to your friends. I think most people can understand that. So if that were the standard, the way it's supposed to be, then yeah, she should be off the case. But because appellate courts, hang on for a second here. Had to do a quick scold. Because the appellate courts don't like overturning convictions and they like coming up with reasons to not have to do that, we just get back to this harmfulness of the error. Is it a no harm, no foul situation or not? And the only way you establish that it's harmful is by showing she was in fact actually biased. And you can't establish that just by somebody had a friend. It's not impossible that a person could, be objective about their friend. It's not impossible. We just think it's, probably unlikely, probably not real consistent with most people's common experience. But they let the judge decide that. Yeah. She examined her conscience. Lucy Fair. Hi, Andrea. Could Bev's talk with Karen at sidebar after scolding AJ include notice of Bev not trusting AJ and that her rulings may reflect that? If she did say that, that would be a pretty big problem. Because now she is saying she is biased. That would be acknowledging bias. Saying that she's going to, issue rulings based on her judgment, her prejudgment of, what AJ may or may not be doing. Instead of taking it case by case and based on the facts, she's going to hold something against him. That would be admitting bias. So I doubt she probably did that. I am very curious about the sidebar conversation, though. I mean, the way that she described it in court was she just asked Ms. Reed if she wanted to continue with her current counsel. Yes, she does. And so you're not going to remove them, and you're not going to not let ARCA testify. And so there's, no sanction for any of this. I mean, did you think she was going to say, yeah, I've paid them hundreds of thousands of dollars, but I want to go ahead and boot them now over this? You really think that was going to happen? I don't know what all that was about. I really don't. If Karen says, yes, I want to not have them be my lawyers anymore, what do you do now? What are you going to do now? You're not going to make her go pro se. I don't see you getting to make her go pro se. If you're saying the attorneys misrepresented something, that's not something you punish her for. So what, are you going to continue the trial? She's going to get a new lawyer, get up to speed. Like what even was this about? It's very perplexing to me. I definitely do wonder if there has been some kind of advisement, not along these lines that, oh, my rulings might show I don't trust your lawyers anymore. That would be an admission of bias. She's not going to do that. But something along the lines of this could jeopardize, your trial if this conduct is repeated. I may have to remove them. And then you're going to be, in between a rock and a hard place. And you need to know that as you're making your decision about whether to go forward with them or not. Potentially could have been given some kind of advisement like that. Don't know. And unless it gets put in a court filing now, we aren't going to find out. They can't answer questions about it. They can't make extrajudicial statements about it. So very curious about that sidebar conversation myself, because her own explanation for it is like, why? This is not adding up to why you do that unless you are using it for purposes of, delivering a warning about this is what could happen if you don't, I don't know, do what I want, I guess, implicitly, and get rid of them yourself. Then it's going to be at your peril. Nikki, Yannetti hasn't sent discovery to the feds since January. Commonwealth discovery number 57. We're up to 61 now. March 25 was referencing when Brennan found out about the subpoena. I don't think this new info from Brennan proves either way. Yeah, if he's no longer providing it, don't know why. Could be consistent with the investigation not going forward, being concluded. It could be consistent with you're in the middle of trial prep and you're really busy and you got other priorities right now. Could be a few different things, but yeah, I agree. Brennan was saying he just found out about the subpoena on March 25th. Not that that's when David Yannetti got subpoenaed. I did see some kind of confusion about the timeline, mostly on X. Some people did seem to be conflating those two things. No, I didn't understand that there was a new subpoena to Mr. Yannetti in March. The issue is that he had been complying with the original subpoena on an ongoing basis, and then March was the hearing where Mr. Yannetti announced that in open court. I got a subpoena for my file and I turned everything over. That's why ARCA got what they got. The feds had access to all of it. They chose what they wanted to provide. I didn't cherry pick what I provided to the feds for them to then feed to ARCA. So that was the context in which all of that came out. So I hear that Ted Daniels is reporting that The first day of jury selection is concluded in the Karen Reed trial. 2 jurors have been seated out of the 62 screened today, back for more tomorrow. So they got through 62. It's about half of their panel. It's about half of their panel. Gonna start getting real complicated with moving the people through the process, isn't it? 'Cause we're already backed up. You probably already had another 100 and some scheduled to come in today, 100 and some scheduled to come in the day after that. How exactly are you going to work through all these in a way that's efficient for everybody? I don't know. I really don't know. That's why, when we talked about this before, I said that the way that I have typically seen this happen in the past is you just bring in a bunch of people to do the questionnaire and hand in the questionnaire, and then you send them all home, and you just call them back when it's time for them to be able to do their individual questioning, especially once you get a sense of how many people you're going to be able to work through. If she thought they were going to be able to work through all 120-ish people today, which is kind of what it sounds like she did expect, they're at, half that rate. They're going twice as slow as she anticipated. So just a logistical bottleneck dealing with panels this size. But so if they have 2 seated, okay, we get 2 a day. We got about 8 more days to go, 7 more days to go of jury selection. We'd be well into next week before the trial is getting started if that rate continues. So that means probably a lot of people have been challenged for cause, have been excused for cause, because we have only 32 peremptories collectively between the Commonwealth and the defense. Far more people than that have been excused, and it's also very unlikely that everybody exercised all their peremptories today. So this bodes for a quite extended jury selection process. 2 seated, and what we're doing 4 alternates again, 16 total, 7 more days at this rate. Edward Kirkpatrick, Canton PD audit says can preserve recordings for 800 days. So why 30-day auto delete? Oh, that's quite an interesting little find there in the audit report. I can't wait to go forward to this thing. I have a feeling there is going to be some juice in here in the real goods of this audit. The executive summary is just a summary. It's an overview, not necessarily giving you all of the things that might matter in the particular case. So, yeah, good question. Why the 30-day auto delete, and also when? When did that become the policy? I'll be reading that once we conclude here. I'll be taking the time to go through that report and see what else is in it. Tilly T, seeing lots of Andrea is the best. Do I detect bias? You detect informed. You definitely detect some information. I ain't hiding that I got opinions about this case, and I have based my opinions on what I've seen. What I have seen is not impressive. It does not impress me. Not impressive. Yeah, it is a lot of me today, huh? We're coming up on 8 hours here. We just went ahead and waited to see if court was going to do anything. Now that we know this is kind of where we're at and this is what the process is looking like, I'm kind of thinking I'm going to hold off. I don't want to stream every day for like 2 minutes, if we even get that much feed out of the courtroom. Every time she brings in a new panel, she'll give them these same advisements. I don't know if they're even going to be televised at this point. Everything is kind of up in the air. From my perspective, I don't know that it's really substantial enough to want to get on every day and spend 8 hours every day on it. So I think what I'll probably do, at least on a, playing it by ear kind of basis for now, is just go ahead and plan on going back live once we're into the opening statements or pretrial rulings or something like that. That still needs to happen. I might, in the meantime, put some stuff out about everything that's still on the table. I mean, I have this whole list of stuff, everything that came out while I was in Las Vegas. What do we have here? The motion to dismiss was denied. We got that far. The buffer zone was expanded. We haven't talked about that. Victoria George appeared. We haven't talked about that. Dr. Wolf, the neurosurgeon, was allowed. Karen Reed filed her motion for the headphones to have be able to listen in to the sidebars from sitting at her table. That's been denied. The Mr. Gilman, the weatherman, has been allowed. The First Circuit has denied Karen's writ and, simultaneously the stay. So that whole process is over. The manner of death from the medical examiner is going to be allowed. There's a new specific motion for specific discovery from the defense where they want to know about quid pro quos, any reluctance on the part of witnesses to testify, benefits to them, and so forth. Haven't talked about that. Commonwealth has also filed a motion for reciprocal discovery about ARCA, where they want more stuff. Defense simultaneously, same day, filed their notice of reciprocal discovery, indicating that they have provided everything that was being asked for. We haven't talked about any of that. The response to Mr. Welcher's PowerPoint, the fact that he didn't really change anything after indicating, a lot was going to be revised. Haven't talked about that. Order excluding Michael Easter, we did go through that. We talked about that. The order denying the mention of Department of Justice or the fact that they were hired by ARCA, hired by the FBI, we didn't discuss that. The spectators and the media being prohibited from giving physical descriptions of the jurors. We haven't talked about that. And that one is a little juicy. The third party culprit ruling, Colin is out. Don't get to say Colin Albert is maybe the one who killed John O'Keefe, but we can say maybe Brian Higgins or Brian Albert, but not an opening. Haven't talked about this either. This is another peculiar ruling, and a renewed motion to exclude Garrett Wing, the dog bite guy. Next, yet another dog bite guy in a case that I don't know. Kind of matters. The story of those injuries to John, kind of really important in sorting out what happened to him in those final moments. So anyway, a lot still to go over. I may go live to do that. I may record something while I'm doing my other chores. I did that before with the Juror Ronnie interview. I still have bone's eyes to repot. I have some big ones to do. It may require me to pause and focus a little bit for a few minutes here and there. But we are getting very late in the season and I need to get that done. So if folks enjoyed that, that's a pretty convenient way for me to be able to share some thoughts while I'm also, attending to my beings around the house. So that's kind of my short-term plan. Not going to plan to stream the trial every day for jury selection. I'll wait until they're getting into something more substantive. But I reserve the right to change my mind about that if it turns out that we are getting to see a little bit more, or there is a reason to pay closer attention to it. I might go ahead and change my mind. So that's kind of where I'm at as far as the short term and seeing lots of me. And I guarantee you, once this trial gets underway with the evidence, you will be seeing a lot of me. It will be a lot of early mornings for me. We've been through this routine before. You guys know the routine. You know the routine. I'll be here. Casey Cat, and evidence wasn't turned over to the lab for 45 days. Yeah, it was in March, I think. Sat there until March. And then it was March 5th. And that's when they finally got the chain of custody log started. The lab had to do it because nobody at MSP could be bothered to formally book things into the evidence system, produce a chain of custody. Yep. We're supposed to just trust that. Just trust me, bro. You've shown you're not trustworthy. That's why people can't just trust you. And that's why they criticize you. It's really not rocket science, not hard to follow. Tilly T, by the way, I think Andrea is the best too. Lovely chatters and mods here too. Thank you from IK. Well, thank you. Appreciate that. And we do have great chatters and great mods here. Very grateful to all of them for hanging out with us and just helping it be a good scene for everybody. We want everyone to be able to share their opinions respectfully. It's really it. You know, if you're going to be an asshole, it's not a crime. It's not a crime. But, you know, at a certain point, you bring down the vibe and we're going to do something about it. But by and large, you know, we don't have a problem with different opinions and perspectives and stuff like that. That's it's one of the benefits of the First Amendment is having that marketplace of ideas and people being able to freely debate and exchange ideas about things. And you know what? If you don't like something that somebody has to say, you've learned something about that person when they say it. You know, if you muzzle people, you don't learn who they really are. So just one of those things to bear in mind. Nikki, if the jury is supposed to presume innocence, is the Commonwealth allowed to kick jurors if they say they think she's innocent? If they say they can't change their opinion or they would not change their opinion based on what's presented to them in the courtroom, then that's cause because they're not able to be impartial. Having an opinion in and of itself is not disqualifying in either direction. Now, I tend to agree with you. Every single person at this stage of the process should have the opinion that Karen Read is innocent, because legally that's the posture where we're at. She is innocent. Commonwealth hasn't met its burden of proof. If we took the vote right now, the vote would and should be not guilty. But that's just kind of a legal, a legal fact. And that's not what most people mean. I think when they say they think she's innocent, when people say they think she's innocent, they're not saying I've formed a, legal conclusion based on the elements of the charge. They're not saying that. They're saying, I think she didn't do it. And so can you be open to new information that might change your mind and get you to think that she did? That's the core inquiry there. And it goes the same way for both parties. Because if you can't do that, you can't do the job of being a juror. You wouldn't be able to follow the oath and to only consider what you're presented in court as the basis for your verdict. You'd be relying on what you already knew coming into the courtroom. And you're not required to be a blank slate, but you are required to be able to put that aside. So Tilly T, Andrea, no, I meant bias in chat saying you are the best. Nothing about case. Sorry. Oh, my bad. Well, I'm sorry to make you have to clarify that. But it's always a fun opportunity to remind folks about the difference between being biased and being informed. We all have biases. We all have biases. Of course I have biases. I'm a human being. Of course I have biases. Talk about them all the time. When I look at cases, I look at them from the framework of the job that I did for almost 20 years as a defense lawyer. That's what I understand. That's the universe I understand. That's what's instinctive to me. So that's how I evaluate the information is through that filter of somebody who has practiced in that area of the law. Does that mean I think every person accused is innocent? No. Yeah, that's a big no. Big no. Has nothing to do with my evaluation of the facts in any particular case. Tend to be pretty skeptical. Pretty skeptical. Does that favor the defense? Yeah, it does. But that's because you're supposed to. You're supposed to be skeptical until the state has proven beyond a reasonable doubt. So, for me, talk is cheap. Show me, don't tell me. If you're having to argue to me about why you've established something, or tell me it's real clear when it's not, your evidence really should be able to speak for itself, because we're smart enough to be able to look at it independently and form our own opinions about it. And so people characterizing it doesn't carry weight with me. I want to see the facts, and then I'll make that decision for myself. So that's how I see the difference between being biased and being informed. I'm biased in the sense that I will always see things through the lens of a defense attorney, because that's my background and that's my familiarity. I understand their role in this process, the decisions that they're faced with, and so forth. that's what colors my analysis. I've never been a prosecutor, so I don't really have a lot of insight into, the decisions that prosecutors make and, just that whole side of it. But when it comes to evaluating the facts and what happened, well, it's based on the evidence. And being a defense attorney doesn't change that one way or the other. Defense attorneys, aren't like exempt from reality. And you certainly better not be. You won't be a very good defense attorney if you aren't able to look at the evidence and see for yourself. Jury isn't going to like this. Jury's not going to think kindly about this. You got to be able to get out of your own perspective. So, Edward Kirkpatrick might want to go through Audit and download the live link calls before they get taken down. Carrie Roberts might get crossed. Oh boy, sounds like I need to be in a rush to get this information. I will trust that there are people out there that are already doing that. I'm sure it will be out there. Maybe my girl Sleuthy's already on it. I don't know. If she's not, she's probably sourced it. So a lot of folks with the interest in making sure there is a complete record on this one. So I will go through that audit probably this afternoon. Oops. Sorry, I think I just, didn't I just skip one? And I unstart it. Oof. I'm sorry, I don't remember if I skipped a comment there. That is absolutely my bad. Adjust your robe, Bev. Your bias is showing. In this trial, should they question more as to why CERT was used for evidence collection instead of crime scene services unit? Yeah, I think they should. I think that's valid. This is not the evidence collection team. This is the crowd control team. These are the people that you send out to contain the streets, to have a show of force, things like that. These are not the people that are the specialists trained in evidence collection. And we see that in their work product. The photographs that they take that are not to scale, that are not showing things in context, they're not showing things in their location, when and as they were discovered. They're just kind of random pieces of plastic laid on top of lumps of disturbed snow. Clearly not trained in evidence collection and documentation. So I think it's fair ground. Absolutely. And again, this is the type of thing that you would expect Mr. Easter to be able to shed some light on. What's the difference between units like this? What's the difference in their training? What's the difference in their expectations? What's the expectations for the detectives, the people that are in the decision-making roles about when to call out support, who to call out, and so forth? What sorts of standards apply to them when deciding, should I call CERT or should I call crime scene services? I think that's all fair game, and it's stuff that that is potentially, within the purview of an expert on these types of groups, these types of specialties when it comes to organizations within law enforcement, the training that's associated with it, and so forth. Because yeah, it's reasonable to ask questions about why these guys. Why these guys? Why not the crime scene services unit, the ones that have the actual training to do this? Oh, I imagine we might get a because of the snow answer. Seems to be the answer for everything. You can't do anything, apparently, in Massachusetts when it snows. So you guys must be getting like absolutely mobbed, looted 4 to 6 months out of the year, no law enforcement when the snow is falling. I think it's legitimate ground. Curious to see if there's anything about that in the audit as well, since they did focus on crime scene and evidence retention and so forth with the MPD. Obviously, it's not going to go specifically into CERT because CERT is MSP. By this point, MSP is in charge of the investigation. It's not really Canton's call, but they should have secured it at least until that organization got out, according to the report. So. Duncan, Idaho, the idea that none of these pieces of taillight were visible or seen by anyone at the scene and only turned up over the next weeks is so ridiculous. Yeah, you want to talk about what's in the realm of common sense for a juror. I'm sorry, but okay, if this point of impact happens on the side of the road, like where Trooper Paul said it happened, I'm sorry, but some of that taillight is going to end up in the road. It's not going to all fly out into the yard. I'm not buying that. I'm not buying, like, what even is this angle supposed to be? So some of this taillight's going to end up in the road. And if some of this taillight is going to end up in the road, it's going to end up getting plowed. Okay. Snow plow passes how many times just during the course of this single storm? So who knows where that taillight, that plastic taillight is going to end up. It's going to have been moved and relocated. And then as berms are built and snow is moved around. I don't know. I've seen a lot of heavy snow removal up in Tahoe. I mean, talk about snow. Law enforcement doesn't stop in the snow up in Tahoe. It's pretty normal, just a thing you deal with. But have to move huge volumes of snow sometimes. And so, you bring out the front loaders and you cut this berm here initially, but then you relocate it over here. I don't know how much you got to do stuff like that in Massachusetts, but bottom line is things in the road are going to get moved around. And so you're going to have me believe that the only pieces of taillight that you couldn't find that might have ended up in the road were just those ones that are all conveniently in that one piece of the taillight, the one that looks a little bit like maybe a small crack, like one might have done, backing into a traverse, one that might meet the description of what Officer Barros from Dighton described, cracked, not completely missing. I'm to believe that those are the only pieces that maybe ended up in the road and couldn't be found. I don't buy it. I don't buy it. That's common sense. You're not going to tell me that some exploding taillight exploded with such a pattern, okay, not randomly, but just such a pattern that the only pieces we couldn't recover that ended up in the street and got plowed away or something were the ones from the same part of the taillight. I'm not going to buy it. It is ridiculous. It's absolutely ridiculous. I saw, you see lots of little things around, and it does seem like there is a lot more interest in this case the second time around. A lot more eyes on it, a lot more people speaking up. Somebody, I think on TikTok, I saw it on X. I'm not on TikTok, but people repost things on X. There've been some really good things, really enjoyable things. But this was a TikToker who is from the area, or claims to be from the area, had photographs from like her front porch or back deck or something like that for the days following the snowstorm, and like within a day or two, all the snow is gone. And you're trying to tell me it took like 2 weeks for you to find all of these pieces of taillight, and that nothing happened to it in the meantime. It was just undisturbed. No, I'm not buying it. I'm interested to see if the defense can't maybe turn the weatherman to their benefit for something like that. How snowy was it really in the coming days? How long did it take for that snow to melt? I don't know if you can opine about how hard the ground gets once it starts to snow. Surely he can opine about how long it takes for the snow to melt. Yeah, I agree. It's ridiculous. And it's especially ridiculous on top of the whole snowblower story. You took it down to bare ground. You were out there at the time when there was the least amount of snow for anybody to have to deal with. You cleared it out all the way down to bare ground, which, by the way, you had to do because John O'Keefe himself was not on bare ground. He was on snow after it started to snow. So you had to clear it down to bare ground in a 12-foot by 12-foot area, pretty sure is what they said. 144 square feet, and none of the taillight happened to be there. You found the glass there. It's all supposed to be pretty much in the same area. You didn't find a single piece of taillight. No, it doesn't pass the smell test. It doesn't pass the smell test. Nobody saw it. Reflective material when you got all of these lights out there, it's dark. It's literally, the situation is prime for that reflective material to do what it is designed to do, to catch the light in the dark and get your attention. And none of it doesn't pass the smell test. Duncan, Idaho, also hilarious that was the night of the butt talkers for half a dozen phone conversations. That many coincidental butt conversations. This is where I think it gets to the reason why people are so outraged about this, and the reason why they are directing that ire at the law enforcement who is supposed to be asking the hard questions about things like this, instead of just accepting at face value, oh yeah, well, they said it was butt dials. That seems reasonable. Does it? Does it now? Because it doesn't to anybody else. It doesn't seem reasonable to anybody else. Nobody else that you confront with a Celebrite record that shows them having a phone call of a certain number of seconds and tells you that that's a butt dial, nobody else are you going to believe when they give you that explanation. You are, in fact, going to use it against them and say that, they denied, they offered this, ridiculous explanation. You're going to see what we all see in this particular case. And so it's the fact that you haven't done it in this particular case. That's what people are angry about, because they can see for themselves how you're like flaunting the double standard. Yes, this is ridiculous, and nobody buys it, and nobody should buy it. It's a ridiculous explanation that they would never accept from anybody that they didn't want to protect, want to clear. Because everybody knows that butts don't answer calls for 8 seconds and then hang them back up after the butt dialed it, the first time. Little bit of a remarkable set of coincidences. Nobody buys it. So yeah, distrust in law enforcement, distrust of the system and the process. Maybe have just the tiniest little bit of reflection into your own role in creating that environment. Maybe just turn inwards a little bit, reflect. Could I have done something differently that would have generated more trust in me and my investigation? Maybe if I hadn't just bought this ridiculous excuse from these people that I've already texted to all of my buddies aren't going to get any heat because of the fact that he's a cop and that's it. Maybe that's why people don't trust it. Just a suggestion. Nikki Mick, Jen M told 911 that J.O. was face down and just turned him over. I don't think this was explored in first trial. Moving body changes a lot. Thoughts? You're right. They didn't really explore it in the first trial. And so I don't know. I don't know if they will or will not. face down changes a lot just in terms of kind of the mechanism of the injury and the accident. They got to explain, why does John O'Keefe have nothing but these very superficial abrasions and contusions, and then the skull injury on the back of his head? If he was thrown and tumbled, landed on his back, but like tumbled and ended up on his face, or he's struck in the back by the car and thrown and lands on his face, aren't you going to expect more bruising? I got hit by a skier going downhill. I think I've told this story before. Not even a car, but it's enough. It's enough force to get you thunk, 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 thunking. And was I bruised up? Boy, was I. I was the lucky person in the snowboard, my feet strapped in, so I didn't tear up my knee, unlike the guy that hit me. Absolutely destroyed his knee. Play stupid games, win stupid prizes, unfortunately. But that's just the force of being hit by another person. I got to think you're going to be pretty bruised up, especially if you stay alive. Their whole theory is he didn't die instantaneously. That doesn't fit. It doesn't fit with the rigor. It doesn't fit with the blood, the bleeding. Your heart stops, you don't bleed anymore. That type of thing. It doesn't fit their story. So you got time for these inflammatory processes to work enough, to get the eye swelling, the explanation that came from the skull fracture. That's their claim. It took time for that to happen, and it took time while the body is still alive and still engaging in these processes for that to happen. So I don't know how all this is happening and you're not getting massive, tumble injuries if you're being thrown some kind of distance, coming to a stop on your face. So that's a part of it. It has to be incorporated into the mechanism of the accident. How did John land on his face? Or how did he end up on his face if that's where you found him? And then it has to be incorporated into, what is the evidence at the scene as best as we can tell? We have to maybe incorporate that into, where's the blood? And how does this fit in with the blood patterns that we do have? I think it's a lot harder to explain, why is there a bunch of blood dripping down his front onto the top of his shoe, and a bunch that dripped down onto his back from the back of his head, if he was supposed to have simply been thrown and landed on his face. It's not how the blood's going to flow. It's going to flow around. Face is down, gravity, very simple. It's going to flow around. It's got no particular reason to just go down your neck. And so when it flows down, what's going to happen? Where is it going to go? It's going to be on your face. It's going to be dripped underneath your chin. Where's the blood has always been a big problem in this case. Where's the blood from the cut? The laceration over his eye. Where's that blood? Are those the spots that they collected? I don't know. It does definitely change some of the aspects of the case. I'm not sure, if the defense didn't really get into that in the first trial, are they going to get into that in this trial? I hope so, because again, for me, that's what matters. The details of showing that this explanation of what happened to John doesn't fit the evidence. That's really where the heart of the case is. That's what Ronnie told us. And it just makes sense to me intuitively, because jurors want to give everybody the benefit of the doubt. They don't want to reach the conclusion that somebody else deliberately did this, deliberately set it up for somebody else to take the fall. It's hard for them to buy that. So focusing on that piece of it, just from a strategic standpoint, I think we learned from Ronnie that could maybe be improved upon. And this is one of the areas where you do it. You focus on the physical evidence and the impossibility of things happening the way that the Commonwealth said that they did. That in and of itself is reasonable doubt. So plenty of reasonable doubt that can be built from the pattern of the blood as I saw it. Watching that trial, as soon as I see the front of that shirt, pants, onto his shoes, I'm done. I can't even, just last Monday, okay, I got back in the ring. First time since I was down in South America. Not in my ring shape yet. Got a little worked over. I'm a bleeder. It happens. I have this exact pattern on my clothes like 2 weeks ago because it's like, the 100th or so time that I've bled in a fight in the ring. I know what that looks like. So as soon as I saw the clothes and I'm like, wow, I've bled like that a million times when somebody's punched me in the nose. Yeah. That's when you have a hard time convincing me that this guy was hit by a car and landed either on his back or on his front, landed horizontally, and yet produced this blood pattern. That's not how gravity works. He had to be vertical for it to get on his shoes. So I do hope that this is the kind of thing that they explore more because, I think there is a lot of potential hay to be made with that type of evidence. Edward Kirkpatrick, how about someone saying, I will turn over my phone, but can I delete some non-relevant convos with daughters first? Sure, go ahead. Oh, why wouldn't we trust these people? Why wouldn't we trust these people? I'm sure they'll apply the same standard to you or me when we get stopped in Massachusetts, won't they? They'll apply this same standard to us when they take our phones and want to use them as evidence against us. Why wouldn't we trust them? Yeah, if the audit doesn't address this type of thing, I mean, the problem again, it's just the problem with the scope, the difference in scope between the Canton Police Department's responsibility and the MSP's responsibility when it comes to who decided to do what in this particular case. I don't necessarily hold out a lot of hope for the audit to shed light on some of these things. Some of these, while we're talking about opportunities for improvement, ways that you might internalize some of the reasons for this criticism that you're receiving and why it has gotten so strident, because you are refusing to hear it. And so people are getting louder and louder and louder. Because when they said it quietly and politely, you didn't pay any attention. You just dismissed it and you kept going about business as usual. So now it's at a crisis point and they're yelling at you. Are you ready to listen yet? Are you ready to listen yet? Color me skeptical. Damaris San Giuliano, the world is watching Judge Cannoni, Commonwealth, and relevant law enforcement, but it doesn't seem to matter. Just like in Delphi, makes me sad. Only bright side is watching your coverage, hoping the defense team kick ass. Well, that is nice of you to say. I definitely, of course, I appreciate, compliments about my coverage. I don't know if it doesn't matter. I really don't know if it doesn't matter. I think there are good indications that it does. Like we said, this information in the report where they're talking about how much blowback, at least in the law enforcement's perspective, they have gotten for their mishandling of this investigation. That tells me if that's true, and that's not just them being crybabies about getting any criticism at all. If that's true, and that is a widespread perspective, that's a very good thing. That's a very good thing. People have had enough. I mean, just the fact that the Canton town, the town of Canton, was able to be persuaded to spend the money on this audit. That's indicative of some pretty significant demand. We're only seating 2 jurors out of 62. Don't know how that's going to break down with have people prejudged it or not. Don't know how that's going to break down. I still haven't finished the documentary, the most recent one. I think we made it through like 2 episodes and we're into the 3rd. So getting close. So far, doesn't really seem terrible. It's not all inclusive, of course. They never are. They always make judgment calls about what they include and what they leave out. And of course, they want it to be dramatic. So they try to, kind of present it like it's a big back and forth. First we're going to present it like she really did do it. And then we're going to present it like she really didn't. It really was a frame. And, try to kind of keep you on the cliffhanger for every episode. So that can be a little bit over the top and maybe give a bad impression about the respective weight of the cases. Especially how the documentary seems to be focusing a lot more just on emotion than on evidence. It's the fact that people are mad. People are mad that Karen is contesting it. Like that's what they're covering as their kind of outrage. Not evidence that she hit him with a car, but just people saying, I can't believe she's doing this. I can't believe she acted like this. It's just sheer emotional manipulation. It has nothing to do with what the jury should or shouldn't do in the case. But anyway, I'm bringing all this up just because we don't know where people are getting their information. And so, yeah, the tone and tenor of the media coverage, I don't tend to expect good things from mainstream coverage of criminal cases. I just don't tend to expect good things from it. For whatever reason, nobody wants to get the Pulitzer for exposing all of this misconduct, all this shit in law enforcement that we see over and over and over. We see it over and over and over. And nobody wants to be the one to be calling it out. Why? I don't know. Might impair their access, might limit their ability to get information in the future, might make things unfriendly to them when they show up at the courthouse. You gotta kind of pick your allies sort of situation. And that's really not what journalists are for. I gotta point out, I'm gonna wrap up real quick here, and I'm gonna have more to say, in coming days, but this order that spectators may not describe physical characteristics of the jurors. This is so far over the line. It's so far over the line. Where is the media challenging this? Now, again, nobody is saying, oh yeah, we should be able to dox the jurors. Nobody wants to dox the jurors. The press routinely sits in on criminal cases where they know who the jurors are, and they still don't dox them. So we can take it on faith, at least as our kind of starting point. It's probably not what anybody wants to do. Now, can there be bad actors? Of course. Of course there can. But are you fixing that by saying you can't talk about the jurors? You can't distinguish this juror by that one from that one by saying this juror over here is an elderly lady with white hair, and this lady over here, this other juror, appears to be of Asian ethnicity, middle-aged. You're not allowed to say that? How is that narrowly tailored to keeping people from doxing the jury? It's not. It's not. So this is very far over the line, and it's very much intruding into an area that journalists conventionally do talk about. It's the whole reason, one of the whole reasons to go to the courtroom at all when you have a case that's being televised because we don't get to see the jury. We don't get the vibe in the room. We don't get to gauge who they are, what are they thinking, how are they responding, how are they interacting with each other, what are they paying attention to. These are very, very classic observations about the trial process that journalists routinely make. And this order, this is a substantial impairment of their ability to be able to do that. Where's the challenge? Where's the challenge? Are they going to challenge it, do you think? Kind of would have thought they would already. Guess we'll see. Guess we'll see. But we can't count on the media to be the defenders of the public anymore. We can't count on them to be the purveyors of the information that the public wants to know. And it's unfortunate that, as our trust in the institutions has been eroded, so has our trust in the Fourth Estate, the one that is supposed to be our method of getting information and imposing accountability, holding people responsible for abusing the institutions that we're supposed to have trust in. We can't trust the press to tell us because they've been captured by it too. They're playing the same game as everybody else. They want their access. They want their access and they want it at minimum cost to themselves. So unfortunately, the days of journalists being rigorous advocates for the rights of the public, if those ever really existed, they are long gone. They are long gone. So sad place to be. Happy that I can be out here trying to give a full picture of the case and what's going on, not cherry picking, not supporting a narrative, just here to talk about what's been filed and what we make of it. Lieutenant Pez Dispenser Tully, Bev can't possibly enforce this about don't describe jurors, can she? I don't see how she can enforce it against spectators. You have to prove that the spectators had knowledge of this order. So you're going to have some process where they acknowledge it by entering the courtroom. They have to sign something when they come in for their seat. It's really the best way to show that they had notice of it. Okay, you could have somebody stationed, a guard stationed, at the door telling them, by the way, these are the rules. No guarantee they heard it. No guarantee they listened to it. Didn't just, pass through one ear and out the other. Best way to do it is to get the acknowledgement. So they're going to sign off on this to get into the courtroom. If they don't have notice of the order, they're not in contempt of it because they're not in willful violation. It's inadvertent, and that's not contempt of court. So that's a problem with enforceability. How are you going to enforce it anyway? Are you keeping a list of who the spectators are and how to get a hold of them? Spectators aren't required to be from Canton, Massachusetts. They aren't required to be from Massachusetts at all. How do you propose somebody comes in from out of state for one day to sit in there? They report something about the physical characteristics of the jurors, and then they go home. You have no extraterritorial jurisdiction. How are you going to enforce that? We have the whole problem that I mentioned at the top, where we have under-inclusiveness, right? We're focusing on the spectators in the courtroom, and we're ignoring all the people that may have the opportunity to observe the jurors outside of the court. Are the jurors being entirely shielded from public view? They're not being sequestered, right? They're not being sequestered. We haven't heard anything along those grounds, and it would be quite unusual. The fact that they did that in Delphi was it's almost never heard of anymore. So why are people not able to follow them to their cars, watch them with drones, whatever? watch them with a scope from a distance, binoculars, figure out who they are. The order doesn't apply to them. They're not a trial spectator. So you're not even preventing the harm that your order is purporting to cover, the risk of doxing the jurors, because you're not getting at everybody who could potentially be the source of that information. The reality is, and always has been, that if somebody wants to dox the jurors, they can and they will. And the judge has a fair amount of discretion over her courtroom, but gagging people, telling the press what they can and can't report, that's always been a red line. It's always been a red line when it comes to the press. You can't gag them. It's a prior restraint. It's presumed unconstitutional. It's not allowed. Not to mention, there is plenty of case law that they get to report information that they have independently obtained. So, for example, you impound the jury list, they find out the name through some other way, they can publish it under the First Amendment. They just don't do that. And this is not a new state of affairs. This has been the law for decades. So, big problem with this order. I don't know how they're going to enforce it. I don't see it being realistic. I think it should be challenged. I think it's easily challengeable. Is the press going to do that? Is the press going to do that? I guess we'll have to wait and see. Because I don't see some random spectator doing it. Why is some random spectator going to take it upon themselves to hire a lawyer and go out and litigate this? Why would they do that? That's what press organizations do. That's why they have legal teams available to be able to pursue this type of thing for them. We'll see if they do. Duncan, Idaho, bad idea to issue orders you can't enforce. Makes the court look weak and dumb unless she closes the court to the public. She can't do that. She cannot do that. That would definitely be a red line that's being crossed. Very clear in the Constitution. Public has the right to attend criminal trials. You don't get to exclude the public sweepingly as a general measure because of some concern that you have. It has to be individualized, your basis for excluding people from the courtroom. So no, she cannot close the court to the public. So the result is, yeah, she's likely to end up looking weak and dumb if this order doesn't get enforced. If people describe the physical characteristics of the jury and she doesn't institute contempt proceedings, yeah, she looks weak and dumb. Because when it came time to put up or shut up, she didn't put up. Not a good place to be. Well, guys, it's been a bit of a day, hasn't it? 8.5 hours. My goodness, we covered a lot, and yet there is still so much more. Can't believe what a flurry it's been in the final run up to just getting a jury selected. Shouldn't be that much. There's probably been even more filed today. Wouldn't surprise me at all. I'm going to have to check that now. But at least in the short term, my focus is going to be on finishing that report and seeing what other kind of information is in there. So guys, like I said, not planning to go live again tomorrow for jury selection. I'm going to play it by ear, wait and see until we have something that looks a little bit substantive. I reserve the right to change my mind. So if you're so inclined to have notifications on and so forth, that will let you know. I tend to try to put things out on Twitter too. If I'm going to do something on short notice, just to let people know that it's going on. But that's probably how you'll find out. It's just because I'll do it, I'll decide and then I'll do it. But I might also just take the opportunity to do some pre-recorded things and incorporate them with the many other busy tasks we have in the spring when you're into gardening. A lot of stuff going on. Fortunately, some of it is a little too noisy to do a video. Like, I'd love to mow my grass with you. That's not going to work. That's not going to work very well. Sound would be quite terrible on that. But anyway, I'll be looking forward to probably doing some stuff like that while we wait for the trial to get into the meaty stuff, into the evidence. So do keep your eyes open for that. Got a lot of loose ends I'm working on tying up, like I mentioned on Substack. Really want to follow up on this question about the legal standard for dismissing a juror, a sworn juror. Is there really any basis for this distinction between deliberating or not deliberating outside of the context of hardship excuses? It's not real clear to me that there is. So anyway, I'm working on that, and keep an eye out for that as well if you're interested in that type of written material. Otherwise, guys, I'll be, popping in on X, doing my thing. Oh yeah, finally got caught up on Kohberger. So much going on right now. It's a deluge of information. I'm just kind of grateful that things are in a little bit of a lull in Richard Allen's case while we wait for the appeal to get going, which is probably going to take a while. That's given me a little bit of an opening to focus on these other cases and get up to speed. There's like 100 and some filings in Kohberger on just motions and limine, responses, replies, supplemental affidavits, all that stuff. I got a lot to say about, what we see in these motions and what we don't see in these motions. So that's the type of thing I'll probably sit in pot of bonsai tree and talk to you guys about. I'll probably need to do more than one because it's, so voluminous what's been happening. But that as well, if you have been missing my comments on the Kohberger case, finally there, guys. We got a hearing on the 9th. If court isn't in session yet in Karen Reed, then we're going to definitely live stream that one when it happens. If we're in court with Karen Reed, then we'll probably try to catch up on it at another point. But again, just going to play that one by ear and see how it unfolds. But do keep an eye out for some thoughts about those motions in the meantime in some format, Substack or video or something like that. So that's what's coming up, guys. Thank you, as always, for being here. Really appreciate it. Quick question here from Lisa Shelton. Lisa, thanks for checking in. What do you think about the affidavit of Cy Ray? Can't wait to hear about BK. Yeah, well, Cy Ray is not pulling any punches. Cy Ray, for those of you who haven't necessarily been following Kohberger very closely, Cy Ray is a former Fed. He's a former FBI agent. He is one of the early, basically, inventors of geolocation through cell site information. He's one of the guys that figured out back in the 90s how you can use this information to figure out where a person is located. And so he is like one of the top, historically anyway, has been one of the top trainers for law enforcement people doing this type of analysis. He's worked with the CAST team. He developed his own software program that maps cell site data, depending on the type of data that they have. He did, millions of miles of drive testing, they say, to kind of substantiate how he does it. Some controversy about Cy Ray because this is the first time he's ever testified for the defense. Made that very clear in pretrial proceedings. He's never testified for the defense before. This is a cop's cop. Okay, this guy is a cop. And so the fact that he's chosen this case to be the one, has people asking why. Some people, questioning his work. There was a Colorado trial court that excluded his mapping software, finding that it was generally unreliable. And so a lot of people have seized on that, like, oh, he's discredited. Law enforcement don't work with him anymore. No, he just testified for law enforcement like 2 weeks ago in a case over in California. And he conventionally does. And there have been other cases where his software has come under scrutiny, and it's been upheld. It's been affirmed. The most recent one I'm familiar with was out of the Sixth Circuit back in 2004, just last year. They said, yeah, this satisfies Daubert. It's a good decision. U.S. versus Reynolds. It's good to read just because it goes a lot into the background of what exactly he does and what his opinions are based on when he's doing this type of geolocation. So that's the background on Cy Ray and who he is. This is the first time he's ever testified for the defense. And he has been, for quite some time now, raising the alarm about what the investigation, either Moscow police or the FBI's cast agent, Nicholas Balance, did with cell site data or did not do with cell site data when they began making representations that were used in probable cause affidavits to support an argument about where Brian was at various points in time throughout the night. And it's reached the point where Cy Ray is pretty clearly saying they lied. They lied about what the evidence showed, and then they tried to cover it up. He's insisting that there is evidence that is likely exculpatory to Brian, because there have been other discrepancies he's found that have been exculpatory to Brian. But in particular, what they call timing advance records. These are a particular piece of information that the cell companies can keep that tracks the time it takes for the connection to travel between your phone and the cell tower. And so that's a fixed measurement. That's a constant at the speed of light. And so because you can measure the speed, you can then get a pretty accurate calculation of what was the distance that this person was from the tower. And so then given the distance and the orientation of the tower, that tells you this person must be, in this general area. You can sometimes run this timing advance information off of multiple towers if the phone is connecting to multiple towers at once. If you know the distance from this tower and the distance from that tower, now all you need is trigonometry, and you can place exactly where you are. You can figure out that third angle and where exactly you would need to be for those signals to align. So potentially very, very useful information when it comes to this type of analysis, far more useful than just you connected to a cell tower, which could mean, you're anywhere within a multi-mile range distance of the cell tower. He's argued that they have this timing advance release information for Brian's phone, and that they would have had access to it. They tried to get access to it. They did get access to it. It's reflected in their analysis, and they are denying that. They're saying the prosecutor has said definitively, we don't have it. You're mistaken. It's not something we ever got. And having that denial, Cy Ray doubled down in this affidavit, really, really calling him out, saying, I have never seen a more egregious case of prosecutors trying to mislead the court about what the evidence is. Oof. Well, hate to tell you, Cy, but it may be because you've spent all that time on the prosecutor side that you haven't seen it before. If you spend a little time over on this side, unfortunately, you're probably going to see it a little bit more. But it's a very scathing affidavit. He is not holding back. He clearly doesn't like what he's seen. He's not pulling his punches. It doesn't matter to him that these are the people that he ordinarily works with and for. He doesn't like it. And he is not being a shrinking violet about it. So, yeah, I'm eager to see how this unfolds and what it means. I might do a video just getting real specifically into Cy Ray in particular and this whole issue, because there is some kind of technical stuff in terms of what the state is claiming that they did, what they say they have access to, what they say they didn't have access to, and why, how that's been countered. There's kind of a lot of details in there that it's, even though I've given a wordy answer already, I haven't really gotten into a lot of that specific stuff. So maybe I'll do a specific follow-up just on that piece. But yeah, it's pretty fiery. The guy that has never worked for the defense is making a lot of noise about prosecutors and FBI in particular, engaging in shenanigans with the evidence and trying to hide exculpatory evidence and then lying to try to cover their tracks. He's saying that pretty explicitly. So I would be inclined to think that given who he is and who he works for, what his normal client base is, that you would not take this type of position lightly. You would not do it incautiously. It would be quite reckless to be this emphatic if you didn't have a really, really solid ground to base it on. So I don't know. That's just kind of my my inclination. I could be wrong about that. He could be just totally over the top. I don't know. We'll find out. But it's enough to be a little bit alarmed about what the FBI and the prosecution may have known or not known about Brian's location while they're trying to, establish probable cause to arrest him, get more evidence against him, and so forth. Might be a little bit of a concern. We'll have to see. Lisa Shelton, last question. I'm so sorry. What do you think Hippler will do referring to this, and any comment on Ashley Jennings pronouncing magistrates? No, I don't want to give Ms. Jennings, I don't want to give her unfair criticism. I mean, yes, people misstate things. It does happen. I am a malapropism queen. I accidentally say the wrong thing with some frequency. A lot of times it's just because I'm trying to think down multiple lines at the same time. And it's like the wires get crossed on the way out of the mouth. I'm saying this one thing, kind of thinking about this other, figuring out where I'm going to go. And it just it's not always a smooth road. So I don't want to give her grief for things that I think are just, fairly normal and can happen to anybody. Maybe a little bit embarrassing, but whatever, it happens. We've all fallen on our faces and embarrassed ourselves at some point or another. But what do you think Hippler will do referring to this? Well, I feel like what we have already seen from Hippler is that he is firmly on team prosecution. Maybe not as bad as Judge Cannoni in terms of at least overt bias, but in terms of receptiveness to the idea that law enforcement may have made mistakes, may have gone too far, may have crossed a line. Very, very, very reluctant to go there. So we already know Ann Taylor asked for leave for Cy Ray to be able to testify at the hearing coming up on the 9th. And he said no. He said, no, I can decide it on affidavits and just have them available. I'll if I change my mind, then they can just zoom in, but he's not going to pre-approve them being able to come in and testify. He wants it to be decided on the affidavits. So that puts it in a little bit of a different context. Puts it in a little bit of a different context because it sort of shifts the realm of opportunity that's available to the parties as far as establishing what the facts are, what, if any, disputes there are about the material facts. Cy Ray has come out explicitly in his affidavit and said, please, this is available in the evidence. Like, anybody can look at it with their own eyes and see that there's a problem here. Please take this seriously and allow me to demonstrate it. Is the judge actually going to take? Is he actually going to take that? I don't know. I don't know that he is. I don't know that he is. If he doesn't want to, if he wants to be blind to it, he can be. So I think we'll learn quite a bit about Judge Hippler in this process. Does this cause him grave concern? This possibility that the state's denying it outright, and the defense expert is saying, you'll be able to see this for yourself if you just let me show you. Is he going to be curious about it, or is he going to be like Judge Bev? I don't know. Eager to see. Duncan, Idaho, 24-hour stream. Let's go. No 24-hour stream for me. Probably not ever, honestly. Like I'm not that young. Not that young. Just had a birthday. Not getting any easier to stay up for 24 hours, let alone to go to Vegas for a weekend and come back and have, had one day yesterday, a full day to, recover from that. Might not be quite enough. So no, I will not be doing the 24-hour live stream, but thank you for the suggestion. I do appreciate that. Guys, I said I was going to wrap this up like 20 minutes ago, and then you got me going on more stuff. So I really am going to wrap it up now. Got a lot of stuff to look at, things to pay attention to, things to catch up on. Keep an eye out on the YouTube, on the Substack. That's where I will be letting you know if I've got new content, new thoughts about the stuff that we've been talking about. Thank you, everybody, again for joining. Thank you for your awesome chat, your great questions, your support, all the nice things that you say. If the chat is biased in favor of me, I'm not going to have a problem with that. Why would I dispute that? That sounds like a pretty good state of affairs to me. Works for me. But I also trust you'll keep an open mind. I make no promises to be perfect. I can make mistakes. It's happened before. It certainly will happen again in the course of my life. So don't ever be afraid to, challenge me on the merits of anything. I welcome debate. It's just got to be in good faith. It's got to be, about the issues and not just this bullshit that we see all over social media where like, oh, I disagree with you and you suck, name calling stuff. It's like it's completely valueless. We don't have any use for that here. But always happy to be challenged on my perspective. I've been known to change my mind. Has happened. So anyway, I appreciate all of you. Appreciate your contributions to the chat, to the great scene that we have going here. Really enjoyed it for almost 9 hours today. And with that, guys, I'm going to go ahead and check out. I will see you the next time I see you. Maybe April 9th for the Koberger hearing. Maybe before for Karen Reed. Maybe not until after for Karen Reed. I don't know, but you know where to keep your eyes open. So thank you again. Hope you all have a wonderful day.